State and spell your first and last name for the court, please.
Thomas Burnett.
Yeah,
THOMASBURNETTE.
Good afternoon, Ms. Burnett. How are you doing?
Hey, how are you?
Hey.
Ms. Burnett, did you drive or fly here today?
Fly.
You're from another state?
Charlotte.
And what do you currently do for a living?
I'm a service consultant at an Infiniti dealership in Charlotte.
Okay. Salute to everybody in here. Good morning. Straight up. What's up with you? Yeah. How y'all doing today? I appreciate y'all being here. Tap the like button for me. Why not? Yeah, good morning, man. Straight up. Let's get it grooving.
And what was the first year that you began working for Infiniti?
1997.
What did you do when you first began working for Infiniti in 1997?
I was a valet. I was a valet while I was going through college.
You was valet for Infiniti? They ain't got no club. What, they got a restaurant?
And in that capacity, would you drive Infiniti cars?
Yes.
After that, where did you end up? Did you ever end up getting a degree?
Yes.
Where did you get your degree?
DeVry University.
And what was your degree in?
Business administration.
Did you get that here in the state of Georgia?
Yes.
Hey, yo, who is DeVry? Who is DeVry? They got a basketball team. I ain't never seen them in the March Madness, bro. I be watching the college b-ball, bro. They got DeVry. DeVry ain't got nobody in the league, bro.
Now,
Surely.
after when you first were working as a valet, what was the next job that you had after getting your degree?
With Infiniti or just the next job period?
Next job period.
I was in furniture sales.
What?
What did you do after that?
I went back to Infiniti.
What drew you back to Infiniti? How did you end up back working?
Because once he went into furniture sales, Infiniti figured he could tell people about the leather seats. Once he got the leather seat knowledge, he was grade A to work back at Infiniti. Now he could tell people about the seating in the Infinitis.
Looking for them.
Just a familiarity. I had a relationship with the manager at the store, and they kind of asked me to. It was opportunity, so I went back.
Now, when you went to Infiniti this time, what was your job position?
Currently, what I do, service consultant.
Now, can you explain for the jury what is a service consultant? What all do you do?
Yeah, explain.
So I meet with the clients or customers that come in for maintenance or repairs on their vehicle. I assess what the vehicle needs, whether it's check engine light on or a leak or no starting issue. I basically get the information from the client and put that in a manner so where the technicians can properly diagnose the vehicle. Once it's diagnosed, I reach out to the client.
You're not even the tech.
And let them know what repairs are needed and gain the authorization to fix the car, and then basically handle the client throughout the process on updating them, let them know when the car is ready, payment, etc.
All right. Yo, let's let some people get in here. Tap the like button. Help me get to 100 likes before we get to 20 minutes,
With
y'all.
what all you just described in terms of your job, what all you do in that job?
We not ready to go over this full testimony, y'all. I'm just letting the people get in. Come on, let's rock.
Makes and models of Infiniti.
Yes.
Can you explain for the jury how you gain familiarity with Infiniti makes and models as a service consultant?
Well, we have to do certification tests quarterly to make sure we're certified. And then, also just being around the vehicles, you learn and pick up certain common things about the cars. And you have to identify certain things with them to know what year it is, what type of oil it takes.
All right, so pay attention, y'all. The state built up all of this so they could build up the foundation to say that Holmes is a professional at being able to know these cars. And then Adams came at the end and just monkey nutted on Holmes, though. Just gorillaed him. Straight up, bro. They did all that clarification. And then Holmes got there. What'd he do, y'all? How you get him? Good morning. Salute to everybody in here. He got him. He basically, did he show that boy the same picture that the state used? And that boy actually thought that was the same exact car. Did he show that boy the picture that the state used? The one with the gray car sitting in the parking lot? And that boy thought it was the same car though. Like he literally thought he was looking at the car. So he like, that's not the car? We here 9 years later. Yo said, so that's not the car? Yo, it's too late for you to be in question mark. Like you supposed to know. So Adams hollered, is it? Is it? Hey, I don't know. You tell me. You the expert.
So when you're quoting prices, you know you quote them accurately. So
Now, as a service consultant, is your
But how could it be the same car? That car in that picture had tints on it. The car that we seen in the joint didn't. I don't even know about no tints still.
primary focus, is it true or false that you're focused on the clients that come in?
mainly, yes. Yeah.
Now, to be an effective service consultant, with Infinity, do you have to understand the technician side of the business?
Yes, because I have to basically interpret as far as what the client is saying. As far as sometimes
Salute to everybody here. I appreciate y'all being here. Good morning. So that's a good point. And the bumper falling off. All right. Remember I asked about the bumper, y'all. Woody and them got into a bang 'em up, right, with the car. Scraped the bumper, knocked it off, allegedly. They snapped it back on. But pay attention. Adams asked, you can't see any damage? Yo, let me ask y'all. Why would Adams ask that? He know that the car was actually damaged? Like visibly. Pay attention, y'all. What Adams know that we don't know? I kept saying, yo, how they pop that bumper on and off? Like, I ain't even gonna lie. Like, new cars, you knock a bumper off, you lucky if that thing snap back. Now, a couple people say, yo, you might be able to snap it back in. I know, but that's rare. But Adams actually talking about visible damage.
help the technician understand what the issue is. And then there's a lot of terms and expressions that technicians will explain to what's wrong with the car. And sometimes that's not customer friendly for us to understand what actually the issue. So sometimes I have to do some interpretation as far as making it a little easier to understand on what actually is going on with the vehicle.
Now, Mr. Burnett, jumping back to after you got your degree and you worked in, when you first went back to Infinity, what location were you working out of?
South Atlanta, Infinity of South Atlanta.
Is that the one on 4201 Jonesboro Road?
Correct.
Now, how long did you...
Yo, if the car got in an accident, the rental car spot didn't, what would they call it? Document, the damages when they get back. So, yeah, so they could charge them.
What year was it that you...
2005.
And how long did you work at that location?
Till 2021, I'm sorry.
So roughly about 15 years?
Yes.
Now, over those 15 years, how often would you drive Infinity cars in any capacity?
Every day.
Would you drive them in both daylight and nighttime?
Yes, I've also currently own Infinity, and I've also owned Infinities from like 2007 on. So.
Do you get some perks working for Infinity in terms of owning an Infinity or buying one?
Yeah, we do get some discounts or consideration as far as what it is.
Oh, yeah? Like what?
Now, what kind of vehicle do you currently drive?
Q50, Infinity Q50, 2020 Infinity Q50.
Now, since you've been working for Infinity, when did the Infinity Q50...
Yeah, what's the coincidence that Holmes drives the same car? Really, y'all, let's address that. Did he say he drive a Q50? That's what the car is, ain't it? Like, that's a little bit weird. He drives one.
On the market?
2014.
Now, when it first came on the market, how would you describe an Infinity Q50?
It's a sports sedan built on performance. It was pretty unique in design as far as at the time, as far as it had distinct features as far as the headlights, tail lights, the front grille were pretty distinctive at the time when it first came out.
I don't think so.
Is there any Infinity model or make that is similar back in 2014 when the Q50s first came on the market?
No, there was a G37 sedan, but it looked completely different than the Q50. It wasn't really. It was a whole different design. So
now, is there any significance to the G37 in terms of the name of that car versus the Q50?
No.
In terms of the lettering or numbering?
Oh, well, like as far as the G37 was basically named after the engine size. So the 37 is how Infiniti used to distinguish what size engine was in the car. When the Q50 came out, it was the beginning of the rebadging to where all the same models basically had the same. So a Q50 is the sedan, the four-door sedan. A Q60 would be the two-door car. And then they identify the engine size by the callus on the side of the car, whether it's a 2.0 engine or 3.0 or 3.7 back when it first came out in 14.
Now, you have described a decal on the side of the Infiniti Q50. Is that unique to that make and model?
Pretty unique. You don't see it a lot on other makes. You know, most makes don't identify what engine size is in the car by any type of badging on the side.
So previously, Infiniti, you would know the engine size based on
the name.
Yeah. And then after that, they put a visual indication of the engine size?
Correct. Yeah, they were kind of tired of changing names.
Yo. So listen to this, y'all. Brian Steele's wife represented APF, one of over 20 people charged in a complex Mexican drug trafficking conspiracy. After a 2-week trial, alongside 4 other co-defendants on trial, her client was found not guilty of all charges, and he was freed after almost 2 years in jail. Side note, that's just a commercial for Steele Law Firm. That was his wife that beat that case. I've been just going over these cases that these people done beat, y'all. Tap the like button. Salute to everybody in here. Yeah. Tap the like button. Salute. I'm here. Good morning. Yeah, I'm here. I promise. I'm here. Yeah. Yeah. We vintage today, man. We got True Religion jean jackets on, man. I swear. We vintage. Straight up.
Every time a new engine came out. So it went from like G35 to G37, and then it stopped, and then they just changed the badge on all the cars to Q.
That makes sense. Now, are all the makes and models in the Infiniti fleet start with Q?
Correct. Yeah, the cars are Q, and then the SUVs are QX.
Now, you were working for Infiniti in 2014 when the Q50 first came out.
Yes.
Has the Infiniti Q50, does it have a sunroof?
Yes. Pretty much probably 80% of the models, or maybe even higher, have a sunroof. The only ones that don't have a sunroof are the Q50As, and that's on the back of the car. You'll see the A. And that was kind of like the base entry-level car, which we didn't sell very many of those cars because dealerships wouldn't order them because they knew they wouldn't sell them. So now, when you said when you went back in 2005, you worked till 2020. What did you do after leaving the South Atlanta Infiniti in 2020? I moved to a few dealerships around. Initially, I took a job as a service manager at a Nissan store in LaGrange, Georgia. That didn't quite work out, so I worked at the Nissan in Morrow. Then I went back to Infiniti, different location. I was at the location in Nally, and then I worked.
Holmes was phony. Let's skip to the cross exam. Holmes was phony. Let's let Adams cook till they start the day, y'all. Come on, Adams. Come through. Oh, yeah, he did Adams dirty with moving the mic.
One of the last things you said was that...
Why did she tell him to move the mic like that, y'all? Look. And she grabbed it and put it over there and let that man talk off mic that whole time, bro.
Yeah, sure.
That was dirty.
Thank you.
So he went to go take it back. Oh, she's like, nah.
Hey, how are you?
I'm good. One of the last things you said was that the rental companies, I think first you mentioned, sometimes brought their cars in to be serviced at the location that you work at, correct?
Correct, because we're close by the airport. So
Yo, that was a dirty move, bro.
We would get a lot of those cars brought in. So.
Do you have any personal interaction with any car, any Q?
That is not Colette Steele. It's him wife. What? What? Amy Lee, what you mean? That's not his wife?
Brought into your dealership back in January or February of 2015.
I wouldn't be able to recollect that.
And you would not have been the one to observe or look at or inspect any vehicles going from hers anyway, would you?
Only thing I would do was check it in, which basically would mean getting the mileage, then plate off
Oh,
of it.
Ashley Merchant. Nah. My bad,
Like a walk
Amy
around
Lee.
for
Okay.
damage. That would be my end as far as inspecting it.
Brian still don't even look like he would mess with her. Real rap.
In 2000,
Tap the like button. Salute to everybody in. Yo, help me get 12 more likes, y'all, before 20 minutes. Let's get 100 before we get to 20 minutes, man. That's my little threshold thing, man.
2015 or 16 when the Atlanta police came to talk to you?
His wife was a part of the team. It was a group of them. His wife was a part of the team of people that was representing him when he was in contempt. I believe so, bro. She was a part of the team. Yo, it was a slew of them.
About infinities.
I don't actually remember the exact date.
You have no real memory, no clear memory of when that was, right?
Salute for the
not
likes.
date, no.
Okay. Is it fair to say that when they came to see
She
you,
didn't rep him?
they didn't bring an actual vehicle with them for you to
My bad.
look at or offer your opinion on, right?
No, they were like
I thought
photos.
she was in.
Yeah.
The images that you just saw, and I'm going to ask the state's indulgence in a bit to put some of those back up again. You would agree with me though that those photos?
Ashley represented him. You sure she was by herself, Terrell? Could have swore it seemed like it was more than one person. I could be totally wrong though, because that part was kind of irrelevant to me, so I kind of like skipped over it. His wife wrote it.
We're good.
Those are black and white images, right?
What's that? The photos they brought in, or
Yeah, well, no, the photos that you were just looking at in the video you just looked at. Still shot, and then the two videos, one of the car rolling forward from the front, the other from the back.
well, the photos here are color. The ones that they.
That's the up.
Yeah.
I do remember saying more than two, I
I'm
believe,
going to
bro.
reference the record 459 and 459A. These are the photographs.
They
that were
pulled up.
presented to you
I remember
from the state a
looking
little while
back
ago,
there
right?
like, wow.
Right. Now, that's not what I'm talking
They
about.
not
I'm talking
playing
about the video
about
that you
y'all.
were looking at, that the state played. Would you agree that was a black and white video?
I don't know if I would classify it as black and white. It wasn't the greatest of quality of video, but I would say it was black and white.
Okay, let's look at it again. Tonight, would you be kind enough, please, to put up what the state has marked as...
Adams cooked his ass on the last piece, y'all. We about to have to fast forward to that last piece, y'all. They jerked my man Adams. I don't even want to hear that part.
So,
It's a video out with trivia. What you mean? Yo, don't ever type that vague like that. What's your point? Come on, bro. Don't come in like that. You spinning us away from what we talking about and you being vague. Don't do that at all. Don't do that.
Yes, sir.
So even though in the still shots and the videos...
There's a lot of videos with her. What are you saying?
Identifying items that you mentioned.
Driving.
Right?
Come on, bro.
Not in the video, no.
We don't see the...
You mean like
the emblem on the infinity emblem on the front.
Yo,
Not in the
send me the
video, no.
link and describe what you talk about in the email. Like, tell me what it is that we looking at. You feel me? So we don't get sidetracked right now.
You say when I identify something as an infinity, your testimony is that you know.
I want to turn this volume up.
Well, right. So this is not the same car. Like
you tell me, is that the same car?
it looks like the same car in the video. It's a Q50.
Cap.
You pay.
Salute. I care. Nah, let me know once you get it. You can tell me. Post it. Do you remember one of the people who got here say it was a Pontiac? Bro, I don't care. I'm with you. Determining what car that is in that video footage is cap if you try and go 100%. Moon Tunk ex-girl speaks out. I don't even really care. Nobody wasn't even talking about her. I was talking about her first. So, you know how this raid go. And I don't like your vagueness for bringing it up in my chat to try to make somebody else go look for it. If you see other content like that out there, email it to me. Don't bring it up in the chat. It's irrelevant. So what, you redirected me to a different YouTube page? Or you really want me to know? Because that was vague, and that's 2 times I gave you the option. So, yeah, how you want to do this? Well, you already know how this is. I really don't even like your name. So, to be honest, I really don't need assistance from you because you don't seem trustworthy with your name. So, respectfully, relax. Respectfully, though. Hey, Terrell, don't type the word shooter. Don't type that in my chat. Respectfully. Yo, don't curse in my chat, bro, or type dumb words. And if you ain't smart enough or you think it's a problem because I'm saying that, go over the line crime, for real. I don't get the pass like them. So, like, them type of words be seeming like they might hinder my chat because they read it and then seem like they might not want to share it no more. But so please be careful with the words you be typing, please. We ain't worried about who was representing Steele. That was a question that was felonious beforehand. We ain't even worried about who was representing Steele. That was a fake play. Let's focus on the trial. Do y'all know who Kente is? Wake up. Come on, get back on track. We ain't worried about who was representing Steele. That was a side note. That has got nothing to do with what we talking about. So let's please get focused. Let's please get focused. And I'm going to challenge Corey Gibbons. You know who Kente is? You know who Kente is, Corey Gibbons? What about Ken? Craig, if you know Ken, tell him pull up. Yeah, what about Ken? No, we just wondering how Ken been on the street so long. You feel me? Without getting chipped off, for real. They said he the man. But if everybody know you the man, then that means somebody telling on you. But if somebody telling on you and you don't go down, that means you must be the big teller. Or you're actually hired by the Atlanta PD to do exactly what you do.
So you're thinking that 459 and 459A, which has been given to you by the state, you believe that this is the same car that's been shown in that video.
People say anything? What people? Nah, I'm talking about me, and I don't say anything, Craig. I got all facts. So now what you saying? It's me and what I'm saying against Kente. This ain't no speculation. So if you want to keep defending Ken, can you hear the trial? Yeah, go to law and crime. You got the freedom to press the play when you want. It was up all night. Why you ain't watch it yesterday? Ow. You tried. Sorry. Sure you can. We don't even need to do a recap of the Infinity Expert. It was a trash witness. But we was wondering more about Kente. Yeah. LaMarcus Allison. From Jonesboro South. Yeah. And the Allison family. And how they was able to evade or breaking the law all these years. Yup. Is it Rudy dad? He ain't Rudy father, is he? Is
Video
it?
is definitely a Q50, yes.
Okay, you think it's this car?
It appears to be, as far as the color and everything else appears to be, but
But what?
Does this?
But what? But why? Why?
So you're thinking that 459 and 459A, which has been given to you by the state, you believe that this is the same car that's been shown in that video?
the video is definitely a Q50, yes.
Okay, you think it's this car?
Tap the
It
like button.
appears to be, as far as the color and everything else appears to be, but
Does this
Again, these are all standard things. It's not like this is it has custom wheels on it or if it has a custom grill. Those are all the standard things that's on the car. So every Infiniti has the grill. I mean, has the logo on the grill. Every Infiniti has the badging on the side. Those are the standard headlights. Those are standard tail lights.
right?
So if it's a Q50, then it has those things.
So every Infiniti has that that emblem on the grill that we can't see on the video, right?
Q50, yes.
Every Q50 has that emblem on the side that we can't see on the video, right?
Correct.
Every Infiniti has maybe standard, maybe not standard wheels that we can't see on the video, right?
Correct.
But your testimony to this jury is that these pictures given to you by the state is the same vehicle that's on that video.
Correct.
All right, that's all.
All right. Now you're free to go.
All right, thank you.
Yeah.
All right. And it's just about 5 o'clock. So I think we'll break
The
for
hell
the
you want
day.
to talk about?
And I'm going to remind y'all, sometimes I give you a longer reminder, that you need to decide this case based only on the evidence that's
She is flabbergasted. Look at her face. This is defeat. She looked like game 6. Guys going home. Look at her face, bro. Hold up. You know we got to put her on the tizzy. You know we got to put her on the tizzy. Hold on, let me get her. Nah. Bring that ass. Nah, bring that ass. Come here. Bring that ass. Come here real quick. Hold on. Look. Now that's humbled. That's humble pie. You see the way her lips folded over? That's the bitterness of humble pie. Got her lips rolled over like that. You see that? Yeah. Bitterberry. Shorty had a bitterberry pie. Yo, hold up though. Oh, look at Weinstein. Yo, stunting on her. Like I told you, look at Weinstein in the back looking like Kobe. I told you couldn't guard me. I told you couldn't guard me. I don't even know why you was playing. You's a young buck. You ain't even in my draft class. I don't even know why you try to guard me. I told you. You 4 years my senior. You 4 years my junior, I mean. You ain't rocking with me, cuz. That's why I told you. I put up 48 points on you tonight.
admitted
Straight
inside
up.
this courtroom.
She tried
So
not to look at him.
Please don't use the internet or any other source, electronic or otherwise, to get any kind of information about this case or about concepts in the law. Don't read, watch, listen to any accounts of this trial that might appear online, in print, on television, on the radio, or
right.
otherwise, including social media. Don't discuss.
All right, y'all. I misspoke yesterday, and I thought that they was actually past Donovan Thomas. Nope, I was wrong. Yeah. They still on Donovan Thomas. Yeah. I do think they ready to get into some other elements of it, but somehow they still on Donovan Thomas. I think they might be ready to move towards. They ready to play. They got the Donovan Thomas up on the board, but it looked like they ready to jump around. Now they got Thorpe. Excuse me. Thorpe is supposed to pull up. Now he a whole beanhead. He a jerk. I watched him. I watched first 48 episodes just so I could peep Holmes. Yeah. Because he ain't pop up yet. And he, the one did all that dirtbag. He lined Woody up, y'all. To be honest, Woody owe me. Seriously, Woody a clown, for real. Straight up, he lucky dudes don't run his pockets, for real. But look, right, Thorpe lined him up. Now, when Thorpe did that to Holmes, I felt some type of way because Thorpe was scared to come testify. Yeah, like they kept playing with Thorpe testimony. He was been supposed to come, y'all, at the beginning of Donovan Thomas. So they skipped and moved him all the way around. Now he popping up on the back end. Something ain't right with that, right? So look, once we noticed that he was supposed to pop up, right? I went and looked at some of the first 48 episodes where Holmes is on that. Bro. Man. Holmes ain't even right on the TV show, y'all. I'm going to keep it real. He clearly acting on the TV show. Like, I'm telling, it's like a bad act job. You know how Quinn, you could tell he turning up a little bit so he could be good on camera? Well, Holmes got the wrong version. Hence, he's not the star. He on a decent amount of episodes though. So I thought that was odd. Yeah, I watched a couple. One of the episodes was real weird, bro. Like his acting style, he was really trying. He was trying to be right on camera. Let me say that. Which is, you got to learn how to be good on camera, bro. Unless you naturally got it, right? I ain't blaming him for that. He a damn police. I do think it's odd that we have this many police that actually was on TV in this trial, but we'll figure that out later. I want to see him. Some of the other people that's listed to come, I don't know who they is. Somebody said one of the ladies was the person, I think it was Darren Mills' aunt who got shot in the buttocks that's supposed to pull up in one of the drive-bys. Don't quote me on that. Yeah, it was her and Lucci Mother. So if it ain't Lucci Mother, it got to be the lady that got hit in the buttocks. Yeah. So, I don't know. Who was those other witnesses? Matter of fact, let me play it.
The case with anybody or allow anybody to discuss it with you or around you.
Craig, you're lame. So you keep asking about Kente, and now you're going to say, I'm blocking you for saying that. Yep, I'm blocking you for that. Tap the like button.
Including don't discuss amongst yourselves. Leave your notepads, notes in the jury room. And remember, for y'all tomorrow, it's a non-jury day. We'll be working, but we'll see y'all back Thursday morning at 9.
Hey, hey, hey. Hey, hey, hey.
State tenders a 444Y conditional, well,
So I guess she means she wants to, if possible, be able to come to agreement about redactions of them. And if not, then present them to the court with her proposed redactions, which.
No, it's a non-jury day because they claiming they got stuff they need to go over. If you ask me, it's probably a combination of all of these things. They don't have their witness. They claim they named about 5 to 6 witnesses yesterday that they have ready, give or take. You know what I mean? All those witnesses don't seem like they even apply to making their case. I'm going to keep it real. According to what they had going on the witness list, they jumped around. So essentially, they needed Rich Homie Quan and his father, Quindarius Zachary, Thorpe. Who else got skipped? It's about 5 to 6 people, y'all, that got skipped around Woody that I thought they was going to jump back to, but they might have dropped the ball. So, of course, Rich Homie Quan can't come anymore. Rich Homie Quan and his father might have been eluding. Zachary dipped on him. How can you prove it, Shay? Not saying you lying, but like, how can we, that's a guess? Shay, go. You can't talk to me like that. Listen, can you please stop this form of education you're doing right now? Without giving me the foundation to where you're getting it from, could you please state if it's an opinion or fact? Please, before you keep going. Before you keep going, I don't want to have to stop you, Shago, because you're typing fast. So before you type your next message, say where you're getting your information from. Respectfully. I don't really do hearsay. Love announced it a couple days ago. She said all of what you just said. She said all of that. She said he was in the hospital. She said all that? She said all that, bro. You sure? Hold on, bro. I think you putting something together that she actually didn't say, and you putting it together the rest. She said things about witnesses, but didn't specifically connect it to his name. And y'all filling in the blanks? Timestamp it, clip it. Clip it. Clip it. She said Quindarius Zachary is in the hospital. He's trying to evade us. He doesn't want to come. But not about him being in the hospital. Oh, now we reneging on what... Man. Yo, when she was speaking of this witness, did she ever say his name was Zachary? Did she ever say Zachary's in the hospital out her mouth? Or she said the witness was in the hospital and y'all filling in the blanks? Nah, where the original person that said it? Don't leave. Nah. Hey, Shay, go. Nah, come here. I'm on everybody's heels. Everybody that stamped, she did. She said that boy name? She said witness.
Get together, and since we have a non-jury day tomorrow, we can deal with that tomorrow. But I don't mean y'all figure out what the potential redactions are tomorrow. I mean, have something ready to present.
Yes, and so, Your Honor, in as much as the tendering was done today, I'll withdraw that request until I have a redacted version to show counsel for defendants into the court.
Okay.
And the court had it exactly right. It was until there was either an agreement or something that the court
Or then
deemed.
you can present it to me and I'll make a decision.
Yes.
Okay. All right. Well, then have those ready first thing in the morning.
We will, along with the other additional emails that the court told me to have.
Right. For me, for an in-camera inspection. And then I would like for us tomorrow, I know that a couple of people have forwarded some things for our task list for tomorrow. There's a motion in limine filed by Mr. Ryan about autopsy photos. There is a motion in limine by Mr. Williams that provides some law and argument on an issue that we had raised our last non-jury week, but not decided about. I can't remember whose statements they were, but some of the wiretap statements we had kind of gotten partway through and gotten, I think it's fair to say, probably bogged down on one particular call and whether there's hearsay within hearsay and whether it qualifies under 801 D2E. So we'll circle back on that issue and maybe make our way a little bit more through that. And then I would like for us to at least start on what's everybody's understanding of which exhibits have been admitted and which haven't, kind of what the status is of the exhibits so far. I covered everything that anybody's forwarded.
Tap the like button. Salute to everybody in here. Good morning. Straight up. I don't care about Quindarius Zachary. I'm more concerned about Kente. So if you don't know about Kente, don't talk to me. And I still don't believe y'all about what she said. I don't believe she said his name, and it's irrelevant. So if you thought that you knew, and you was in here trying to tell me, it's irrelevant. It don't matter. But you could go ahead and type it if you want. So maybe she did, maybe she didn't. It's irrelevant. But I know what's really going on with the trial. I could care less about Quindarius Zachary and whether or not she mentioned his name in the courthouse. I really don't think she did, though. But y'all that believe she did, if she did say it in reference to the person that was in the hospital, then technically, okay, I just didn't hear it. But I really don't care. I really keep up with the whole trial. And everybody that was speaking about Quindarius Zachary just now, y'all probably ain't really hip with the whole trial. So y'all was focused on that point. I'm really not worried about that part. It's irrelevant. What's up, though?
Is there anything else? There might be.
Yeah.
I haven't yet seen, but
But do you remember when I played that early audio, Quindarius Zachary telling before anybody on the net played it? What you know about that part? When we pointed out that that boy was testifying before the whole internet even knew. So let's scroll back to that part. Do you remember me doing that? Any of y'all that was talking about what happened in court with him recently, do y'all remember that? When everyone was trying to tell me that's not his voice on the audio. Were you here? Oh.
I know that they probably are in my inbox. So we'll, since we should be, I guess, ready to respond to the motions in limine.
What about that part?
Well, the one of them I think is new about the autopsy. photos. The other one's
Slug, like my
just a
brother.
Follow up on some of the
Slug.
And we filed a brief on that yesterday, I believe.
On what?
So I just want to make
Maybe
sure that
that's
you.
what I'm thinking of.
Salute to Ricky
the
Williams.
Williams motion limine separate than the Mr. Nichols brief?
Yes.
Didn't
on
want to
that?
state his
Two separate
conditions.
Yes.
It was a detective supposed to be a
issues,
witness.
or the same issue.
I did not repeat what the Honorable
Yeah.
Mr. Nichols.
I mean, we gave the people in the chat a chance to try to clarify what exactly, because when she was speaking about who was in the hospital, it was real. She didn't get, she was purposely trying not to specify who it was. So I remember her speaking of that. If she later on specified that it was Zachary, I ain't here. But to be honest, it's irrelevant. Now, I have seen the rumors of Holmes allegedly being sick or, being out of town, unavailable. I've seen a lot of rumors, no proof. That's the only reason
Same topic?
Yes.
Okay.
I just said.
Yeah, good vibes. I never said that. I mean, I never heard her say specifically it was Zachary. That's what was my thing. Because remember, the dudes were saying Holmes might have possibly got poked up. I done heard a lot of rumors, y'all. Put it like that. Put it like that. The rumors ain't just start. That's why I really called it a rumor.
Other law.
All right. All right.
We just
And
want to
honestly, that'll
clarify.
probably carry us through the day. We probably won't even get through all of it. Any other topics or items we need to be thinking about?
Could the court just inquire who's the next several witnesses? It got kind of.
Sure.
I know it's a witness issue. I was told.
Yeah. So Thursday and Friday, who do y'all anticipate your witnesses being?
Second, let me get that list.
If I was Zachary, I definitely wouldn't be available.
Officer Adrian Pitts.
Tap the like button. Salute to everybody in here. If I was
Miss Sharon Latner.
if I was him, I definitely wouldn't be available though. Like, hey yo, did she mess with Treve? Do he mess with Treve? Hold on, which one of the little D's do Treve mess with, y'all? Tap the like button. Salute to everybody in here. Help me get some more people.
Potentially crime scene tech Turner, Mr. Nice Bell, Officer Sean Hill.
For real.
Turner Bill and who?
Hill. Officer Sean Hill.
Okay. All right.
Crime scene tech Jenkins, Detective Thorpe.
Okay. That we won't get through all of those in 2 days. So that'll give y'all the list of the next several. All right.
And the one main one, if we the one that has
It's just the gremlins that are apparently in residence here in 1C.
What's the chances that it's one of the same little D's? Zachary got the deal what he got, so he can't plead the fifth.
That one doesn't seem to be working at all.
Quindarius Zachary got caught up in another charge with OG Bentley. Don't quote me on the year. So he got a charge that's outside of this RICO. I forget what it is. I think it's like a gun possession charge or something. And it happens, to be honest, I don't know when it happened. I don't know if he got that charge after he went to the feds or not. But he allegedly went to the feds. Something fishy about Holmes. Something fishy about Holmes. Free Scarface. You know that boy? GK? You thought he was on the run? He might be. I know one thing. He got some other charges outside of this RICO, but he not charged in this RICO. He an unindicted co-conspirator. So his telling rate is probably up kind of high like Woody. He did go to the feds, though. Oh, he definitely told. Well, first off, he told on the other little D. Both the little D's told on each other, so they both rats. Yes, sir. Both little D's rats. They told on each other. Flat out. He shot. No, he shot. Seriously. This is serious. This is fact. You feel me? Ain't no question about that. They both told on each other. Like, for no reason, too. To be honest. To be honest, they didn't have to tell y'all. They could have beat it. The way I'm looking at the paperwork, they could have beat that. Ain't no other witnesses, I don't think. Well, they took plea deals. It might have been other witnesses. I don't think it was. It very well could have been, though, y'all.
We may need to put new batteries in some of these.
Yeah, they both ratted on each other and implicated Tunk as the driver, not the shooter. They dirtbagged him. They put him in the driver's seat, which is like, come on, bro. You might as well have just said it was Johnny. You feel me?
On our list is available that we had mentioned last week that we had approached the bench about regarding a condition that they had.
Hold on, y'all. Hold. All right. He got locked up for being a straw purchaser of weapons that was used in aggravated assaults. He lucky ain't no bodies on none of them joints. I don't think so. I don't know, though. I mean, to be honest, I don't know how many straw purchases he got charged for. But to be honest, you don't want that. You don't want no straw purchase charge for no gang.
Remember. Do they know who you're talking about? I can't remember. Do y'all know who we're
Your Honor, I'm going to
here?
withdraw that. We'll leave it at where we have it right now.
Okay.
I'll speak to anybody who asks about
Okay.
that, but we're
Mr.
good.
Weinstein, you seem to want to say something.
Normally it's that I have to use the restroom, but actually it's on a different subject matter.
All right.
Just briefly, I'm not going to be here, Your Honor, tomorrow. Ms. Singer-T is.
Okay.
But I guess I'm going to go back to the old saw that I keep bringing up, Your Honor. And just briefly.
All right, let me jump out here and say this, y'all, to the people. Salute to the people that's saying, hey, good morning. If you're new, subscribe to the channel. Let us know where you're from. Good vibes. Good vibes say, me and my girl watch this channel almost every day, and I got a few people on it now. Way more informative than, yeah, they be misleading in their titles. I think that's partially, sometimes they really out of context. And sometimes that's a part of the job. You got somebody doing these titles, y'all. It get a little bit overwhelming if you really on it. I could easily see somebody being overwhelmed that work for one of these companies doing these videos and this YouTube. Yeah, because they probably doing multiple channels at the same time. So I see why it be like it is, y'all. Real rap. I no excuses though. No excuses. Yeah. Yup. Who is YSL Doo-Wop? Somebody brought it up on Twitter yesterday and said they hiding him, but I didn't know what they meant by it. He a rat? He folded? He from the early stages. Allegedly, he's in the car in the Donovan Thomas situation. His name pop up sporadically, right? He an earlier member. So he involved. Like he ain't in a lot of pictures, but he in some of the ones that count from the early years, right? He indicted though, right? He on the indictment. He actually on the indictment, right? He's severed, I believe. They can't find him. I mean, if they can't find you, bro, it's a wrap. That's a wrap. You can't find him till now. I mean, it's pretty much, you can safely say that Holmes is he out the way. I mean, he could be gone. If he really, if he a guilty party, bro, Holmes might be gone. Seriously, don't sleep. Don't sleep. Don't sleep. I mean, this ain't even the type of charge to run from, to be honest, y'all. Unless he just run until it's over, which I would have tried to pull. I swear to God. I swear to God. Yes, sir. Run until I see what happened. Yeah, hell yeah. I want to see what's going to happen with y'all. Hell yeah. Y'all ain't trying to run? You ain't trying to run? Shit, I'm gone, bro. I'm gone, bro. All you got to do is stay out the way for the trial. He probably ain't think it was going to last this goddamn long. But, yeah, I don't think they're going, I mean, if you don't want to be found, you just got to sit still. Think about it. And to be honest, if he hasn't been caught, more than likely, he sitting real still. He really minding his business, y'all, because it's easy to get pulled up for a warrant. I mean, for just a pull up, let me see ID. Like, it's easy to get that. Oh, you ain't got ID? We fingerprinting you. You feel me? Like, no bullshit. So, is it possible he in witness protection? I doubt it. Because I don't think he no worse than Woody. What we done seen with Woody and DK, I mean, if they ain't putting them boys in, what more could he say? What more value? I mean, unless he literally gonna point out the guy. Which I doubt. Did they say he might be the shooter for Donovan Thomas? Has that been a thing? Did anybody implicate him as actually being a trigger man? Real rap. That'll make your ass get up and go get on a run. Real rap. Yo, I told y'all I was on a run, a baby run, right? From a goddamn preset warrant failure to appeal violation, right? When I finally turned myself in, I told y'all the judge said, she looked at the paper, said, oh, this violation been going for a year. Oh, so you was doing all right. What made you come? Like how did he get caught? Lawyers say, nah, he turned himself in, Judge. He wanted to be woo, woo, woo. She hollered, nah, you don't get no credit for turning yourself in. You should have kept running. I promise y'all, she said that. I'm not making it up. Not making it up, bro. She asked me, what was you doing? Told her, I was working. I had studio set up. Boom, boom, boom. She said, so, like, basically, what made you turn yourself in? Why you stopped your good run? I swear, y'all. What made you come in here? You was doing fine. saying I wanted to get this out the way type shit, right? I forget exactly what I said, but that's where I was at with it, thinking it's good merit. You know, I'm going to get some credit for being a guy that just, hey, here I am. You know what I mean? Shorty hollered, nah, you should have kept running. You ain't getting no credit for that. And she ain't even say it sassy. She said it more like on the rules is what they is. But if you is out there, you know, breaking them, technically you had us. They wasn't looking for me, bro. Ain't like I was a goddamn, you feel me? It was basically whenever I get caught up. So if I'd have stayed and not got no trouble, bro, she might have been speaking towards, bro, if you'd have kept fucking going, bro, you might not have had to even face this. Because essentially the charge was so petty, I think technically statute of limitations might have got that up off of there, bro. Real rap. Like if you going to run for 7 straight years on a petty ass charge, like, what happens? Now, she ain't say all that, but I might want to look into that. Real rap. Because that's what the way she was leaning towards. I would never turn myself in. I thought I was right. I thought I was going to be able to just knock it out the box, GK. Because I had a couple of dollars to actually get a lawyer. Yeah, I mean, I was situated. So I'm like, let me go in and jump in real quick. Get this situated, and so I could ride. Shorty gave me that 12 months. Quackow. Wackow. I couldn't be mad, though, y'all. She told me she was going to do it. I had to accept it. Yo, let me know if y'all see the trial pop up, y'all. I got it playing in the background, though. They ain't in there yet. Yeah, whole lot. Yeah, I got it out the way. And I ain't gonna lie, I think I needed it, y'all, so I could get more, I could tighten up. Yeah, I think I needed it because it made me dead serious. Dead serious. The whole 12 months? Hell no. Like 11. And I wouldn't even, I'd have got right back out if I ain't have another charge. I'd have been available to get right back out. I had another charge that I had to go to court for later. Like, I ain't wind up going to court for this other charge till I was like halfway into my time. To where as though they gave me 6 months on that. So now my good time and stuff start being active where I was at, and it actually, put me where I needed to be because I ain't had no open charge no more. But I had this consecutive 6 months. Man, it was phony. But I ain't gonna lie though, for me to get my mind right in the streets, I needed to see that. Yeah, it changed my whole perspective with turning up outside. Like it gave me a real understanding. Like, nah, bro, stop playing outside. It's a business. It ain't no game. Ain't no funny games. Like I was more leisure before that. After that, no leisure. I'm not playing. Was not playing. Even people around me was peeping it. Yo, it's not playing.
Just give me 1 minute.
Okay.
1 minute. I'm going to renew my motion for the court to limit the state's time. I'm going to cite your authority under 244403, 246611, and I'm just going to ask you, please read, if you haven't already, U.S. v. Reeves.
I've read it.
I think it's very persuasive on your ability and the logic and reasoning behind putting a time limit on the state. We just got through with a witness, Your Honor, that the state said was going to take 3 hours. And we spent, now that was just 3 hours on direct. Yeah. And we just spent a week on that witness, Your Honor.
Well,
so
we had 2 witnesses
no way around
this week.
5 days. And then, yes, Your Honor, I'm not going to disagree.
Well,
with you.
wait, no, this is only, what is
Hell yeah. Ain't no way around going to prison, not changing your life. That wasn't no jail, y'all. Yeah, ain't no way around it. Even though it was a short time, it was a real jail, though. You feel me? Yeah, transitional spot. Dudes in there with with goddamn probably 6 months all the way up to goddamn 55 years in the middle, though. Dudes just getting 50s is in there because they ready to get shipped out there to where they at. Now dudes that's coming back in town from 50s. They on like 35 and 40. They in here too. So yeah, this joint was turned.
This is only
It was
Tuesday.
Tuesday. I think it was Tuesday, Wednesday, Thursday, Friday, and then Monday. But whatever. It was far, far longer than 3 hours. So please look at Reeves again and consider it, Your Honor.
So I am reticent to say for this witness, you can only have X amount of time.
No, I'm asking for.
However, okay, we've got a how many count indictment here with at least 8 in addition to the RICO count. 8 different.
Some dudes go in and out, y'all, because they don't got no drive for nothing in a regular world. Ain't nothing for them. Not even the streets. Like, listen. Some dudes don't really want the street life. They ain't got no focus. Them the dudes gonna go in and out that jail, bro. They ain't got nothing that make them, you feel me? You need something that make you say, you know what? I'd be damned to keep going in and out of that. Seriously, because if you're gonna be breaking law, jail is easy to go. It's easy to get caught. But you need some fire in you to say, I'm gonna be out here and I'd be damned to get caught. You gotta turn up on them. So a lot of dudes don't got that fire of the continuously, I'd be damned if they catch me. Seriously, bro, you really got, I'm not playing about that. Like, you should see when you out there, if you out there in the mix, certain dudes just really be on some old, I'm just out here. And you gotta look around and realize, oh, Holmes don't really, he not looking at it like me. Like, I'm really gonna go Carl Lewis when I see the police bend that corner. Holmes laxy daisy with it. Got work in multiple pockets. He ain't even prepared to run. Yo, got his shoes untied. His pants sagging. He think it's a game out here. I'm out this bitch with my belt tied up on my goddamn hips. Like you know what I mean? I'm prepared like every time. I'm thinking they ready to come around the corner and I'm not playing with them. Then you realize everybody else, it's people out here that really do, they don't mind going in and out that clean. They laugh about it when they get back out on the streets. First day out. To be a local joker again. Nah. I done had these conversations out there with these dudes. Yo, what y'all like being out here? Staring in niggas' faces. Y'all like this shit? Y'all niggas is bums. Fuck this. Nigga, I'm about to come up. I ain't gonna be out this bitch no more. Guess what? I wasn't out that bitch no more. Straight like that.
Sets of crimes. And the case law also provides that the state is entitled to, and it is, a violation to prevent them from being able to present their case. And I know that's not what you're asking, but how am I to know how long it is going to take them to efficiently present the amount of evidence to cover all of the things that are in this indictment? That being said, I will say that not so much, honestly, even the amount of time that was taken up with Mr. Sledge, because I assume the 3-hour estimate was
right, bro.
thinking Mr.
All right. So she really tried to talk about time again, bro. That was crazy. I'm going to keep it real. That was crazy. Yo, the trial not on? What is going on? They got 858 people watching nothing. You unalive Quan. Yo, what's going on with that Quan situation? Tap the like button. Salute to everybody in here. I appreciate you being here. I still don't get YouTube. How the hell can they have 800 people? It ain't even nobody in the chat, y'all. They got one message in the chat, and it say they got 900 people in there. 3 people typed in the chat so far. I don't get it. Ain't no way I'm that goddamn annoying. Ain't no way. Ain't no way. Ain't no way. Post, you mentioned how I gave you a different perspective, but doesn't that play in the scared straight? Scared my ass. It ain't scaring you straight, bro. You ain't even got no choice but to make you an animal. It's no choice, bro. You could go in there and curve, but even if you curve, you still gonna come out animalistic. Real rap. Even a curved prisoner that did a bid in one of these real jails, these real prisons, bro, even the curved is coming out animalistic. You feel me? Like I ain't get presented with the situations that would make a dude become more aggressive with necessarily physical. I ain't get put in that situation, right? So I ain't need to sharpen my skills on war like that. My whole thing was trap, like getting to the chicken, drugs. You understand? So that's all I was thinking about. That's all I looked at in there. You feel me? Like, and it's a microcosm of it. It's the same thing going on. So like you like to sit beside somebody in jail and understand that somebody is making thousands of dollars in the jail. It'll make you say, what am I doing? Holmes making more money in the jail than I can on the streets. I need to get my shit together. And niggas doing it easy though. No sweat. It's just an operation that's moving. Niggas nuking. So like when you see that type shit, bro, that's a slap in the face. To ain't no way. Who am I? Am I some local joker that can't play this game? Shit. Shit. But look, I'm gonna tell you this. If it was a war zone, then imagine what it would have did. It would have turned me into an animal on that tip, and I would have came out more aggressive physically. Or I would have had to curve. Either way, I really ain't a curve artist, so technically I would have adapted. Hey, let's party. It is what it is. Let's rock. Luckily, I wasn't in that situation where no pressure was trying to get put on me. You feel me? I kind of was able to breeze. I mean, with no, luckily. It easily could have went another way because I'm damn sure a small dude. So if I was in a situation where dudes was trying to apply pressure, I more came in my age and my size. Dudes, it's like I was in a joint where you really wasn't allowed to take advantage of some little niggas. Plus, I came in familiar with certain people. It gave me a pass. So, like, I'm going to just keep it real. My experience was slightly different, so I wasn't even worried about having to really defend myself or any of that type shit, right? Seriously. I got to keep it real. It don't go like that for everybody. You come in there and you worried about your damn life every damn day. Man. And I will say, the joint where I was at, you wasn't even allowed to rock like that. Like, if you was on them type of terms with somebody, it's going to get situated and y'all ready to get moved. You feel me? Like, it wasn't no open air market where you could it's just going to be live on site brawls all the time. Hell no. You get in that type of situation where we was at, y'all getting packed up and sent to, you feel me? So it's like, it was an order. Oh, your name the fuck I care, and you gonna act soft on the back end? I've been coming here with good energy the last few weeks for you to try and step on my neck this morning was out of pocket. Just wanted to share a relevant video to your stream. I'm out though. You soft as shit with that name like that. Stop being a pansy. You was coming in here talking vague. You ain't share no video. Everybody know how to share the video to my email. Stop playing. Ah. Try again. Yo, your name is, look at your name, bro. How you a victim? Leave, bro. You said you was leaving. Respectfully. And I thank you for being here. And I thank you for sharing the video without really sharing it. Yeah, you ain't send the link or the correct title. You typed numerous messages alluding to there was a video with some idea of what we thought we should go look for. Come on, bro, stop playing. But respectfully, go ahead about your way since your feelings was hurt and your skin was thin. Yeah. Yeah. Respectfully. Yup. Because you just said that you killed your own argument. You know, you've been here for a minute watching my content coming with good vibes, but you never paid attention that I got an email that's open for everybody to send links to the content so you don't have to describe it and distract the content, the people that's in the stream watching. Yeah. Now, please, can you leave? Since you've been around for so long and you failed to do the normal routine that everyone else does. Hey, Post, I sent you an email. So thank you. Could you please leave? Respectfully, I don't like blocking people. But since you brought it up, that you felt some type of way about the link that you didn't never send this morning, yeah, go ahead, respectfully, go about your business, bro. I love you, though. I love you, though. Baby, baby. Salute to everybody. Yeah, hey, good morning. It's 101.9 Slime Radio. Yeah, you know the local jokers will pop up if you don't lock the doors. Make sure you lock the doors. Put the coon catchers out front. Yeah, put the coon catchers out front. Put the coon catchers out front. Yeah, we about to have a party. Somebody go get the coon catchers. Put the coon catchers out front. Yeah.
Sledge was going to be a cooperative witness, and Mr. Sledge didn't ultimately end up being so much of a cooperative witness. But y'all, I mean, the amount of time that was taken up by everybody with Mr. Wright was probably a bit excessive, and I put everybody who asked questions almost in that category. I do think that the state needs to, I don't know, get more targeted and focused with the examinations, and then there seems to be redirects take almost as long as the directs, and that should not usually be the case. And nobody ought to be rehashing things that have already been established, either at, I mean, a little bit of leeway every once in a while to, okay, let me refamiliarize you to this as I lead into what I want to get to. But like a 5-question, you know, there's this.
I got on denim thongs with this denim jacket, bro. What are you playing? What are you saying? You want me to stand up? Stand up. Stand up for your rights. You don't want me to stand up, cuz. Yo, real rad. Hey, Josh, what's up? You ain't never seen that look before? I'm telling you. And I got the knee-high boots on. That's the hardest part. the go get 'em daddy boots. Yeah, they leather knee highs. Yeah, you should see them. You should see them, man. Yeah, some leather Jones. They black. They shiny though. On the radio? Nah, I should be. Real rap. I'm bluffing. I should have applied myself. I don't know why I didn't. Oh yeah, I'm tripping. I got this We doing, yeah, tap the like button. Salute to everybody in here, man. I appreciate your being here. We waiting on the trial, man. Hold on. Let me see what they got going, man. Yeah, they turned the cams on, y'all, but ain't no action. You ain't missed nothing. They just pulling up. Salute to all y'all. Yeah. We doing, what we doing? We got vintage true religion on today, man. Yeah. I'm doing trues. You see the U's? Look, we got orange U's on pockets, man. Oreos and shit. Yeah, vintage. Salute, Marie. Salute to all y'all, man. I appreciate y'all being here. Yeah. We just waiting on some real action. Yeah, I'm trying to rock. I got him. I'm trying to rock. Yeah, I got the Rick James boots on. Yo, did this nigga just secretly put his Cash App in the chat? Tap the like button if you're new. Type something in the chat. Subscribe to the channel. Let us know where you from. Yo, Max B. I don't think Zachary gonna show up. All he gotta do is stall him until the trial over, right? I think I can stay away from him that long. Rick James holla, take my boots off. that yocaine is a hell of a drug. Darkness. Darkness. Man, I got Yoshi Kush, y'all. Yoshi Kush and Coffin Flop.
All right. Yeah,
I don't know what the hell. Okay, she got her hair done for me. It ain't really done. It's just pinned up, you know. Damn, they diamonds in them earrings.
Podium. One of you can come
Bro.
up, and the other one can just sit in one of those seats right there till it's your turn. So you are Miss Borden.
Yes.
Okay, and you want to live stream, or what do you want to do?
Yes, I wanted to do a live stream in pictures and take notes.
Okay, well, you're certainly welcome to take notes. That is not a problem at all.
Everybody want to come and live stream the trial? What the hell? And how Thug get back in the front? What the hell going on? Bro.
In terms of live streaming, we've already got a lot of different cameras going, and so you are welcome to pool from either of the streams that's already occurring. All right?
So the judge is allowing everybody to stream from the streams that's already going. Remember I told y'all this live stream stuff was going to change? They out. But if y'all pay attention, the judge is defending the corporations since they already got the Rule 22. So is she going to block the news companies when the regular people get all of the courtroom Rule 22s before the news companies later on? So let me say, for instance, if I get 5 cameramen in all of the rest of these trials that's going to be in Atlanta, will she still allow Long Crime in there on the back end? Or will she tell Long Crime they got to get the feed from me?
Your Honor, I would like to, if it's okay, I would like to submit some reference letters that I have from a civil rights attorney and also the news media channels that I've been working with over a decade.
Oh, she works with news media. Look, here we go.
We may, and it absolutely has nothing to do with who you are or who you represent or what you're going to say. It's just that we've already got so many pieces of equipment.
But is there rules on how much equipment can be allowed? So look, here we go again. All right, so the rule gonna be they need bigger courtrooms now, y'all. Y'all see what's happening? They need a whole area for the camera crew. Y'all see what's going on? Why? I'm telling you, that's what's really happening. That's the only reason they letting these people get up there on camera, is to exploit the fact that, yo, everyone wants to see these trials. Nah, the law ain't really first come, first serve, to be honest, because technically that means you limited at a certain point. So it's like, it's tricky.
In here, it just becomes a kind of a security matter and a distraction to the deputies and frankly to me to have to trying to keep track of that many more pieces of equipment and people handling them. Had you been the first person, I probably happily would have given you the right. But it's just, we've already kind of got everything set up. There are two different streams that you can pull from.
How?
Oh, yeah, I'm happy to take them. That's not the reason for the denial. It has nothing to do with who you are.
And can I say something, please?
Sure, absolutely.
So my concern up under the Rule 2022, and I've been doing this over a decade as a civil rights leader, and also in the
Yeah, cuz that boy got a goddamn hillbilly toothpick in his mouth right now. Who the hell?
for the community advocate board, our former mayor. So I am aware that there are other cameras, but with the case of this nature, I feel like the community deserves different angles and different.
Man, lady, get the fuck out of here. You late as shit. We halfway through, and a person coming in here and saying, that's cap. She's so concerned, but she coming on the back end, bro.
Perspectives. So while they do have a camera and while the camera is on, there's still different perspectives and angles. That footage goes through some other entities that I'm not a part of. So even if I was to pull or jump on their train, that is separate from me as a civil rights leader.
You ain't pushing those. I'm pissed. I'm pissed. I'm pissed.
And wanting to share with the community and making sure that it is a fair trial.
Okay, so I don't know.
You late. Get out of here.
If you mean angle as in position that you would take in your reporting or angle as in camera angle?
When I say angles, meaning that, for example, there's a camera on right now,
Right.
that I'm looking at. So if I want to report something or show something and it's not from his angle, that means if I have to jump on what he's doing.
Lady, I am pissed right now. I am pissed.
I'm relying on his footage only.
So you actually literally mean camera angle.
Yes. Yes,
Which
camera
is
angle.
either going to be
Yes.
on the witness, the judge, the state, or one of the defendants.
Yes, but it's still the reliance of me depending on the footage. And I'm pretty sure the footage that they have, I know any other time I've worked with 25 and 1146, there's an approval process for that footage.
That's who Sylvia worked for, y'all, who she just mentioned. So there's another person that says she been working in this same group of news companies. Look. So all these people trying to hoard the content, y'all. Pay attention. Sylvia worked for that same company she just named, y'all.
I will also be dependent on that sometimes as well. But if I'm able to stream myself, then I have more control of that footage.
Okay, well, if you want to go back in the media room and film from there, you may do that.
Okay.
Okay. All right. All right. Anything else?
No, Your Honor.
Okay.
Well, get the hell out of here.
All right, and Miss Hall. Good morning. How are you?
Good morning. I'm fine. Thank you for your time.
The ugliest fake butt ever. The ugliest fake butt ever. Here we have it. God damn.
Okay.
Sure. And you want to do still photography and audio.
Yes, ma'am. My situation is a little bit different, even though I do have a YouTube channel and I can pull from the pool, which
Cameraman got radical.
because I'm a freelance blogger. I can't depend on the pool for still images. So my situation wouldn't.
Yo, why is everybody hopping on this trial in the back end, bro? So I don't like this, bro. I don't like this, bro. Like, what is they doing? How they on the back? Yo, this the we had to.
Up tripods or
Rod don't even like her ass. Look at Rod. Rod, like I don't trust her. Despicable.
anything of that nature, and I would ensure the integrity of that.
Rod over that bitch with a goddamn regular black sweatshirt on, looking like goddamn Ice Cube. Fuck.
It's important, especially from our sitting that we have,
member over that bitch. Bro.
that we don't compromise any integrity. Of
My
truth
bad, y'all.
or
Her
anything
butt
of
is
that
terrible.
nature.
All right, and
Sorry.
you'd be able to, you say still photography and audio, you'd be able to pull audio from one of the
I
pool
can pull,
sources
yeah, I can pull
already.
audio from pool.
Okay.
This is bad,
what
yo.
would you-
Everybody
what
wanna
kind of
talk
equipment
now.
are you talking about?
Sony AX50, one of those type of still cameras.
Wow.
Does it make any noise?
I will make sure the settings are off.
All right, you're going to need to be wherever it is that the deputies put you.
Yes,
And
ma'am.
you're not going to be able to move around.
Yes, ma'am.
Okay. All right, and what's the camera?
I have a Sony AX1, Canon C50. So I'll work with the settings and make sure which one will be dependable on the fact that it will make no noise.
A C50.
All right, and you'll be the one operating.
Yes, ma'am.
Okay. Thank you.
Thank you.
Man.
All right, Ms. Abbasi, did you just get alerted this morning that you were going to be the one covering court?
Is it granted?
Yes. We'll get the paperwork out to y'all probably sometime today.
Okay, thank you so much.
Doug even had to look at her ass on the
Okay.
way out. Like, what was that? Yeah. 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 Got him. I told y'all Thug had to check it out. He like, I ain't never seen an ass like that. Now, I've seen a lot of asses. Let me check this one out because I've been locked up. This one right here is crazy. I've never, look, Brian still like, whoa, that was, I don't know what I would do with that. Like, that was a triangle ass. I've never seen a triangle ass. We used to round asses. Never seen a triangle ass. We used to circle asses. I ain't know they had V-neck asses.
Okay. Well, since you didn't know until, I guess, a few minutes ago, nothing you can really do about it other than get here as soon as you could. So I appreciate you doing that.
Yo, that boy really
All right,
got on the
does anybody have an
NWA
issue with-
sweatshirt. He's like MC Ren over there. Yo,
Thing
crazy.
that occurred over the course of the evening that y'all need to bring up with me? Or is everybody fine? Yes, sir. Well,
Thug really
Mr. Sharp
sized
stood
it
up
up, though.
first.
Thug gonna go back over the tears and be like, yo, y'all ain't gonna believe this ass I seen today, bro. Y'all ain't gonna believe it, yo. It was a triangle. Niggas can be like, what? Tell us more, bro. Tell us more. Hold on, yo. Let me get this. Hold on. Let me get this hook up real quick, bro. Tell me more about this triangle ass you seen.
Your Honor, we came into
She was, what the hell happened? What the hell? What? Niggas start talking and they put us on pause. What? Man, yo, I don't trust these media people, bro. These new people popping up, bro. Why they ain't get the Rule 22 early? Yo, they popping up and really want to be on camera. They just trying to get a commercial for they platform, y'all. Why they just ain't say the name? Yeah, I'm such and such and such and such. I be on every day at 8 a.m. streaming the trial, but I was trying to know if I could get my own camera in the courtroom. Oh, no. Well, please, whoever's listening right now, check me out. I'm so-and-so at such-and-such.com on YouTube. Fuck is wrong with you, bro? What is they doing? Who the fuck is these people? Who these people, bro? Man, I just want that old thing back. The money lucrative. Not really. I'm gonna say not really. Oh, they know something I don't know. All right. How many famous people court cases gonna go in the city where you from? And how long are they gonna last? They should sell banner space. Shorty had the Oval Office on her back. You missed the debate. Man, that wasn't no debate. You ain't missed nothing. Real rap, you really didn't miss nothing. The court's already overturned Lil Rod conviction. Lil Rod eyes on the fake BBL? Yeah, yo, if you in jail, any BBL is right. It probably didn't even look like how it looked for us. It probably looked regular to him. Yeah. Fat chicks start looking, you start making shapes out of them when you see them. Yeah, you can kind of like form a chick to look how you want. In your eyes. Yeah. Perceptions get like, yeah, you could change. It's stronger than beer goggles. Yeah. It's stronger than beer goggles. Yup. I'm talking about, yo, you could turn something that's like a 2 into like a 10 in your mind. I'm telling you, I seen it kick in while I was only there. I was a short timer and it started to kick in on me. I'm like, oh yeah, this that shit. Yeah, because at first I wasn't even jacking it. Now something wild hit the corner. I'm on it like a dog, you heard? And it ain't even what I would normally be on. That ain't nothing right there. My mind was playing tricks on me. I literally could catch myself like, yo, you don't like that. Look at it. And then one side of me is see it like, yeah, you're right. That shit ain't right. And then I see it again and I'm like, oh, there you go. So it's like you got to catch yourself. But look, if I was there a little bit longer, I'd have been trapped. I'm telling you. See, you get convinced. All right, look, this what happened. Other dudes could put you on too, right? So say, for instance, you minding your business. Another dude like, yo, look at her. You like, who? He like, look at her. So you ain't even peeped this chick. She regular, not even, you know what I mean? Because everybody, they ain't dressed up. So when home say, look, I ain't gonna lie, bro. I've been, woo, I like her. Look. You know what I mean? You like, oh. So now he done put you on something. So you looking like how he looking now. You like, well, nigga like, shit, I'll do this. Woo. I'll take one of these big bitches. You nigga can't even be greedy. So you get convinced. Yeah, nigga, I am locked up. Who I'm supposed to? So your threshold of what you looking for will definitely alter, bro. I caught myself, y'all. Seen a little ugly little duck come through the joint. She came through looking real ugly and shabby, right? Now the old head warned me. He said, yo, they look real raggedy when they first pull up, when they newbies. But when they get a couple dollars, they gonna get their head done a little bit better, and they gonna start coming a little bit better. So watch them, right? So a little ugly little duck came through, right? So I peeped. So I'm like, oh yeah, shorty a little ragged, all you feel me? Seen her like about a month later. I'm like, oh, I was a little smitten all of a sudden. I say, oh shit.
Provide me with anything you found between yourself and any of the attorneys for co-defendants who have entered pleas.
Judge, the court gave me information.
Oh, okay, that's fine.
Your Honor, I would like the permission of the court to check with Ms. Winfrey's exhibits to see that 460 is up there because I took one stack, but 460 was not.
You can check.
Thank you.
And were the parties able to come to any agreement or partial agreement with regard to any of the exhibits that were tendered at the end of the day yesterday?
No, Your Honor, we haven't discussed that.
Y'all haven't what?
We haven't discussed that, redactions. I have gone over the exhibits themselves, and I have a legal argument that I'd like to present to the court regarding 104.
Well, I'll hear it after lunch then, because I instructed you to get with the defense so that you could see whether y'all could come to any sort of an agreement. So if they haven't seen it yet, then I will give y'all the lunch break to accomplish what you were supposed to accomplish yesterday evening.
Yes, and may I inquire what the court inquired? 460, which was a document that I believe at the end of the day, some counsel for defense looking at, I believe that I retrieved it, but I believe Mr. Sharp may have had it.
I don't know. Does anybody have 460Y? Can y'all check? Sometimes it's hard to keep track of all the documents.
They starting off stale as a mondron, ain't they?
Identified only.
Yes, identified only. I don't know.
Where Adam's at? Good question. Tap the like button. Salute to everybody in here. Straight up. Keep grinding. I don't know what they ready to do, y'all. Hopefully we get some excitement today. It feels really weird. Yeah, they got the seats switched around. We ain't back. I'm using my phone internet, y'all. This will not work. We ain't back. This connection is this. I'm gonna run through this data in about. First off, it can't even feed the amount of data I be sending. So I'm gonna just let y'all know. T-Mobile about to clip that ASAP. They about to clip that ASAP. Bet that. Yeah. I got y'all. Yeah, Comcast bluffing, y'all. It's a Comcast shortage in my area. They bluffing. Yeah, it ain't me, y'all. It ain't nothing I could do. The bill paid, I checked everything. It's them, it's actually a shortage, y'all. They talking 12. You mean? I'll be back, though. I'll be back, Jack. Nah, we not really back, y'all. Nah, I can't really stream. It's gonna keep glitching. Yeah, Comcast down for about a couple hours. Yeah, I'm glad it happened today, so I ain't even really tripping. Yeah, but you know, I'm going to have to go back to see what they was doing. So regardless, I'm going to be back. Yeah. I can't even watch it, to be honest. I mean, I probably could watch it on my phone, but yeah, I pulled up to let y'all know what was going on. Nah. We not back, y'all. Go watch it. Go watch it somewhere else, y'all. Until check me back at 12. Check back with me at 12, y'all. Yeah, put your notifications on. I mean, I might just leave this live stream up until I go live again, if it'll stay up, because somehow I managed to let it keep running somehow. I don't know how I did that, but yeah, it ain't nothing we could do. I just gotta wait, y'all. It ain't no technical things on my side. Ain't nothing wrong. It was just the internet on Comcast. You feel me? But I'm glad it happened today. I ain't tripping. Who knows what happened? I know it's glitching. And somehow I just rolled the skinniest blunt ever. I don't even know how I rolled the skinniest, this little ass blunt. I'm talking about, you'd have thought we was trying to roll 6 out of 3.5 or something. The way I rolled this joint. A streeter. They call this a streeter. A skimper. Yo rolled a skimper. Yeah, y'all, I'm smoking skimpers over here. I'm doing bad. My internet connection fucked up. I'm rolling skimpers. It's crazy. Nah. I'm tripping, y'all. Everything good. Comcast just failed. Guess you ain't like my comments. What are you talking about, bro? Everything good, bro. I don't know who you talking to. What I'm smoking something called coffin flop. I ain't even put enough in the blunt to really pay attention to what's going on with it. To be honest, I can't even judge it off of what I just did. I wrote this. I can't even call this blunt. Put it like this, y'all. This the type of blunt, yo. When you smoking and you go to hand it to somebody, they gonna say something. Yo, what's this? Damn, that's paper, bro. Damn, bro, what you smoking? Grass or paper? Yeah, coffin flop. It's made by a company I condone. It's the strain company. I like some of they strains, but this one called coffin flop I never tried, so I got it. They had something else called Yoshi Kush too, and I tried that. I haven't noticed nothing spectacular going on, but I'll let you know. Yeah, can y'all hear me smooth? Let me see. Yeah, that bitch done dropped 14,000 frames since it's dropped 70% of the frames I've been streaming. Yeah, that's, hold on, y'all. I think I might be able to fix it. I'm lying. No, I'm not. I think I can. I think I can. Hold on, y'all. Let me see. What? They gonna let me change it in real time? Cat. Hell no. They is not ready to let me change this number. Yeah. Did it? I green lighted it? Oh, no, I didn't. Did I?
I'm wrong, but I thought
Why is it in negative time?
You can check. And were the parties able to come to any agreement or partial agreement with regard to any of the exhibits that were tendered at the end of the day yesterday?
No, Your Honor, we haven't discussed that.
Y'all haven't what?
We haven't discussed that, redactions. I have gone over the exhibits themselves, and I have a legal argument that I'd like to present to the court regarding 104.
Well, I'll hear it after lunch then, because I instructed you to get with the defense so that you could see whether y'all could come to any sort of an agreement. So if they haven't seen it yet, then I will give y'all the lunch break to accomplish what you were supposed to accomplish yesterday evening.
Yes, and may I inquire what the court inquired, whether 460, which was a document that I believe at the end of the day,
Yo, how the connection is? How the connection is, y'all? I just had to do some tech shit. Don't ask. I mean, it ain't that, well, I don't know. But yeah. Who knows how long it's gonna last? I done cut down my data rate, right? So it could play smooth. Now we banking on how much data does T-Mobile give you for unlimited. Now I don't never use my phone, so we going off of a whole month's worth of goddamn data. So let's see how fast it take for unlimited to allegedly run out. Real rap. We on unlimited, allegedly. So technically it shouldn't run out, right? But let's see how long it takes.
I don't know. Does anybody have 460Y? Can y'all check? Sometimes it's hard to keep track of all the documents.
There were several documents that someone, I think it was either myself or Mrs. Adams, put into the
That boy talking from the furthest wall in the courthouse.
Identified only.
identified only. I don't know.
Something don't feel right in this courtroom, though. Turn me up, y'all. Turn me up. One's in the chat. I lost all the
Yes.
people, y'all. Well, I ain't tripping, y'all. They dipped off because I wasn't here.
Do you locate it?
What motion for Mr. Ryan?
Were you able to locate it, Ms. Love?
Move thugs because of death threats. Don Cato, salute. Yo, salute for that cash app.
Okay. Well, I'd imagine that would be easy.
You just
enough to
told them I'm
reproduce.
back.
It's
Where they
just
go?
printouts from emails, right? I mean, yeah. I'm sure I have a copy of it since you gave it to me, if that would help.
it would, if the court doesn't mind allowing us their copy, court's copy, I will.
Okay.
return it back.
I don't
You
think I've
drinking
made any
hen?
markings. Well, I have made a marking.
Whoa.
I'm sorry.
You ain't gonna be here long.
It would actually have to be recreated, so I can.
To just, yeah, look at it to recreate it, that's fine.
Hilton back.
Nobody was able to find A460Y anywhere?
I personally don't have.
Okay. Has anybody checked up in that podium area? Okay. All right. Well, it can be
die.
regard to, just kind of a general overview, the evidence that will establish that Act 79.
Generally,
What we doing?
All right. And Ms. Bossy, do you want to make any argument?
At this point, no judgment.
All right. Turning to the issues we need to decide. Ms. Abbasi, your co-counsel, had filed a motion in limine regarding autopsy photos from the Holmes murder. Is the state ready to respond to that?
yes, Your Honor.
All right.
Salute to
And Ms.
Don
Bossy, do you want to make any
Cato,
argument?
man, and Cito.
At this point, no judgment. The motion is largely self.
All right.
Thank you, Your
Straight
Honor.
up.
Good morning.
Good morning.
Your Honor, when we
My bad for the fumble, y'all. That wasn't me. That wasn't me, y'all. That was Comcast, and they said my real internet ain't gonna be on till back ready till 12. So I'm streaming from my phone internet. I don't expect it to last long because I'm pushing way too much data. T-Mobile cheap.
get to presenting this act, which is count one, Act 79, the state intentionally did not include the medical examiner. This is a case in which Mr. Ryan has been convicted of the murder of Jamari Holmes. And so it is only the state's intention to bring in 3 photos, and I have a copy of those 3 photos that I can show Ms. Abbasi through the lead detective in order to minimize that level of testimony. And so we do not plan to stipulate, but we've selected only 3 photos that we intend to
All right.
introduce.
Let's see what they are.
And I can bring them up to the
Whoa.
for the purpose of this hearing.
All right. This homie that they talking about right here, Holmes, that dude that allegedly Lil Rod had something to do with him being unalived, right? That's a key element. Now, I skip over that one because Rod got the case overturned, and I believe that shouldn't even be brought up in this RICO because I don't believe it had nothing to do with the gang. That's my opinion. Yeah, I'm familiar with that part. I heard when they mentioned it yesterday, the actual autopsy photos. But see, I've been kind of skipping over this because I think technically I don't think this homie should be a part of this RICO trial, y'all. This is one of the ones I was firmly trying to get, separated, or this ain't got nothing to do with this gang. And really, you really super reaching with this one. And that police situation with Christian Eppinger. Real rap. These boys so young, and in the situation is so wild. It's like, yo, you really just trying to put that to add that to YSL versus really accepting that these are some crimes that was done by some other people that just happen to be in proximity. You reaching. And I think this one right here is really a reach, y'all.
Yes.
Hotspot lasts for 7 days. That's cat. You must say never. You ain't pushed this thing to the limit like me, boo.
And for the purpose of this hearing, Your Honor, the state's going to label them States 1 RR, States 2 RR, and States 3 RR.
We gonna crush this thing in a couple hours, cuz.
And what do y'all plan to present with regard to, just kind of a general overview, the evidence that will establish that Act 79?
Generally, Your Honor, what occurred leading up to the homicide of Mr. Holmes, which was a luring of Mr. Holmes to an apartment complex that Mr. Ryan and Mr. Blaylock then, we believe, ambushed Mr. Holmes along with 2 other.
You might be able to watch some TV and stream some TV and stuff like that. Yeah, but what I'm doing right now, nah, we pushing too much.
Victims. They were in a vehicle. Mr. Holmes was shot, and then they fled. And then subsequent to that, there were Instagram postings, Facebook postings, social media postings regarding YSL.
very close in time to the murder of Mr. Holmes, Your Honor.
All right. And how many witnesses are you going to utilize?
For that act, we have 5 witnesses.
Who are they? And what will they generally testify to?
Yo, the resources.
You know, that 5 is a marked reduction from the original list of witnesses.
The courthouse has to balance in favor of the state because of the defense got way more resources, y'all.
Your Honor, 5. The witnesses for that act are Ms. Sharon Latner's, Starry Holmes, who was the mother of Mr. Holmes. Mariah.
An eyewitness?
No, she is. Just will be able to bring in his in-life photo.
Let's figure out a different way to do that.
Facts. Cumulative.
Especially given that this is not even the trial of that case.
And speak about Mr. Holmes and who he was. Okay.
Nah, cumulative. Oh, Shorty came from jogging this morning. Knew she was going to be all right with Rod. She like, nah, I got you, Rod. Miss Williams going to sub out. I'm going to come in after my morning jog, and I got this. Dang. Yeah, she an animal, y'all.
Oh, and that would be sustained.
And to talk about his involvement, who he is as a prior to this murder happening, he was a juvenile. I don't know if any of these other witnesses would be able to do that. Mariah
Cumulative.
Smith was someone I believe he had just met recently who helped set up the robbery that ultimately led to his death.
Okay, all right. Have you moved on to another witness now? Is Mariah?
Whoa, Mariah Smith. Yo. All right, so the little girl of Mariah Smith allegedly is the girl that Lil Rod and them used to set up some robbery that turned into a homicide that they saying is connected to the gang. Yes, sir. They say, all right, they trying to say Holmes, they did this in furtherance of YSL. First off, petty robbery, young kids. But I think they even went as far as to saying Holmes is from the ops side. Don't quote me on that back part. Everything else, I'm stamping. All of that. But I think they even went that far. Try to allude to Holmes was from the opposite side or something. I swear, y'all. I was tripping like, oh, whoa, they going, I thought it was a botched robbery. I think they even went to the way he got set up was he was a op. They went for the robbery on some old, man, I ain't going for it, though. I ain't going for it.
Smith another witness, or
Mariah Smith is another witness, Your Honor.
So Mariah Smith would be able to say he was a juvenile, right?
She doesn't. I don't believe she really knew Mr. Holmes.
Facts. It's cumulative. She don't even know yo.
How old was he?
He was 15 at the time of his death.
Mm-hmm.
And
Miss Latner's backing up. She would introduce a 911 call,
yes,
and what's that gonna say?
Judge, you know good and goddamn well is what it's gonna say. What the hell kind of question was that? Judge, you ain't been paying attention to the case. Listen, we got so many overt acts. You must don't do RICOs. So we got so many overt acts. We need the goddamn 911 lady to come back every time. You don't get that? Gee whiz, you ain't never did no RICO trial, lady. So look, let me explain to you. It's multiple overt acts. Every time we get to a new overt act, we need the lady with the 911 calls to come so we could play the 911 calls, get used to what we about to be going over with these other witnesses, and then it all works. You know, each overt act has its own 911 calls and its own set of witnesses. You don't get that, lady? What are you doing? What are you doing? What are you doing, lady?
It was the initial reporting of the shooting. So it was at the time, the time of the shooting.
Just one call?
Yeah, I believe just one call.
What?
We have no objection to the call.
Okay.
Admitted where.
Yo, she tripping.
No problem with that call coming in.
Is that
Hey,
the
yo,
call?
she really tripping right now, bro. She tripping because she trying to insinuate that it's cumulative what these witnesses coming for. Her asking what the goddamn CAD report lady is coming for is crazy. Real rap. I'm going to have to say, if I know exactly why the hell the CAD lady need to come, what the hell is the judge doing questioning it? Real rap. It's like that's the only person you really can question. Real rap. What are you doing? We got an overt act. We never heard the 911 calls. So, unless she's saying we don't need this lady to hear the calls. We've been hearing her ass pop up every other time. She seem annoyed popping up, so maybe she knows something we don't know too. Maybe we don't need to see her ass.
I don't think that that's the call. I think that the initial call about the shooting.
That may be a different call.
Yeah, that's
It's a different call.
Okay.
And
Okay. So
the witnesses are
He is
a
not happy.
skeleton version of what we can present to show absent, because we cannot just put in the certified to show the facts of the case. So
That boy Thug is not a happy camper today.
we're trying to put
well,
in.
I mean, sure, the fact that the murder wouldn't get it as an overt act that is a part of RICO. So I understand you need to do a little bit more than that.
Right. And so we're trying to, we've scaled back. We had these
Okay.
witnesses.
All right. I don't need to
represent
hear what it was going to be at one point in time. Maria Smith is going to say what?
She was one of the two young ladies.
Rod, this is not the day to wear the goddamn crew neck sweatshirt up there. God damn, bro, why you ain't wear the goddamn? Why you ain't wear the prom suit, bro? They talking about your body today. Come on, baby.
Who lured Mr. Holmes and his three friends back
Okay.
to the location, or to the location.
All right.
Then we have one of the two other victims. We don't plan on calling both of them.
Okay.
So that it'd be either Mr. Uten or Mr. Mitchell.
All right.
Then we have the lead detective on the case, who was Detective Hogan. Then
Circle that.
we have Mr. Mike Sprinkle, he further brought.
All right, let's talk about this fashion that Yak done brought out today. Triple black, turtleneck underneath of the collar, unbutton the top collar, and let the tie go loose. Yeah, he flaring on him. You ain't know? Yeah, you ain't peep it? Yes, sir. It's low key. You gotta pay attention. He flaring. Yeah. Yup. No blazer. That's flare. Nigga look like he work at motherfucking Applebee's. Papa bet you. Yo, the slickest waiter they got. This nigga get mega tips. He just took his apron off.
Did additional evidence of some of the social media, that came in later. And then last, sort of.
7, not 5.
So Rooney Lee is one of the co-defendants or co-conspirators in this case. He is coming in during this portion, but he was present during the initial trial of Mr. Ryan and posted some social media postings with rat emojis when Miss Mariah Smith initially testified in that trial. And so
What?
he's coming in that portion, but he's not actually a part
What'd
of
she say?
Trial of Mr. Ryan and posted some social media posting trial of he is coming in during this portion, but he was present during the initial trial of Mr. Ryan and posted some social media postings with rat emojis when Miss Mariah Smith initially testified in that trial. And so he's coming in that portion, but he's not actually a part of what would prove the actual act, but that's why he's included.
Your Honor, we do need some clarification whether it's going to be Mr. Uten
Girl, you know it's true.
or Mr. Mitchell. We've been in contact with the state about going through the evidence offered for these witnesses, what does or does not need to be redacted. Mr. Uten's interview is.
Can you spell that last name?
Yes, Your Honor, it's Ooten.
Okay.
His interview is maybe 20 minutes, half hour with some quiet time, and Mr. Mitchell's interview is several hours long.
Damn, this nigga got a vampire tie on. The fuck is that?
Okay. When are we going to get to this part of the trial?
Your Honor, we would believe that we would get to this portion of the trial probably early October.
Okay.
Damn.
So fairly soon.
Fairly soon. Yes,
All right. When will y'all know who it's going to be?
We should know within the next few weeks, within 2 weeks, Your Honor.
Well, 2 weeks from now is the end of October. So
Hell no. Cap, her math off than a on John.
I mean, the end of September.
Okay.
Trying to rush that along.
Okay. Get it right.
Evidence they believe will actually be admissible. Right now, we've got more than 50 pages of Instagram records from Mr. Blaylock, co-defendant.
That lady definitely does cross country running. She's slender than a mon John. Oh. Where the fuck? What the fuck? I lost it. It's gone. Yo, it's gone. What happened, y'all? It's gone. It's gone. What the hell?
For the 200 pages from Mr. Ryan, those are obviously issues we'd rather not sit down with the court and go page by page.
My bad, yeah.
We need to then.
And I believe there was some preliminary conversations, and we do intend on furthering or finishing those conversations with Ms. Abbasi and Ms. D. Williams.
Okay, well, that probably needs to get done before the end of next week.
The state could respond to our emails.
Turn your mic on,
y'all
baby.
We can. We've also found it fruitful to communicate via phone, which we have done and will continue to do at times that are convenient for either Mr. Abbasi or Mr. Williams. That communication has not stopped. I think there were some issues, but we've done that as well.
All right, well, try to do it in a timely manner, please. Okay, let me see the photos.
Mm.
And the photos would come in through the detective. Did you get copies too, or are we just going to Is this third one like post-incision, or is that the exit wound?
That is the entrance wound.
Entrance wound?
Yes, Your Honor.
Mr. Honor, one of our objections is I don't know who's going to be able to answer that question. I don't believe the detective is qualified to explain what type of injury you're bringing in. We don't believe the detective will be able to lay foundation. Oh, I'm sorry. We don't believe the detective will be able to lay the foundation for these photos.
All right.
We believe that with some conversation, he can talk about the fact that the victim was shot in his head. That is the victim that it was his homicide that he was investigating. The picture, which I believe is 2RR, with just the area in which the
Before it's shaved.
I believe that he could talk about where the bullet was, or that he was shot in the head.
Bro.
And then the last
You don't need to show that picture, though.
photo, I'm not sure if he'll be able to say it's an entrance wound. We'd have some further conversations with him regarding whether or not he was present during the autopsy or not, and whether or not he
Yeah, Marcy, I don't know how the facts of his conviction is admissible if it got overturned. Seriously. I really don't. And I'm mad that they even didn't, they left him on this side of the trial. They should have severed him, man. For real, man. Like, bro. So Thug told him to do that.
Do you think that there's any chance he was present during the autopsy?
sometimes they are.
What?
Sometimes they are. I'm not saying that he would, but sometimes they
Sometimes.
are present during the autopsy.
Was he present at the scene before the body was removed?
Yes, Your Honor, I believe so. I
Believe.
so, but I need to ask
Okay, well, you'll-
Ms. Love.
We doing a lot of guessing. That boy facing life.
Your Honor, I've got, based on the police report, the officer received his phone call at 6:07 requesting assistance to the homicide. The victim had already been taken to Brady and ambulance 571 was pronounced dead.
Uh-oh, she had shock over that.
Okay, so if he was at the scene, he wouldn't have seen the victim at the scene, so that would.
She a skinny ass shock. You damn. Yo, she tackled Hilton ass just now. Hilton tried to slide that shit in. Shorty attacked their ass real quick. Stop playing with me.
Wouldn't be helpful with regard to these photos.
And Your Honor, we were trying to avoid the ME, so if we can have some
Damn.
stipulations to that, or
He got life
we can have
already.
ME
You
come in
sure?
for innocent purpose.
Why don't you?
Oh. His case got overturned. You sure? I think he gave it back and got to go back to court. Yeah, it got overturned, Jones. You sure it didn't? Maybe I'm confused then. On appealing, that don't count? Yeah, you back neutral when you appealing. You back to square one. He had life. Once you appealed, you back at 0. You got to get re-lifed. You ain't got life no more when you get an appeal. True or false? That shit gone. Now, you ain't safe, though, but that's gone. You feel me? It's not safe. No.
I'll get together. I'm going to hand these back for now and come up. Maybe you could come
False.
up with all sorts of stipulations.
How?
So we'll revisit that.
Well, he not on appeal. Okay. All right. The appeal is in progress. He not on appeal. So what happened? Nothing? Please explain more. Can you explain why some of us have the wrong impression then? Because I'm confused. And there's a couple of us that have the wrong understanding. So could you please expound on why we're wrong?
But we are just trying to reduce the need of having to call the medical examiner.
Say that again.
We are just trying to reduce the need of having to call Dr. Sullivan.
Well, there's no necessity to call him or her. Can't remember. Thought so.
Oh, you're at work, can't type like that, but you can tell us that we're wrong. Oh. Oh.
Okay.
Oh.
Yes.
On that, I'm not saying I cannot find my list. I cannot remember if the state is moving for the verdict against Mr. Ryan into evidence, but I would be objecting under 24-8-80322. And I'm just reading from a case, a jury's verdict that the co-defendants were guilty as a hearsay statement. The exception to the hearsay rule provides for the admissibility of the final judgment of guilty as to a felony, but not including when offered by the government for purposes other than impeachment, judgment against other persons other than the accused. And then I just pulled up 24-8-803, and then it's subsection 2.2, and it specifically says the same.
What's with the state's plan with regard to that?
I just want to put you on notice so we don't go into it.
As to the conviction
It was already overturned, meaning he won the appeal, right?
itself, Your Honor, I believe that it would not be improper, and I'll reread the case law on that. I don't believe that it would be improper to limit, as the court did earlier with the conviction itself of the witness. Actually, because it was not a statement that he made, actually, Your Honor, I think that it would be admissible against all of them. It wasn't a guilty plea, so it's not a statement that the
It's any judgment of previous conviction is what 22 covers.
Okay.
So,
So to the extent that the actual certified is tendered, then if it is the fact, and it could, we don't argue that it, it's probably the fact that that certified alone is admissible only against Mr. Ryan. But the facts of the murder itself and the circumstances and what he did, we'd argue are admissible against all of the defendants in this case. So
the facts,
yes.
right.
Not the actual certified, but I was speaking Ms. Hilton, not the court.
I can't hear you. I mean, I know that mic doesn't want to behave properly, but maybe you can borrow the witness stand mic if that one was even working yesterday.
It wasn't. I'll try to hold it carefully.
Yeah, you got to hold it.
The certified itself, we may have no argument regarding that being used and there being a limiting instruction as to the certified itself against Mr. Ryan only. But we would also ask and would craft and present to the court an alternative if there is an instruction that is requested that includes language that the facts that are presented, that the jury takes as evidence, are admissible against all of the defendants, including any postings or statements that Mr. Ryan or Mr. Blaylock made as a result of or in furtherance of that act.
Okay.
First off, something fishy with them splitting them two up. I'ma just say that. Demiki and Garlington being over on that other side. Damone Blaylock being over on that other side. Like, that's kind of tricky because they involved in overt acts that's included in the RICO, and they co-defendants from those charges are on this side of the trial. So, like, mind you, I talked about this early in the trial, whether Lil Rod evidence can even be introduced. Real rap. Is Thug staring at his ass? Is Thug staring at Rod, though? If he is, he on his ass. He like 6 feet away from you, staring in your eyes from the side. Rod was trying to act busy.
The court can't pick this up somehow. Or another. The person who is running the camera,
Rod trying to act busy.
All right. Well, I have, that is irrelevant to me. I mean, I'm not worried about how the media can or cannot hear. I'm worried about whether the parties in this case and the court and the jury, when the jury's here, is able to hear. So they'll just have to deal with it.
Because the issue was they can hear our internal.
Oh, they can hear what y'all are saying there at the, so that's getting picked up?
Yes.
Well, that's problematic.
With all the mics off.
Okay, so y'all going to need to adjust your microphone in a way that is not picking up attorney work product conversations. Can you do that?
You just get the feeds from the courthouse.
Okay, well, then you're not going to be able to to do the audio if it's picking up attorney work product conversations between
That's y'all bad audio.
the counsel at the tables. I don't know what to, I mean, some adjustment's going to need to be made. I doubt if they can hear it all the way over there, but what all's getting picked up?
Bro.
Just when we were having a conversation,
The state?
I turned the audio off when I heard it.
Yeah.
Well, I appreciate that, but I'd imagine it's going to be pretty constant that they're going to need to talk amongst themselves.
And it's happened multiple times in trial that people will text us, they can hear your conversation at the table. So this is a repeated issue that's been.
Okay, well, thank you for bringing it to my attention.
Oh, they trying to get the camera. Oh, shit, they dirty macking. People can hear your conversations.
Where's your feed, like your audio feed coming from? Where's it getting picked up from?
Exactly.
You know where the mic is?
No, it's connected to the court system. So whatever feed you all give us.
Now, it's y'all that's doing it. He ain't got no specific mic. They try blaming on the cameraman, but the cameraman is getting the goddamn feed from the audio feed of the mic system and audio that's in the court. He is not doing no extra audio. He ain't got control of it. He ain't got control of it. Real rap, y'all. Yeah, come on, bro. I could tell he ain't got control of that audio feed. Yo is getting the audio feed from them. How else would her mic be coming through the goddamn video camera, y'all? Seriously, that's cap. I knew they was lying. Like, hold on, what are you talking about? He ain't got no mic. All y'all mics is running through. Only way for that to happen is to have him getting one goddamn audio feed coming in the camera recording and sending it out. This ain't his mic.
All right, Ms. Persfield, can you get IT to get on that issue, please? She's watching on the Zoom, I assume. Maybe I should text her too or email her too.
Camera mics don't even, ain't no mic that can capture them like this.
Give me just a second.
If he had the mic, we wouldn't have audio problems. They super capping.
So you're attached to what, the Zoom?
Look, she dumb as a bitch. She still don't understand.
I don't know what feed the court gets, but all right.
She still don't get it. It's this damn mixer board. And they dumbass ain't pressing the buttons on their mic. First off, they got 3 mics on their table. Why the fuck we got 3 mics on the table? First off, throw the ones on the floor we ain't using. First off, let's just go ahead and remove shit we not using. That's how we gonna get this popping. Yeah. Let's just go ahead and eliminate shit we ain't using off top. You feel me? Come on, bro. What we doing?
All right,
What we
Mr.
doing with 3
reaching
mics?
out to IT about it now.
First off. Nah, they lying though, y'all. That was they mics. They not turning off. And we hear them. They whispering away from the mic thinking that
All right,
we
do we
can't
want
hear 'em.
to
They
turn
blaming it
to
on the
where
goddamn
we left
cameraman.
off when we were last here, which was trying to sort out the nested hearsay and
Hell yeah, they left the mics on and blamed the cameraman, y'all. I promise y'all. I promise y'all. I promise you, y'all. They literally don't mute their mics and be whispering and shit amongst themselves. Somebody tell them, yo, they can hear you, meaning y'all need to mute your damn mic. They blame the cameraman.
one of the wiretap conversations.
Your Honor?
Yes.
Before we turn the page, could I just get some clarity? Because I'm confused. The state, I believe, indicated that they thought.
Nah, they can't get rid of him, y'all. I can prove that ain't his audio. Hell yeah. Yeah, I can prove it. Like, nah, he's getting that in one feed. That's a stereo output coming into his goddamn camera feed. That boy ain't got multiple inputs. They in control of that. Like, they can't, nah, he is not guilty. I'm an expert, y'all. That man not guilty.
The facts of the murder case involving Mr. Ryan were admissible in his trial, but the conviction wasn't. But then they started talking about limiting instructions.
Mm-hmm.
And I'm confused. Are they maintaining that the jury verdict from a separate jury is admissible against in this case? Or are they abandoning that and saying that they're going to get into the facts of this case?
Go ahead. We are saying, Your Honor, that the conviction itself is admissible and will be tendered, and that an instruction should be given that the certified that we intend to introduce that conviction should be considered against Mr. Ryan only.
Oh my.
But the facts of the murder and what happened should be considered as evidence if they choose to, believe it, against anyone currently on trial.
All right, so it sounds like you do intend to introduce a certified copy of the conviction?
Yes, Your
and
Honor.
that would be accompanied by a limiting instruction that is probably similar to the one I gave before, that that can only be considered against Mr. Ryan. Of course, he's charged with the RICO count, right?
He is.
Okay. And then they would present facts which they would hope to be able to establish not only that a murder occurred, but that the murder was part of the RICO conspiracy.
We would
And
introduce
that would be admissible against everybody charged with the RICO count.
we would, right, much like some of the unresolved murders that are in the indictment. We would be introducing the
Unresolved
evidence
murders.
that Mr. Ryan and Mr. Blaylock did it, and what connection we believe it has to YSL, and what they did to promote YSL before, during, and or after. So that evidence we believe is admissible against, well, we know it's admissible against everybody on
Look at
trial
Ryan.
now.
Okay.
All right, does that clarify?
Well, it clarified that we do not have an agreement, and I'm diametrically
Brian.
opposed to what the state is saying. Couple things. First of all, that verdict was not the verdict of the fact finders in this case, which
Sure.
we chose and are our jury, and that's Mr. Stillwell's jury.
All right.
Also, Your Honor, I'd like Your Honor to know that Mr. Ryan's case is currently on appeal. It's not a final judgment. It's on appeal.
All right.
And I guess I defer to Mr. Attorney Steele on this, because as I understood it, he was going through the law that would prevent them from presenting this as evidence. And it is evidence against us.
I'm sorry, when you say this, what do you mean?
The
Fact of
conviction.
conviction?
I'm not worried about the facts. I understand the facts, but the conviction, and they want to use it as proof of an overt act, which as an
Plans
element.
to Mr. Ryan
Well,
is what they're saying.
Well, no, they just said it against everyone as far as count 1 to RICO.
The facts that they're going to present, not the conviction.
Okay, well, I don't, as I understood
the
the case law, as Mr. Steele was reciting it, and maybe I'm wrong, but I thought we were at an understanding that they could, that's exactly what they could not do, is take a verdict from another jury and use it as substantive evidence against anyone in this case.
No, they can use it against, I think that they can use it against Mr. Ryan.
Well, they're using it against him for a RICO. This was not an admission by Mr. Ryan. This was not a plea of guilty.
He was found guilty. It's still a judgment of conviction.
Well, it's not a final
And
judgment. It's on appeal.
Pendency of appeal doesn't matter in terms of admissibility. It's right there in the statute.
Okay. Well, I understood the state said two different things, and so I was seeking clarity. I'm opposed to it. I'm stating my objection. I don't believe that if Mr. Ryan is charged with a RICO count along with my client, and they have the exact same element, and the jury's instructed that they need to find the commission of one of the overt acts, and they're told to consider the jury, the finding of a separate jury against Mr. Ryan. I don't know how they separate that. I don't know how a limiting instruction separates that and protects Mr. Stillwell's rights, and they wouldn't accept that same jury verdict against Mr. Stillwell and others for count 1. I don't think a limiting instruction would be sufficient. I think they need to prove that case.
I like that.
I think we have some case law that addresses that subject. I'd like to flesh it out given Mr. Sharp's objection, but I preliminarily point the court to United States versus Pelullo, Pelullo, 14 F 3rd, 881 at 888. It's a Third Circuit 1994 case. And it specifically speaks to prior convictions being routinely admitted into evidence at subsequent RICO trials as an ordinary piece of evidence. A judgment is subject to evaluation by the
Slow down a little bit.
Oh, I'm sorry.
A judgment what?
As a judgment, I'm sorry, as an ordinary piece of evidence, a judgment is subject to evaluation by the fact finder who can accept or reject such evidence as it deems appropriate. Also, United States versus Tocco, Tocco, 200 F 3rd, 401, in site 417 to 418. It's a Sixth Circuit 2000 case, finding the district court's admission of evidence of a co-defendant's prior conviction permissible to establish RICO predicate. Here it says because the evidence was not used as collateral estoppel, but again, these are cases that I would need to flesh out. These are just preliminary cases for the court's consideration, given the argument that I'm hearing Mr. Sharp make right now, that we would point to as a starting point.
All right. Well, we're going to have to get that sorted out fairly quickly if we think that within the next 2 weeks we're going to get to this.
Yes.
Or so, 2 weeks or so. Okay. So, Mr. Shar, are you clear at least on what the state's position is?
Now,
Okay.
thank you.
Tap the like button.
All right, we ready to turn to that Garlington wiretap?
I'm here.
Oh, yeah, I'm not deciding that issue right now. We'll come back to that.
And they went on break. And they're back.
Okay, and can you remind me, did the state decide on Mr. Ryan?
All right, we skipped the break, y'all. Let's rock. I'm in here. Tap the like button. Good morning. My internet was a little bit wonky, but I'm here.
Maybe we should turn to the evidence that's going to come in
What the volume like?
On Mr. Ryan's, on that'll happen before the wiretap evidence.
Yes, Ryan, I thought, are you talking about the email that Miss D. Williams sent?
I don't know.
Because
Did she send one recently?
I thought Ms. Abbasi and I, that was what we talked about a few moments ago. You said the two of you need to get together by the end of next week to go through those items so that we wouldn't have to use the court's time to do that.
So I guess it was, yes, Ms. DeWilliams' email from, well, it was a long time ago, about all of the exhibits.
Yes, Your Honor, and
Okay,
I'll
so
get
y'all
with
will
Ms.
get
Abbasi
together on that.
Yes, to discuss the time.
Okay, and can you remind me, did the state decide that y'all can, I guess, concede that Mr. Ryan's statement to police is inadmissible, or no?
Yes, we can use that.
Okay, all right. I thought y'all had conceded that, but I hadn't written it down on this. So. Let me put that in the issues that have been dealt with folder.
Salute to all y'all, man. Good morning. Only the real. What up? They're a little bit dry, y'all, but it's interesting.
The what?
One of the matters that were addressed in an email by Mr. Ryan's counsel was the Harold Bussey stabbing. I believe Mr. Abbasi or Mr. Williams moved in limine regarding excluding the evidence that Mr. Bussey was stabbed. Our argument about it being intrinsic, the court last said, or gave Mr. Abbasi an opportunity to give case law stating that things that were used after the fact, Mr. Abbasi can correct me where I'm wrong, but acts that occurred after indictment could not be presented. And I think in her brief, she indicated that, I don't want to speak for her, but I think she indicated that she found no case law in support of that position. So we're prepared to argue that. I'll let her speak.
We submitted a brief and went through each of the possible admissible purposes. And as far as completing the story, something which happened after the indictment is all in there. However, something which after indictment certainly could be part and parcel and inextricably intertwined in the same facts and circumstances, but that's not the case. So the brief does put out in there that the intrinsic facts the state is seeking to admit does not meet any of the criteria or exceptions, whatever you'd like to qualify it as, for those acts to be admitted. I don't know if the state is planning to respond. I did submit that several weeks ago. Right, and I read it and I marked on it, and now all I need to do is find it. I need somebody to keep me organized. Does the state have a response?
We do. And
did y'all file a response?
No, we made an argument that essentially is the same one we're going to make today, but based on what they've put forth, we'll respond specifically to the arguments that are asserted, put forth in Ms. Abbasi's brief. I think we presented case law, and I think that the court saw that case law. I won't speak for the court, but I believe the court saw and was satisfied that the case law does say that acts occurring after indictment are not precluded as evidence of the conspiracy.
Right. No, agreed. But it's two separate issues.
Right.
I mean, if it's going to be, they're not precluded just because they're post-indictment. But if they're going to be admitted as intrinsic evidence, then they have to fall within one of the things that makes them intrinsic evidence, that it's the same series of transactions, it's necessary to complete the story, or it's inextricably intertwined with the evidence about the charged offenses. So what are y'all contending that it is?
All of it. So inasmuch as the arguments that are put forth in Ms. Abbasi's brief seems to focus specifically on
I don't think there is a focus. I've never heard them say which theory they're proceeding under.
right. Yeah,
You're saying it's not any of them.
Correct. I've never heard them say which of those three is specifically are.
So, Your Honor, I'll just tell Ms. Abbasi in the court right now. It is intrinsic to count one. Additionally, the conspiracy that it also is a part of is the YSL gang itself and the conspiracy that the gang itself makes up. I think we already presented some of the facts of the case to the court regarding the in concert action by five YSL members and 2 others stabbing one person in defense of Mr. Ryan. And I know that the court has already read the indictment that describes, as the state alleges, the conspiracy itself being preserving, protecting, and enhancing the reputation, power, etc. of the enterprise through acts that include assault and threats of violence. And of course, I'm not reading the entire indictment, but in this particular case, it falls squarely under a number of actions that are intended to sort of circle the wagons around YSL members, show that they will stand up for each other and that they will commit violence on persons who they perceive as threats to members of YSL. Mr. Ryan, after he was indicted, there were several, at least one YSL member that we have listed as an overt act who makes assertions about Mr. Ryan and his murder charge and subsequent, I think, conviction. And there are people who perform acts during the course of his trial. At least one person that we believe were intended to intimidate a witness who was actually on the stand at the time. There are, by way of examples or analogies of other similar acts that are committed on behalf of YSL to show their solidarity. For instance, when Mr. Garlington is jumped, other members of YSL immediately jump in. We have evidence that when Mr. Copeland is jumped, at least one person in the courtroom now jumped, just jumped in just because. When it's one of them, they're going to come to their defense. The act itself was
Cap.
Hear all of this argument. It'd be great under 404B. I'm waiting to hear which of these 3 categories it falls into. We're talking about 2 different issues here.
Yeah.
And then 404.
Yeah, little baby white shark. Yeah. Little baby white shark over there. Little baby white shark. Yeah.
404B. It is intrinsic.
It could be both. I mean, I guess it would be intrinsic, but I mean, y'all haven't offered it as 404B, right? And you don't intend to,
Right.
even if I rule against you on the intrinsic.
Well, if the court ruled against us, it would be a different argument that we'd be prepared to make on a different day, because that's not something we're putting before this court
Okay.
today.
All right.
So the actions of Mr. Ryan and the other YSL members in concert in stabbing Mr. Bussey, when Ms. Abbasi asserts that they're not necessary to complete the story of the crime, this is our position, is that this conspiracy didn't stop at the jailhouse doors. It's ongoing. It's necessary that the jury sees that it is ongoing to show to them the truth and the whole truth that we believe that our evidence reflects, to show them the extent to which YSL members go in order to preserve and protect not only their name, their own.
Y'all ready? So she not going to tell how they had to hide multiple YSL members in the back of the jail and how other co-defendants know about this and they don't do nothing. So how much really are they a threat? Woody ain't get no help when he got jumped at that club, y'all. Pay attention. YSL was in there. They ain't defend that boy in that club. That boy say he got jumped on and had to basically run up out of there. These boys getting beat on, bro. She lying talking about they be retaliating. Nah, bro. They be in survival mode. They is not no dangerous gang that's a threat to other people, bro, or they wouldn't be getting attacked like this or being in the back of the goddamn crazy part of the jail. That ain't what happened to you if you the aggressors, y'all. That's what happened to you, yo. If something gonna happen to you if we put you in certain spots. So she capping right now, straight like that.
But their reputation, Mr. Ryan, Mr. Blaylock, Mr. Eppinger, Mr. Myrick, and Mr. McMullen are seen in the photo that I don't know that the court needs to see it, but if it does, we can present it on Zoom camera to show the concerted action on their part in stabbing Mr. Bussey. This particular screen grab of the video doesn't have 5 knives in the air like one of them does. This was just them all holding him down. And for the purposes of just this here right now, we'll just call it State's Exhibit 465, RR for rebellious crime.
All right.
Your Honor, I guess I'm kind of more confused now because I think the state's purpose is they want to show that it's ongoing. So I don't know how they're using it to complete the story of the crime if their version is that it's not complete and it's ongoing. I don't see how those two square. It's not an element that the jury has to find. The gang is continuing. The only thing they need to prove is that by the date of indictment, this happened. It really doesn't matter as far as what the jury needs to know for the state to meet the required elements. It doesn't matter whether the gang is continuing.
All right, but the state can prove if it chooses
They sure can.
that it's an ongoing conspiracy.
Sure, but that doesn't make
What?
it necessary to complete the crime.
Well, necessary to complete the story of the crime, and I guess the story of the crime is
Ongoing and continuous conspiracy that is YSL, its enterprise, and members committing these particular acts and crimes for the purposes listed in the indictment under the definition of the conspiracy itself. And this act is not something that is obviously relevant to the issue of whether or not the defendants are or are not guilty of count 1 in terms of what we're alleging that they conspired to do. It certainly would be an overt act under the definition of overt act.
Goon
of
salute.
count 1. So go to prove count 1 as to each of the defendants. It's therefore relevant, highly relevant as to that particular issue. It's presumptively, of course, the court is a gatekeeper, but under 402, because of its relevance, is presumptively admissible. Under 403, Your Honor, there's nothing about it that is so substantially more prejudicial than probative, given its highly probative nature. You can have the Zoom up here. Then we put it up in presumptive. Considering it's coming, we're not in yet.
all right. Ms. Abassi, can you remind me? And I don't know which one of y'all cited Murphy. Was that you, Ms. Abassi? The part about integral and natural part of the witness's accounts of the circumstances surrounding the offenses. Which factor did that go to?
I specifically did not cite that case. I did discuss whether it would be integral and natural part of what happened. I didn't cite the Murphy.
Okay, well, maybe it was just one I.
I did want to touch on one thing the state said because I think we're getting into dangerous territory. The state said that this act in and of itself could constitute an overt act to support the verdict. Well, now we're talking about trying to
Hell yeah, go on.
charges against the defendant based on something not in the act.
Well, and you know that's an issue that I've got written down here as something that y'all owe me law on. Whether an overt act not listed could be the sole basis for a conviction.
Right, we do, and I think at some
Still
point,
waiting on that law.
Actually, I think at some point, and I might be wrong about this, but a contrary position was presented, and whatever case was cited did not support that position, and we have affirmative case law that we present in the form of a brief to the court.
All right, well, you go ahead and get that filed. Can you get it filed? When can you get it filed? By Monday? By Friday? All right, by Monday.
Your Honor, I can get to the court kind of the contrary case law. In the appellate, I know it sounds doesn't sound to square up, but it leads to an inconsistent verdict that perhaps some of the jurors found the defendants guilty based on the acts which were in indictment, and perhaps some of them found the defendants guilty on acts which were in indictment.
I mean, it's going to be real fun when we get to the verdict form. I think that we're going to have to get really specific about what they're finding, because I don't think it can be that 6 found one and 3 found another and 2 found a third.
I think that this precise situation came up in Cotman, and I could be very, very wrong. I read it, I glanced over it briefly, but I think that the court found that given that the court instructed the jurors that their verdict had to be unanimous, that it did not present a reversible issue, the defense argued, or the appellants had argued, that there was no way to tell whether or not they all agreed on the same overt act. But in giving the court the brief that we intend to present, I think we can address that as well. I think that that part is easily
All right,
addressed.
so that'll be two different issues. Can an overt act that's not listed in the indictment be the basis, the sole basis to support the conviction? But then there's also, does the jury need to find unanimously this overt act, specific overt acts? Do they need to delineate which overt acts they are unanimously finding exist to each defendant?
Right. And I think that as it relates to our previous discussion that the court said we would address a little bit later, whether we number them or whatever, just off the top of my head, I think that them listing an act that they found unanimously had been committed as to the defendants, I think would suffice.
Okay. Well, if we all agree on that, then we don't need a brief on that.
Okay. So, I'm sorry, Mr. Boston.
I don't know if we made it before or part.
No, we hadn't. We sort of got sidetracked. But all right. So we all agree that the jury is going to need to delineate. We unanimously find this overt act exists as to each defendant, right? I mean, we're going to break each defendant's counts out separately, and
I think that.
I agree, but
and to make certain that we present clearly to the court, we do believe, yes, that the jurors have to make a unanimous decision as to each defendant and as to their overt acts. But as to whether the overt act it finds as the one unanimously has to deal with the others.
I know. I mean, it can be wholly entirely separate as to each defendant. It needs to be a separate determination as to each defendant. Yeah. But for each individual defendant, does the state agree that the jury has to unanimously find two overt acts, one of which needs to happen within the statute of limitations?
We agree they have to at least find one that happen within the statute of limitations.
And it needs to be unanimous that, let's say they all find overt act 66, whatever that is.
I believe it's safest that they find unanimously.
Okay. All right, and then I don't need law on that because we'll just do that the safe way, whether it needs to happen that way or not. Okay, so back to, so I still will need by Monday whether an overt act not listed can be the sole basis for the conviction. And now we will go back to what we were talking about, which is this
the intrinsic
allegedly intrinsic act.
So Mr. Ryan, given Mr. Blaylock is not here, but I will, since they were the two that were charged with the murder in one of the overt acts listed on the indictment, Your Honor, Mr. Ryan and Mr. Blaylock have entered a plea of not guilty to count one. And they are obviously charged with committing an act of violence against a person as alleged in the indictment in a manner that furthered the interest of the enterprise in the conspiracy. The three, I guess, points that Ms. Abbasi referenced in her brief.
How did it further?
Were that the intrinsic or the act needed to arise out of the same transaction or series of transactions as the charge.
How is she just allowed to assume things furthered the gang without proving it, y'all? How can you just say something furthered the gang? That means she can add in every crime, bro. Jaywalking, petty theft, everything, bro. If it furthered the gang, because she's not being obligated to prove that it furthered the gang. How did this further the gang? We got multiple witnesses that came up and said that their crimes did not have nothing to do with the gang. Nobody told them to do it, and we can't see no proceeds from it. We can't even make a reason for the gang not being able to survive without the crime being done. So what furtherance is she talking about that allows her to just throw these crimes underneath of the umbrella of RICO like this? And I'm very interested in seeing why the law even permits them to not be accountable for proving furtherance before throwing a crime into RICO. Before the judge will accept a RICO with overt acts, and crimes of furtherance, they should be obligated to prove the furtherance before we even get here, because otherwise we could lock everybody up.
Offenses necessary to complete the story of the crime, or is inextricably intertwined with the evidence regarding the uncharged offenses, and there is an or, so it does not have to be all three of them. So given that the jury will hear evidence of Mr. Ryan's and Mr. Blaylock's concerted efforts as they related to Mr. Holmes, they will hear evidence of Mr. Ryan's actions after the murder of Mr. Holmes. They'll hear evidence about their connections to YSL, but the fact that you have other members of YSL acting on behalf of Mr. Ryan to support him in a violent way against another person whom they allege only.
They could be fans of Lil Rod himself. Similar to if a person I liked, I was a fan of, hence, let's use my favorite sports player. Let's say Shaquille O'Neal locked up in a clink with me. I rock with him, right? He a part of the Lakers or the Celtics or the Orlando Magic, depending on where he was at, right? Don't matter. But he a part of a team. I ain't on his team. I rock with him, right? Somebody play with him while we in his clink, I'm dusting him. We in the gang? Or am I on the Lakers? Or does that mean I'm in the NBA? Because I dusted some guys on his behalf. Stop playing, lady.
Mess with Mr. Ryan's commissary. Stabbing him just because he messed with Mr. Ryan's commissary.
Stop playing. Don't play with Shaq food. I'm dusting you over here. I'm with everything. Yeah, anybody play with his peanut butter and jelly, his crackers. I don't care if you touch one of his socks, cuz I'm dusting you over here. On Jerry West and them. Play over here.
Show the extent to which members of YSL go to assert their dominance, even in a situation like the Rice Street.
Do that mean that I'm a gang member or Shaq a gang member? Tell me, what does that prove on us crossing and having some illegal? Does that prove anything, or is that just clearly I just ain't like people was playing with my man? Right? Hold on. Let me change it. Let's say we was a gang. So we saying gangs don't defend civilians? That's what we saying? Shorty don't know what she talking about. Shorty don't know what she talking about, bro. Real rap, this is a reach to say that because we defended someone in the prison system, they're a gang. Cap. If we hyenas and you playing in a field that you don't belong in and we don't like what you doing, we own you. It ain't got nothing to do with Holmes for real. To be honest.
Jail. And to protect one another, to show that you don't mess with one of our own.
Or could it be the fact that you just shouldn't be messing with young dudes in the prison system because you taking advantage of them, and we not having that because you just wasn't over here doing that to us? So why you playing with him? So now you got to play with us too. Lady, you don't know what you talking about. You really trying to ship that boy up the river. You don't know what you talking about.
The argument obviously can be made by anyone. Yeah, this is not really what it's all about. But in terms of what the state is required to prove beyond a reasonable doubt to the jury, we alone bear that burden, given that it's evidence that there is violence committed on behalf of a member of YSL by members of YSL. We believe that it shows that the gang itself conducts itself in a particular way, and that
Hey, yo, if this the case, then you got to lock up everybody in every race in the federal prison system. Because technically races defend other races. Defend their own race by obligation, not a gang, just a security measure. So if anybody wants security themselves in case something go get radical from another team, you want somebody around to look out for you like you gonna do. So it automatically turns into one big group, really, right? Yeah. But hold up. Is it a RICO? Is they gang? No. They not gang. They not gang. That's purely segregation. Seriously, bro, like that, us defending somebody in this prison system do not mean they gang, bro. I'm telling y'all.
Okay, let's stop interrupting, though. I mean, I assume she'll get to it at some point.
That the gang itself conducts itself in a particular way. And in Johnson versus State, a Supreme Court of Georgia case, whose site is 312 Georgia 481, decided September 21st, 2021, at Penn site 491. The court said that, of course, evidence is admissible as intrinsic when those three elements that we just mentioned exist. And they went on to expound and say, in applying this test, we have explained the evidence pertaining to the chain of events, explaining the context, motive, and setup of the crime is properly admitted.
I'd pay somebody $1,000 to file a Rule 22 and go in that courtroom and get up on that stand and say, I was just trying to get a Rule 22 so Eban Films could stream in court. Eban Films on YouTube. Now, the whole plot is not to actually get the Rule 22. And no, we're not trying to get a camera. We just want the commercial.
If it is linked in time and circumstances with the charged crime, the defendants, the YSL members, are all together. They are the ones that are included in or that participated in the stabbing of Mr. Bussey, are all housed together at the Rice Street Jail. The time frame is shortly after they're put together in that situation, all together in the Rice Street Jail.
Oh, you gotta say free
in
thug.
this particular case.
Make it 5,000. Come on, cuz I don't make that much goddamn money. Hey, bro. Hey, bro. Bro, I ain't got that.
Circumstances that are not exactly the same as this,
five
we believe
racks.
are analogous in many ways. In Johnson, of course, the
I can get
appellant was
somebody
charged
top
with
knocked off
participating
for 5 racks.
in criminal street gang activity, and the state's theory was that he was involved in the gambling house shootings with Blood Gang affiliate Porter and several unidentified assailants in another restaurant shooting. The evidence related, as the court found, to the Boulevard Place shootings added significant weight to that theory because the evidence was linked in time and circumstances with the charged crimes, and one victim was a member of a violent gang. We are not alleging that it is on all fours with our particular case, but
hold up, though. Technically, if you pull that first move off, we might be able to combo pack it and get you 5 racks. If you try and go for that, we might be able to, but that play ain't. I don't think that it's that hard to pull the move off either, first off. I don't think it's that hard to get it done. Like, literally, you filling the paperwork out, and then what it look like is they going to give you a time period to pull up on camera and talk. I don't know why they doing it, but let's press the line.
To the extent that the Johnson court found it pertinent to say that the intrinsic act, or the act that the state alleged was intrinsic, added significant weight to the state's theory for these reasons, we believe that that is analogous to our case as well, with 5 people, 7 total, acting in the same, overacting with an extreme amount of violence on behalf of one person whose connection, we believe, with the 5 YSL members is just they are all YSL members and they are acting protectively towards him. We have, we believe that incident adds significant weight to our theory of the willingness of YSL members to participate in that enterprise in a manner involving violence to protect.
Ms. Love, can I ask you a question? Was Rod the youngest out of the people you're saying that was in this melee? And was he the smallest? So could it be just sheerly a fact of a group of bigger guys defending the smaller guy?
The dominance.
Love, could you tell me how men are housed in this jail/prison system you're talking about in reference to their neighborhoods or friendships? Not necessarily a gang. Like, are they housed by where they come from? Like, say I'm not in a gang, but I'm from that area. Do I get housed with the guys I grew up with, but I'm not in the gang? I'm just asking.
And the members of the enterprise and the gang itself. So
there she go calling it an enterprise. We ain't seen no. Yo, what the hell is the definition? Hold up. What's the definition of an enterprise? They keep calling YSL an enterprise, bro. I do not feel like it fits the description of an enterprise. I do not. No. Not only is it not a RICO, the word enterprise sounds like a super reach. Enterprise what?
the court found that even though the state didn't charge appellant in connection with the shooting, evidence of the incident was relevant to disputed issues in this case. So as Mr. Ryan has entered a plea of not guilty to count one, conspiring to violate the Racketeer Influenced and Corrupt Organizations Act by participating in.
How long does a business have to be unsuccessful before it's not considered to be ever a business? Seriously, y'all. Like, if you're negative the entire time your business open, was that a business or was you giving goddamn money away? What are we doing? Real rap. Like, enterprise.
YSL through these acts or conspiring to participate in them, then evidence of the involvement of Mr. Blaylock, Mr. Ryan, Mr. Eppinger, Mr. McMullen, and Mr. Myrick, all of whom are also charged in this indictment with a conspiracy. Evidence of Eppinger being charged with the shooting of an officer. Evidence that Ryan, who was promoting YSL while in prison when Eppinger got a bond for shooting at the police, that Blaylock is a co-defendant on the murder of Mr. Holmes, which is an overt act here. And
if we open 10 businesses 2 years apart and never report gang, they all flopped, will we be investigated?
And that Demise McMullen is a named co-defendant on the 2015 murder in the same indictment, shows how intertwined these people, this type of action, and this gang itself is with one another. They're all inextricably intertwined with the evidence regarding the uncharged offense, which is the stabbing of Mr. Bussey. So we believe that it satisfies the requirement of it satisfies the requirements of being an intrinsic act.
Okay, which of the three?
The third one we believe is the strongest in that it's inextricably intertwined with the evidence regarding the uncharged offense.
No, it's the charge. It should read the charged offense, right? I mean, it needs to be inextricable, right?
Yes, that the case is citing it wrong. Yes, thank you. And that being count one, the conspiracy.
So, how is it? And you think it's also necessary to complete the story of the crime, right? You're not asserting that's the same series of transactions as the charged offense, are you?
When the court says the same series of transactions, we believe that it's an overt act, in as much as it could be considered an overt act to promote, to support the gang. So in as much as it is or can be considered an overt act for count one, and that it is gang activity, which it is.
All right,
And
I'm not quite sure where I got this language, but I jotted down, and I think this is kind of the definition of inextricably, or an explanation of inextricably intertwined with the evidence regarding the charged offense, is that it is an integral and natural part of a witness's accounts of the circumstances surrounding the offenses in the indictment. Anybody
so
know if that's as to that mean that's the explanation for what it means to be inextricably intertwined?
I think that came from Murphy.
That's Williams versus State, 302 Georgia 474. Cited in the brief.
What year that was, Williams?
2017, it's cited to on the 11th circuit.
Okay, and I think that language is also in a Court of Appeals case in 2020.
Okay, so, but I mean, if
They in here learning law.
that's what it means for it to be inextricably intertwined.
Yo, she ain't no regular public defender, I don't think, y'all. So listen, you got 3 options on public defenders when you getting a free lawyer, allegedly. 2 of them is real lawyers. Yeah, they ain't just, well, I hate to say real like that. They ain't just run-of-the-mill public defenders. They actually from a side practice or something, and they done been contracted by the state. So maybe she one of them, y'all, because she do not look like she's just, but I think our impression of public defenders is off a little bit too. They ain't all shabby. Now, they just ain't established yet, from what I understand. They putting in their free work so they can get their hours up, from what I understand, or something. So a lot of them I don't think you just stuck at being a public defender. You understand what I'm saying? So the Sharks guy come through there too. I think you might be able to skip it, but I think it looked good on your resume. You know what I mean? Real rap. So she easily might not be a slouch.
With the evidence regarding the charged offense, how is that an integral and natural part of a witness's accounts of the circumstances surrounding the
She is definitely more aggressive than Williams.
indicted offense?
So if the indicted offense is the conspiracy itself, and our witnesses talk about what they've observed and we have evidence of heard to further that conspiracy.
So would this be a witness who's being presented regardless, or is this a witness as to, I mean, obviously if...
Well, just to let y'all know, Jimenez was a C3. Yeah, Mark, he was a C3 lawyer. And he was also a defense lawyer before and a DA. You feel me? So, I mean, that's Indian Spanish, yo, that was on the joint. Remember? Polo was his client. And he also was the DA when DK was telling. You know, with the ponytail, with the plaid suits. Essentially, he was free.
They're just coming in to testify about what happened in the jail. That wouldn't be the same thing, because I would have already made the determination, oh yeah, you can talk about this. Is there going to be any witness who there's no way they can give their account of how it is that any of these defendants is guilty of RICO without telling the jury about the stabbing?
No, we're not saying that. We're not saying that at all.
So then
No.
it's not inextricably intertwined.
But it does, it's an uncharged offense that arises out of the same transaction or series of transactions as the charged offense of count one. And the series of transactions is the acts of violence that have been described. One of the overt acts, as I said, is the murder of Mr. Holmes by Mr. Blaylock and Mr. Ryan, as we've alleged in the indictment.
And then how does this arise out of that transaction?
The series of transactions, one of them is that the series of transactions is the set of actions that occur before, during, and after that murder itself. The series of transactions are the overt acts that help promote the purposes of the conspiracy. You have Mooney Lee posting, I'm sorry, we made you a thug, so early little thug. You have people who are acting within YSL in support of Mr. Ryan. Mr. Ryan essentially talking about staying true to YSL regardless of his circumstances after the murder.
All right, and are all of those overt acts?
Yes, those that I just
alleged?
named are, yes, alleged overt acts. So the series of transactions, we would argue, is not a simple matter as on Monday, July 3rd, he got up, went to the store, bought a gun, and did that. It's
All
more
right, remind me
broad.
when the jail stabbing occurred.
It was February the, what day? February 20.
Of
February the 1st.
So you don't do your police work on the streets. These dudes was getting hunted. You allowed them to be hunted. You told them to defend themselves. You didn't prevent it. You locked them up. You put them in jail. They get hunted as well. You lock them up.
January the 1st of 31st of 2023.
January 31st, 2023.
Yes.
And he'd been in prison, I guess, since 2019. When did they all get moved to the jail?
Mr. Ryan, I think, and Mr. Blade, those 5 co-defendants were, I'd have to look and see in Odyssey when they were transported, put together.
Roughly.
Thank
Okay.
you.
Approximately.
Okay, approximate is fine.
And also, Your Honor, under 104, and I get that we are still hashing out whether or not it's intrinsic. Once the court makes that determination, and we believe that it's clearly intrinsic regarding the conspiracy and the gang itself, there's another argument in support of its admission and use at trial that we make under one of the other rules of evidence, but not until we finish this part.
Well, I'm curious now as to what that would be.
Just that under rule. And I'm also curious about how the court will see or not see this position that I'm offering. But under 24-104, which specifically deals with the court handling the admissibility of evidence and the court's determination of it. 24-104E expressly says that this code section shall not limit the right of a party to introduce before the jury evidence relevant to weight or credibility. And so to the extent that part of our evidence, and it doesn't, speak to the weight of the evidence of the murder, but we believe that it substantiates and it corroborates our assertion via the overt acts that we have listed, that there is this conspiracy and that there are efforts that are continually made by members of YSL to support and protect one another and to advance the dominance and notoriety of the gang through acts of violence and assault.
All right. Well, I do not think 104 has any bearing whatsoever on whether y'all can admit it before the jury.
Okay. See, I know.
Okay. So that takes care of that one. All right. Do you have any, can you look, if you haven't yet, for any case law that deals with kind of a similar set of facts? Mr. Adams has shaking his head yes.
Since
you
he
can
is.
look for that.
Oh, that is, we definitely can. I was just trying to make sure that I fully got what the court was saying. So in saying the same set of facts, is the court speaking that
Similar
specific
set of facts.
as to, somebody jumping somebody?
Well, I mean, yeah, ideally, if you could get that would be great. But no, it doesn't have to be that specific, but something that deals with gangs and or RICO, because what I hear you saying, or what I think I understand you to be saying, is that part of why this is intrinsic is because it's necessary to give a full story of how YSL is this ongoing criminal enterprise that uses violence to protect their members.
Right.
Am I understanding you correctly?
You are, and to assert its dominance. And in support of that, I also say that each of the members of YSL, Blaylock, Eppinger, McMullen, Ryan, and Fleetwood, had all, I believe all of them had been brought in from prison for YSL related offenses that they had been convicted of. Eppinger had been sentenced to prison off of a probation revocation for an armed robbery after he shot Officer Rogers. That was a YSL related incident. Mr. Fleetwood had been brought in from prison after shooting at Milton Howard, who at the time was driving YFN Lucci's vehicle with tinted windows. So the argument obviously could be made. He didn't know it was Mr. Howard. He knew it was an ops
Boo.
car. So all these people are all incarcerated because of YSL related offenses. And then you put them all in the same little area, and they are once more acting as one single bullet against somebody they believe is a threat. But I can and we will look for a case on all fours with this particular set of circumstances.
Okay. I mean, I honestly think the 403 argument is easier than whether this is intrinsic. But yeah, I'll go ahead and hear that because maybe that'll be dispositive of this issue.
So would Ms. Bassi, should I let her go first?
Boo.
The court want to hear from the state.
It's in the brief, so I'll let you begin.
Well, I mean,
They have the burden. I'll give you the.
all you really say in the brief is it doesn't meet 403. You don't really say why.
Well, it has to survive the balancing test.
Okay, well, that's pretty clear.
To exclude what is a standard cumulative open court, I think everything in here we're dealing with is scant and cumulative. There are, I don't want to get wrong, how many other acts in here the state can prove. These are necessary. I'm sorry. That in the 403 analysis, the court should determine the prosecutorial need, degree of similarity, and temporal remoteness.
Did she want to speak how they were allowed to get to Lucci? Like how there must have been a breach in security for them to be allowed around oppositions in a prison system that's supposed to keep oppositions securely away from each other? Could she speak on that?
There are 191 overt acts. I think by the time the jury has heard all of those, they will have heard quite a bit of evidence regarding how gangs operate. Examples.
Miss Love can't handle Lil White Shark by herself, y'all. Yes, sir. If it was just Miss Love against Lil White Shark, 1-on-1, Lil White Shark could beat Love, y'all.
Of criminal street gang activity already. Quite a bit. I'm sure by November there will be more. Don't think there's any prosecutorial need to be coming up with these things additionally. There is plenty. Your Honor is able to exclude evidence which is cumulative, which is of course prejudicial, and a waste of time. I think that's where we're getting to in this circumstance. Clearly, there was enough evidence for the grand jury to return an indictment.
Nah, she don't care about the money. That lady care about law. And her knowledge, she over-equipped with knowledge. You could tell. She not playing. When something ain't right with law, that lady not playing over there, bro. I'm telling you. That lady ain't playing. That lady ain't playing. That lady ain't playing.
Well,
Okay, for this.
that's a lot lower standard.
It is. But if even that lower standard, it was met there, then I don't see how it's suddenly.
Can't even hear.
Okay. Go ahead.
Judge, I've heard, and everyone I believe has heard a lot about the notion of the evidence being cumulative, as if there is a certain amount of evidence the state who bears this very high burden. I'm sure we'll hear told over and over again in closing arguments that the state should be allowed.
Listen, y'all. I ain't red team, right? No affiliation, no tattoos. I ain't none of that, right? Boom. If I get in that clink, because of the area I'm from, there might be a certain group that might be on, I might be on that side where they at. Now, look, the area where I'm from got multiple different groups. And because of the work I do, I know people in different groups. So technically, because these people might hop out and defend me in a certain situation in the clink, I'm gang members with them. That's cap. That's cap. And this is real life. This is real life. If I go over there It's going to be certain people that's going to say, yo, there ain't nothing. Nah, we keeping him. So what he with y'all? Yeah, he with us. Am I on a team? No. Straight like that. We go in the club. Somebody say something to me. This didn't happen in real life. Yo, what you want us to do? Nah, chill. Am I on a team? No. I'm not on a team. But they keeping me straight like that.
To present to meet that very high burden. And I don't believe that cumulative evidence means proof of a different kind to show or to prove the same act. Just because the state has 150 ways to prove that the defendants conspired to violate the Georgia RICO statute, and the state, in an effort to ensure that each of its victims are adequately represented and that the jury hears sufficient evidence to allow it to convict each of the defendants, doesn't mean that the state should be constrained to putting up one piece of evidence, one picture showing somebody throwing up a gang sign.
Can I ask you a question? How many of your overt acts, if any, are assaults or aggravated assaults that are designed to either protect alleged members of YSL or promote or continue the, I can't remember the word you said, but the dominance, assert the dominance of YSL?
As it relates to Mr. Ryan, or just in general?
In general, since the argument is this is done to protect members of YSL and
To assert their dominance.
assert the dominance of YSL.
Okay. Since an overt act does not have to be a crime, I'll just name them, of course. So number 9, where Defendant Williams asserts in one of his songs, YSL.
No, that is not what I mean. I don't mean saying you're going to do something. I mean actual assaults on people.
Oh, she on her ass. Let me give y'all another example real quick, y'all. Listen, I'm in the joint. I stumble across a dude that just happened to be on my tag. I know his little cousin on the street. I don't know him. We know a lot of the same people, right? Yo, a whole loony bin, right? He ain't even in there on no gang time. But yo won't show enough official Oz tip. You understand? Yeah, he with this jail shit, for real, full throttle. You understand? Bro, yo was not playing. You understand? Like, bro, on the strength I knew his little cousin, bro. Like, so, like, that's what I'm saying. Like, people be rocking out with people in these jail systems, bro. So her trying to say the dudes help Lil Rod, you feel me? Nah, bro, certain people just gravitate towards certain people. It ain't always gang. I might know your uncle. That mean you can't touch yo in this dorm right now. Straight off top. I know his uncle. I dare you touch him. Straight like that.
We have Mr. Holmes's death is alleged by the state to have been a murder of someone that they believe to have been a member of a rival gang.
All right. So I'm sorry. I mean, I guess maybe, so because it's a rival gang, that would be dominance.
Yes.
And that's overt act, what, 79 or 69?
And I can also even be more precise there as I look for that number 79 or 69. Mr. Drinks's murder is alleged to have been a direct retaliation for the death of 2 people who were associates.
Your Honor, I'm sorry. I'm just trying to
69.
determine what you're asking. Are you asking what the indictment alleges?
What is overt acts?
Well, the indictment, as I understand it, just broadly alleges that the overt acts are done to that for those purposes. The indictment broadly alleges several purposes and doesn't delineate which overt acts are designed to do what. So the answer, as far as I understand your question, would be all of them. They've alleged all of them.
I mean, I'm asking the state sort of what. I appreciate that position, but I think I'd mean it a little bit differently than that. And yeah, sure, they could end up saying every one of these does all of these things, but I'm kind of asking them to be focused on aggravated assaults, obviously, or worse, murder, that are for these very specific purposes.
So to answer your question about the number for that murder, it was Overt Act number 79.
All right.
Also, the act for 28 by Mr. McMullen.
Overt Act number
April
28.
April 28th.
Okay, yeah.
Yes, I'm looking at them in chronological order.
All right, that's fine.
The act by Mr. Garlington, Mr. Sledge, that act of shooting Miss.
Are we talking about things like rival gang type incidents?
My understanding of what the court said
I
is
just
what
want to know
acts
what the state's position is.
that were done to
Not playing.
acts of violence done to promote either the
Either
notoriety or to
protect
protect.
the members of YSL or to promote the dominance of YSL.
Okay.
Shorty is causing mad hiccups in Miss Love game plan for trying to explain this shit to this judge. If y'all pay attention, she forcing Love to actually have to explain. Every time she step up and question it, look how she on her ass, y'all. She literally watching her wording to a teeth right now. She causing Love some static right now, y'all. She causing Love some static right now.
So the shooting, we believe, by Mr. Winfrey of Lil Wayne's tour bus, which would have been a different one. It's encapsulated in 39 and 40. The shooting of Mr. Murphy.
Now I know why that yellow pad called a legal pad.
On April the 12th.
I ain't never copped because the shit was called a legal pad.
Do you have any other
Montgomery.
overt acts where members or alleged members of YSL are basically doing a beat down of anybody because somebody from YSL got threatened or attacked?
Up.
We have
Whoa.
other ones where they're shooting.
Whoa. Is the judge strategically chopping at her ass for pattern? Is the judge looking for Rico? You got any other version of the shit that you calling an overt act? Because if not, that's not a pattern. Is that what she going for? Whoa.
Other members. And
You
we
said
have-
no? That's not what she doing? She sound like she checking for pattern just now.
Where they, for instance, Mr. Kendrick and Mr. Arnold go out and plan to shoot somebody because someone jumped on Mr. Arnold in a club.
And that's an overt act?
It is.
Okay.
Where also I think we have.
You think?
Yeah. And they are, I think, acts 41 through 45 is the murder.
Okay.
This is the murder
All
on
right.
the 28th or the aggravated assault that I talked about.
Okay.
Judge, check it though. They not real beat down.
All right,
She
now
bluffing.
y'all see if you can find me some more on point factually case law, please.
Okay.
And
Is
I
the
know
court,
y'all want a decision, but we're going to come back to it yet again.
and Your Honor, in terms of the number of acts that we've
Judge, I promise you, it ain't no more ass whoopings. She capping. They wasn't whooping ass. They ain't whooping nobody ass. Your Honor, they ain't got it. She bluffing.
enumerated in here. Does the court want specifics or just the number?
Yeah, that's right. I mean, you've told me enough. That's fine.
Okay.
I mean, it's not like that's critical to my determination.
Okay.
I just was wondering if there were so many that this was something that would really be cumulative, but it doesn't sound like you really have anything that similar to this.
And as well, Judge, in terms of judging whether or not something is substantially more prejudicial than probative, it would have to, I think I've said it before, it would need to tend to sway the jury to convict the defendants on a ground different than something that has been alleged in the indictment. And given the allegations that we've made, we don't believe that this comes near that category of cases or circumstances. As well, Judge, I know the court is aware, but just to put it out there, 403 is all of these rules of evidence are rules that favor admission. And so 403 is not to be used as been alleged to limit the state's ability to present evidence so much as it is a permissive statute that under very rare circumstances should be used to exclude relevant evidence. And the mere fact that a defendant may feel that, oh, the state has too much evidence against me is not one of those circumstances that the courts have recognized.
So actually do speak about prosecutorial need.
To the extent that the argument throughout is that YSL is a gang, that everything that has been, that YSL is a music label, that everything anybody does is just their own independent act that has nothing to do with YSL from day one.
Why you, whoa. Why you try to put a little vernacular on it to sell it more? All right, keep going, though. That's cheesy.
One, from openings throughout up to even now, the assertion by every defendant is, and even the witnesses, I did it for myself, by myself. Every step of the way, the state is having to rebut that assertion that.
Is it the truth, though? So you not willing to accept that you reaching by saying this some type of enterprise. And these petty-ass crimes that they got caught off that lack furtherance might not be connected to a gang. You just really don't want to accept that. We on goddamn 127 or something. And you really been holding up us all up and you going to sit up here and get cocky with it and act like you ain't capping? Like you got a trash-ass case that you been dragging us through the mud with? You really going to get up here boldly like you really got something, shorty? You ought to be ashamed of yourself, especially with the length of your hair. Sit your dusty ass down.
This is just me. I'm a criminal, but they aren't. Okay. So to the extent that there's no one here willing to stipulate that
this shit ain't funny, don't let me see more than 2 of your teeth at a time.
Crimes are being committed by them and others with whom they've conspired to promote or on behalf of YSL, the state has a very strong need to present evidence of one, concerted efforts to commit the acts that we've alleged, to show the conspiracy between the defendants, and to show the purpose behind their concerted efforts.
All right. Thank you.
No, if you'll take you and that goddamn health drink and that goddamn red lawyer book and sit your ass in the back somewhere. Wasted our time and get cocky after all these goddamn months. Come up here with this frivolous ass argument you got.
Case law on prosecutorial need. See what I have to answer Your Honor's question. And that was
You know, go in the back and wash the back of your heels. Been scrubbing your heels with Dawn dish detergent, and you come in here acting like you high sedity, you better than somebody or something. You added a little bit of sheen in your hair, and now you brand new. All right.
gang expert testimony the jury has already heard from about how a crime can further a gang or be part of a gang. I think the need to that point for on this principle, that there is no need. They've heard about it in depth. They will continue to hear about it. And as I said, I'm trying to look and see if I can get any more case law to specify if we have a level or a test for what need is.
All right. Thank you. Well, if you find something else, feel free to just, shoot it over in an email that you share with everybody. That'll be fine. It doesn't need to, if you want to file it as a brief, that's also fine. But
what I've got just looking at some case notes here.
Slide your mic up, baby.
Prosecutorial need to induce a prior rape-related incident to show. Yes, I'm sorry. Explaining that the prosecutorial need to introduce a prior rape-related incident to show the defendant's intent was high because there was little other evidence supporting the charge of aggravated assault with intent to rape. That is a case, Kirby versus State, 304, Georgia, at 483. And I haven't read that case. I'm looking at it. It is cited within Jackson versus State, 306, Georgia, 69 from 2019.
all right.
If we get clarification, is that a 404B case or
They really this low?
14 case or 413 case, Kirby?
This is addressing a 403 issue.
Is it in the context of a 404B?
I don't know, but it's not a different analysis under
Yo,
403.
why they mic so low out there?
As I said, I've not read the full case.
Yeah, it's fine. I understand the concept.
This is crazy.
Okay, let's set that aside and move on to something else. So there was I've got some notes of things we were going to circle back to. And one of them was a video of somebody smoking pot.
Oh, shit. Bro. Anybody say that phrase is out of context. Smoking pot, you going to jail if the judge say that shit like that, bro. Bro.
Wearing a chain.
Whoa. Yeah, you going to jail. You going to jail. You do not want... Yo, that is so far. She lives so far from where rappers and shit is at. She holler, someone smoking pot and wearing a chain. Bro, I'm not coming back to this town if they talk like that. I swear to God. I'm out of here. I don't even want to drive. We could catch an Uber out this bitch, bro. I'm dirty. I'm getting in a cab. Fuck this.
Saying some things. BB maybe, and Eppinger. Something about robbing Smith. What was that about?
Sound like she gonna send niggas to jail forever.
That Mr. Shard, we were supposed to narrow down what videos we were going to admit. I sent that over a few weeks ago, which ones we intended to use. I'm not sure we've been able just to talk about it in light of the last couple of weeks.
Okay, well, these are notes from back when we had that non-jury week.
Yeah, I don't like the way she said that, bro.
Yes, it was the week of August 19th, Your Honor.
Yeah, that's what I thought.
I had flashbacks or something, y'all, to when I got locked up. To be honest, I don't remember what the judge looked like that I had, but she technically, generally, is the same, style of judge as this one, right? And I think I might have just had a flashback because I did time for some grass thinking I wasn't. Shorty, hit me with the same. Maybe she said the same things.
So and I guess that was with regard to counts 27 through 29, maybe, is I think what I wrote down.
Yes, Your Honor.
So is that a video y'all intend to utilize?
We sent over, there are portions of that video we intended to utilize. I believe that the portion that was at issue is not a portion that we need to publish to the jury, Your Honor.
You're not going to show the jury
portions of the video. So the video is maybe approximately 5 to 7 minutes, and there's a portion, and I want to pull up my notes to see what I actually sent over to defense counsel as to what timestamps we intend to use, but a portion of it is relevant because it shows Mr. Eppinger and Mr. BB, the two people alleged to have committed this armed robbery, on the phone, and a portion of that video, Mr. Eppinger appears in I think it's like an Instagram picture, an Instagram video, and BB shows him the chain, but there's another portion of the video in which Mr. BB is pointing a weapon at the camera. So there's just relevant portions, and we just haven't had the opportunity to discuss it, Your Honor. And I can let defense counsel know what date I sent over what the state intends to show.
What this got to do with that?
All right. Does defense counsel still object to whatever portions those were?
Yes, I'll re-forward the email.
I mean, I think they reaching by throwing these overt acts in, y'all. Like, I can't see the
23rd at about 1:55 p.m.
I can't see the chain of command. This ain't got nothing to do with the state wants it to. But I believe this is just guys from areas where, close to where he at. And they might have connection to those areas. But by this point, bro, this man's so far gone, you can't be serious. This man goddamn 30 years old at this point. What he got to do with them young bulls? Smoking a 15-year-old.
Bless you.
Think about that, y'all. Think about that. This little rod, little section right here, and the Eppinger joint. I just never was jacking that. Like, yo, that's clearly a reach, bro. That's like, all right, we all from the same neighborhood. I got some young boys around my way. Now, I don't be around them at all. Now, you know what I mean? I give them some work. Now, they go do a botched robbery.
Are approximately.
Did I tell them to do it? Hell no.
Probably total together about 6 minutes of actual viewing. Is that about right, Ms. Hillen?
Yes, sir.
Okay, so in all honesty, we haven't had a group This is all acts involving someone that's not sitting here. And if we could have a couple minutes just to talk as a group to figure out what our stance is.
All right, and you know what? I may have y'all do that over the lunch hour.
Nah, we want to talk about that now and then go to lunch. What you talking about?
So the next thing I had us circling back on was, and I guess maybe these were from I don't know. We were going through maybe one of the sets of statements because I've got like page 2, 523, 513. Oh, these were the wiretaps, maybe.
Yo, so they literally got a sandwich of nothing. So they got the beginning of the RICO. They tried to frame Young Thug at the beginning to put him in them overt acts. Then you got Donovan Thomas. They can't prove Thug pressed the button on it. Then you got the overt acts that happen afterwards that are even further of a reach to connect Young Thug to. None of it proves furtherance of a gang. None of it proves a pattern, structure, gain, none of this, bro. I don't know what we watching right here. There has to be federal veteran agents watching this shit like, yo, Georgia just need to stop doing RICOs. I don't know why the hell they would take that to trial. Has anyone heard a federal prosecutor speak about this RICO? Because I would love to hear what the hell they got to say. Yeah, I done prosecuted 97 RICOs for the United States government. So what do you think about the YSL RICO trial? Would you have prosecuted that case, or could you have been able to move forward with that RICO? Bro, I would love to hear what they got to say. We talking about, bro, this is bad. I swear, yo, they tried their best to frame Young Thug at the beginning of the RICO and them overt acts. Yes. We got the proof, bro. I'm surprised they even brought it up. Then look, YSL had a secret police that was working for them. They just skipped over that shit. Yup. Skipped straight over it. Nobody talked about it. Now, I'm assuming the defense gonna bring that shit up in their argument. Real rap. It's gotta be. No way. We ain't even seen all the corruption yet. They skipped the corrupt police.
Big Nick.
Yeah.
Waters Road. And then, the comment about, this was the wiretap stuff, the flipping the car and laughing about that. And the state had said, y'all were going to narrow what you wanted to use from that and let us know. Do you recall that?
Just trying to remember flipping the car portion.
I don't know. It was there were two reference numbers. One of them was 513. One of them was 523. It was on that chart that you gave us, I think. On the second page of it, Garlington talking about how they came through and thought they were going to come back and they were going to get ready to light them up, laughing about Shamel Drink's murder and the need to re-up on drugs to sell, and I had determined that the drug part was in, but y'all were going to look again at that other part. You said there was a non-hearsay purpose for it.
Salute to everybody in here. I appreciate you being here. Tap the like button for me if you didn't already.
Wait, did y'all ever go back and do that?
By lunch we can.
Okay.
We'll be able to have an answer by lunchtime.
All right, they about to go to lunch, y'all. What you think?
Yes.
Would you kindly just repeat the two reference numbers?
Yes. 513 or 523. On the chart, it's 513.
Thank you.
And then when we got to 1109 or 1124, there was an argument that shouldn't come in against Nichols or Stillwell because they had already been arrested at the time, and somebody was going to provide law on that.
Yeah.
Did that fall under the broader proposition that the court sort of touched on earlier regarding whether or not overt acts occurring after arrest could be used to prove the conspiracy itself, which would include people who have been arrested prior to the act being committed? If it did, we'd like to sort of address it.
I mean, I think y'all would need to establish that they're still a part of the ongoing conspiracy.
Bro, did Lil Rod lawyer even give an opening statement? I don't remember no opening statement for Rod. Did she? Brian still representing Lil Rod in his appeal, I believe. I might be wrong on that. He might be representing the other dude. Something like that.
Listened to and did re-listen to the part that on the chart is 1974, and I think the other reference was 1999. And this was, I don't know if the argument was 403 there. Confusion, I think, was the argument. And upon re-listening, I don't find that to be a 403 issue. So that is admissible.
You never did. Salute to everybody in here. Y'all the greatest.
That was about as far as we had gotten. And then, of course, we still need to circle back on the that one that we got bogged down with the nested hearsay, with Garlington talking to Thunk, who talked to Quay, who talked to Rill. So why don't we break for lunch? Y'all got some tasks to do over the lunch break. Do you have the material for me to look at? You have. It's not noon yet. It's about 1:15 but.
I just reached out to our other team members.
Okay. All right. Will you are you going to email it or bring it as a hard copy or what's?
I'll email it. That makes it quicker.
Okay. All right. Please do that over the lunch break. Let's reconvene at 1:15.
Yes, Your Honor. And I also put 460 on top of it.
Gee whiz.
My copy of 460. We never did find.
I found our copy.
Okay, great. Thank you.
115.
Police states they have no clue. Hundreds of rounds in the Tahoe. The next line has taco. These are rhyming. There are not 100 rounds in the Tahoe of Mr. Donovan Thomas. You'll have no evidence when that lyric was even created. The prosecution doesn't care. It's a release date. They have no clue.
No clue.
That this is what they're giving to you. And is it 100 rounds in a Tahoe like bullets hit a Tahoe? Or is it someone driving a Tahoe with 100 rounds in it?
What?
It's up to the listener, I guess.
Right.
But the police officers in the city of Atlanta, district attorney's office of Fulton County, everything. It's like 24 M's on an M's head. Everything is viewed wrong.
Wrong.
Wrong. I'm prepared to take him down. Got banana clips for all these ends. Acting monkey. This says slime SHI. This says mob SHI. F the judge. YSL. This is mob life. That's the overhead. It rhymes. There will not be one person to come in here. There will not be one document that comes in here to say the intent of that song was to brag about something that happened to Donovan Thomas or anyone else.
Right.
Jeffrey's being targeted.
Ooh.
The next one, April 12, 2018. Jeffrey released a song on YouTube. It's entitled Anybody. And Jeffrey said, I never killed anybody, but I got something to do with that body. I got the streets on my back.
And Jeffrey said, I never killed anybody, but I got something to do with that body. Yo, rock that shit.
Jeffrey said, I never killed anybody, but I got something to do with that body.
Yeah. Say it again, Brian.
Entitled Anybody. And Jeffrey said, I never killed anybody, but I got something to do with that body.
Yeah. You feel me? That technically mean I can beat a Rico. I ain't. And then I got something to do with the body. That could mean I'm related, but not criminally. I mean, that's vague enough that you can't criminate. I ain't gonna lie, that's fair game right there. It's a little bit hot, but you can't lock me up for that one. Nah, that's fair game.
I got the streets on my back, carry it like I'm moving a body.
Yeah, what? He said that? That's kind of a phony bar right there.
I told him to shoot 100 rounds, like he's trying to move the body.
What? Is he really saying body back to back like that?
Ready for war like Russia. I got all types of cash. I'm a general.
He rhymed that. Whoa, you
You
fucked
will hear
that
that
up.
other artists use the same type of lyrics. Before Jeffrey, after Jeffrey, these are typical. You also learn that this is a song that Jeffrey did with Nicki Minaj.
Kathy Rusin from Law and Crime reported on Twitter when cameras went off this morning that there is a security issue, and that's why they were moved. Something's up. Who was moved? Oh, the people in the courtroom? A security issue? Thug is moved. What's the issue? Right before the cameras went off, Judge wanted to know what happened. What? Yeah, yakking there. Thug got separated from Stillwell. But explain what's the security breach though. I don't see no problem. Like what was the problem that caused it to be like it is now? Like I'm missing something. Where Quay at? He all the way in the back. So close talking. Nah, I don't think it's that. Ain't no way they did it because they was talking. If that's, I mean, I don't think so, bro. I don't know. That's a mystery to me. I would like to know, what's the security problem? Laughing with each other? Yeah, Nicole, they did separate Stillwell and Thug, but I don't see how that's a problem. They've been around, they've been sitting there the whole time. And Thug been communicating with him, like, so it can't be no falling out, but I mean, it could be, but that's a reach.
This song is a gigantic success. Now it's become a confession. It's not true. The next one, January 15, 2019. Jeffrey on YouTube, song called Bad Boy. I shot his mommy, so now he no longer mentioned me. I had, and those are shoes, when I shot the C, act like you want war, they're gonna smoke you like a blunt. I shot at his mommy, now no longer mentions me. So the police are gonna tell you, the prosecutor's gonna tell you, huh? Mr. Bennett, wife Anushi, her mother was shot in drive-by shooting. That was done by Mr. Cope. Not Jeff. It's also January 15, 2019. That shooting happened on January 26, 2015. There's no connection. Plus, wife Anushi.
Well, Daisy, I'm going to keep it real. That's why I don't really rock with those people. Because they floating the news out there vaguely. So, like, that's trash news reporting. You in there, but you halfway telling the story. That's part of the problem. So I'd rather do without it, to be honest. Because that's at this point, it turns into gossip. Real rap. Like, who tell you something like that without telling you what's going on or an explanation on why they can't tell you the rest? Look, there's been something going on. It's a security problem. I'll tell you more when I get more info. They really keeping it a secret. So it's like, it's kind of tricky, like, yo.
He still mentions Jeffrey.
Miss Sylvia. Yo, y'all relax, bro, mentioning other people's channels right now. Yo, relax right now. Y'all really trolling. Relax. It's cool. Relax. Simmer down a little bit. It's cool. Come on. Relax.
Slept with Jeffrey's fiance.
Y'all have a nice day now. Relax. Y'all got it in. Look. Y'all just back to back in them, huh?
Criminalized books, movies, maybe other forms of music. How come other forms of music don't get criminalized? Next. September 16, 2019. Mr. Arnold, Jeffery Williams, it's called Just How It Is. Jeffrey supposedly saying, I escaped every one of the licks because I was supposed to be rich. I don't care nothing about no cop. I'm telling you just how it is. Hit him with a Mac now, his whole body scab. I done for the crew, I done did the robbing, I done did the jacking, now I'm full-time rapping. Last
And now I'm full-time rapping.
At Lennox.
And now I'm full-time rapping.
Yeah. I done for the crew, I done did the robbing, I done did the jacking, now I'm full-time rapping.
Now I'm full-time rapping. Yeah. Yeah. I've done the robbing, I've done the jacking. Now I'm full-time rapping.
Last end tried me, almost got popped into the scab. I done for the crew, I done did the robbing, I done did the jacking, now I'm full-time rapping.
Yeah.
Last end tried me, almost got popped at Lennox. Ask the cops, ask the detectives. They all know the business. Ask the cops, ask the detectives, all the jurisdictions.
Yes. Yo know how to rap. Yo got a cadence. You don't see how he going up with the bars and coming down on the end? He get it. He get it.
And tried me almost got popped at Lennox.
At Lennox.
Ask the cops, ask the detectives. They all know the business. Ask the cops.
Yeah. Ask the cops, ask the detectives. They all know the business. Yeah. Yes.
Ask the cops, ask the detectives. They all know the business. Ask the cops, ask the detectives. All the jurisdictions.
All the jurisdictions. Yo rapping it like hip, hop. Yo.
Gave a lawyer close to $2 million.
Yeah,
He handles
$2
all the
million.
killings. We don't speak about S on wax. It's all mob business.
Yeah.
You know to kill the biggest cats of all the kittens. And that has to be Donovan Thomas, right? It just has to be done.
Yo read that bitch like it was a poem.
There's no evidence that that's true. That's what you're told.
That go to hand.
$2 million for the lawyer to handle all the killings.
He back at it.
The authorities got all of Jeffrey's finances. How much money Jeffrey paid to lawyers? For other people? Hardly any. You'll see a chat that Jeffrey's asked to pay $2,500 to someone's lawyer. Who doesn't even do that? He's asked to pay for lawyers all the time. Who doesn't do it?
Never pay for lawyers.
He's not the head of a conspiracy. He's not in a conspiracy.
Never pay for a lawyer.
They are lyrics. The next one. It's December 18, 2020. This is Mr. Kendrick, Mr. Kitchens,
Damn, Thug and her got the same style. That's crazy.
Jeffrey. And they released a music video, Take It to Trial. This is a very popular song. This song was based on another song called Take It to Trial. They changed the lyrics. So that was the inspiration. Take this MF trial. I rep for my life for real. For slimes you know I kill. Trial. I done beat it twice. State. I'm undefeated like feds. Came and snatched me. I don't know. No point in asking. I was on Believeland. That would be like Cleveland, except the C was dropped for the B. Stuck like a magnet. B-I-T-A-S-S. And I shot at your mommy. Need to stand down. I up my stamina. Take it to trial. Get an appeal. Take it to trial. Yeah. You're gonna whack them, pay for the casket. It's just if we whack them, my young ends
He shouldn't have said that mommy thing, y'all.
pulling up Bentleys, Aston Martins, those Teslas strapped with an FN, choppers, carbons. YSL, slimy and shady. Watch me whack that B, pop them like a cyst, Glock with the assist. And that is your confession. Stuff goes around the world. Now it's held literal to Jeffrey. It's outrageous. The next one. It's April 16, 2021. Jeffrey released a song on YouTube. Really be slime. The lyrics, my end really, they slime. We committing them crimes. Hop out and shoot. Roll one up for the gang. Want to be a slime? Go catch a body. Me and little bro, we used to steal from the store. We had to stick it and go.
Man, little bro, we used to steal from the store. We had to stick it and go. Yo, it's crazy. What's up with him?
That's a confession to an armed robbery. Had to stick them up and go. That's what we're dealing with here. I'm also not telling you that these lyrics are accurate. This is the interpretation of the City of Atlanta Police Department and the District Attorney's Office of Fulton County. You will not hear from the District Attorney's Office. Call one witness who's an expert in lyrics, in rap, in hip hop, in gangster rap, they're not going to do it. They're going to do it through gang experts.
They won't bring a lyric expert. That was an awesome point. I ain't never noticed that before. So still exploits the fact that the state is using all these lyrics, but they won't bring a lyric expert. Wow.
The gang experts know what they're doing. They have 5 gang experts, but they really have 1. Because you're not going to get experts from different jurisdictions, from different types of teachings, from different learnings, from different thoughts. Your 5 gang experts in this case from the District Attorney's Office of Fulton County all work together in the City of Atlanta Police Department. Those are your 5 gang experts. They teach each other. They talk to each other. They decide what the rules are. None of them gave a report. It's just they know it because they are controllers. That's what you're going to be told. They know it more than you, more than me, more than Jeffrey. They just know. We're going to have 5 people designated as experts. They all are biased. They all targeted Jeffrey. They all work together. They have an agenda with the District Attorney's Office, Fulton County. That's our trial. The next one. This is April 16, 2021. Mr. Kendrick, Jeffrey. It's called Slatty. I killed this man in front of his mama, F little bruh, sister, and his cousin. I shoot out, kill him, not leaving a trace. I had to break the safe. Yeah, I didn't leave even a trace. Dissect your body like science class N. Gangster cause, you got a body, little n. Magazine clips, so you might get your issue.
All right. So let's switch up the pace real quick, y'all. What's up? Salute to everybody in here, straight up. So let's go over. All right. Brian Steele was hired to represent an attorney in a well-publicized case where the attorney was charged with conspiracy to commit theft by extortion. The underlying alleged threat being that the lawyer would file a lawsuit if the other party did not settle a client's claims, and being a party to an unlawful surveillance video recording of sexual relationships in a bedroom. Related civil litigation had been in the court for several years, as the alleged victim was the CEO of Waffle House. Soon after the client was indicted, Mr. Steele filed a motion to dismiss the indictment, attacking the constitutionality of the statute charging theft by extortion, as well as the unlawful surveillance statute. The Fulton Superior Court granted the dismissal of the indictment as to all counts, declaring both statutes unconstitutional. The Supreme Court permitted the case to go forward on the unlawful surveillance charge. At trial, Mr. Steele ripped apart the state's case, presented shattering cross-examination of the alleged victim, and the jury returned no not guilty verdicts on all counts. Yeah. What's up? Y'all want to hear some more of those? Put ones in the chat if y'all want to hear some more of these Brian Steele stories. That's pretty interesting, y'all. I read a couple of them to myself, but some of them wild. I think they interesting summaries. Put ones. Give me some ones, y'all. We on lunch break. We got about, what they say, 1:15? It ain't no such thing as a lyric expert. I mean, essentially it is, according to the way they deal with experts. So somebody with more expertise than a lay witness would be deemed an expert witness. I forget the status, but like certain people reach the criteria if that's what they do all the time. So by the court standard, someone could be a lyric expert from what I understand, from what it looked like. All right, let me read these. Let me read some more of these Steele Jones. All right, so what we got? Illegal surveillance, not guilty. Brian Steele was hired to No, hold on. That's the same thing, my bad. Hold on. Here go one. QG was charged with malice murder, felony murder, armed robbery, aggravated assault, and multiple firearm offenses, and he was held in custody without bond for over 1 year. Mr. Steele retained experts who analyzed the video footage of the perpetrators entering and leaving the location of the armed robbery/murder and proved that QG was not one of the perpetrators depicted on the video based on differences in height of QG and either of the perpetrators captured on the video. After sharing these expert findings with the prosecutors, and in the face of this evidence, the state sought continuances of the trial, to which Mr. Steele vehemently objected because the trial had been specially set by the trial court upon request of Mr. Steele. When the state's last-minute continuance request was denied, the state then attempted to file a null pros dismissal of the indictment, but Mr. Steele objected to the null pros. Get that shit out of here. Because the state would then have the opportunity to re-indict the case. The trial court agreed with Mr. Steele's argument and declined to null process the case and summoned a panel of potential jurors for the jury selection. However, the state refused to participate in the jury selection process. The first 12 jurors were the sworn, but the state declined to call any witnesses or otherwise participate in the trial. Mr. Steele made a motion for a directed verdict of acquittal, which was granted. QG was adjudicated not guilty. Additionally, QG's co-defendant also benefited from Mr. Steele's advocacy and was cleared as well. Damn. That was different right there. Tap the like button. Wow. Gee whiz. Hold on. Let's go. Let's get another one. Hold on. AW was charged with murder, felony murder, aggravated assault, possession of a firearm during the commission of a crime, and cruelty to, in the third degree, stemming from a shooting at an automotive repair shop in daylight in front of 9 witnesses, who all testified that AW had no reason to pull a gun. Mr. Steele persuaded the jury that AW acted in self-defense when he shot an unarmed person 2 times at close range. AW had 2 small children in his car, as an aggressive and hostile mechanic instigated a confrontation, seeking a fight. Although the mechanic had no weapon on his person and did not touch AW, the jury found AW not guilty on all charges, and after 19 months in jail, facing a life sentence, AW walked free like George Jefferson out that bitch on the armor of Brian Steele. Damn. He ain't playing. Oh, we got more, y'all. Oh, yeah, I think it's a lot of them, too. I'm at the top of the page still. MM was charged with aggravated assault, shooting, and criminal trespass. Mr. Steele presented a self-defense claim. After a 4-day trial, MM was found not guilty. Simple as that. We ain't got a lot to say. After persuading the courts of appeals to reverse PC's conviction for voluntary manslaughter, Mr. Steele zealously prepared for his client's retrial. Mr. Steele argued at trial that PC was justified in defending his property, quote-unquote vehicle, and the jury returned a verdict of not guilty, and the client was cleared of all counts. After CR was convicted at trial, he hired Mr. Steele to represent him on appeal. Mr. Steele won CR a new trial from convictions on murder, felony murder, aggravated assault, and possession of a firearm during the Mr. Steele was also retained to handle the retrial. At the retrial, Mr. Steele convinced the jury to acquit his client on all indicted offenses based on self-defense, and CR was cleared. Jeez. After the first jury was unable to reach a unanimous verdict, Mr. Steele retrialed LS's case and persuaded a second jury to return verdicts of not guilty on all charges of murder, felony murder, voluntary manslaughter, aggravated assault, and possession of a fire. Based upon self-defense. Believing that she was in mortal danger, LS fatally shot her naked, unarmed husband 6 times at close range in their marital bedroom. LS was cleared on all charges. Damn. Why was he naked? Mr. Steele defended B.I. on 31 counts of whoa. Mr. Steele defended B.I. on 31 counts of unmentionables and more unmentionables and more unmentionables on people that we can't mention. As a result of Mr. Steele's blistering cross-examination of the people we can't mention, therapist and the mother of the people we can't mention, the court granted a mid-trial motion for acquittal on all counts, having found that the people we can't mention statements were inherently unreliable, being as though who they are. Prior to trial, the prosecution's offer to resolve the case was multiple life sentences, plus 100 years to serve in prison. B.I. was cleared on all charges. I'm going to just say this. He should have went to jail. That dude should have went to jail. That dude should have went to jail. I don't know if y'all know what I'm talking about. That dude right there, Holmes should have went to jail. I don't condone that one. That had to cost a lot of money. I would like to know how much that dude paid for that. After a 2-week trial, Mr. Steele's client was found not guilty of all counts. Malice murder, felony murder, voluntary manslaughter, possession of a knife during. CC had a confrontation with an unarmed man whom he stabbed in the neck. CC received no injuries and fled the scene with the knife. Mr. Steele used self-defense as CC's sole defense. CC was freed from custody. Damn. Mr. Steele acquitted ES of 2 counts of armed robbery, 2 counts of kidnapping, and 2 counts of false imprisonment in the face of 3 cooperating co-defendants who accepted deals and testified for the prosecution and implicated ES as a perpetrator. ES was cleared. God damn, how he do that? Oh my God, hold on, let me read that again. Mr. Steele acquitted ES of 2 counts of armed robbery, 2 counts of kidnapping, and 2 counts of false imprisonment in the face of 3 cooperating co-defendants who accepted deals and testified for the prosecution. That's worse than this. That's worse than this. How you do that? Yo, we might need to check that paperwork, bro. Yo beat 3 rats. That was dad. That ain't even hearsay. Yo beat real snitching. Yo beat snitching. Man, I don't even know if I ever heard of that. I don't even think I've never heard of a dude get told on by 3 co-defendants in a situation where they directly snitching and you beat it. I don't think I ever heard of that. It ain't a RICO? If it's one crime, it's not. And they probably don't got no gang determining factors, Grease. They probably don't have no tats, no social media to juice it up to make it a gang in order to put it to RICO. Can you do RICO without it being a gang? Yep. If they didn't conspire, bro. So you need a couple elements to try to get the RICO. You don't got no gang, no furtherance, no conspirator. You got to prove they're conspiring. They planned, or the goal was like they be breaching. Technically, yeah, Grease, they could have wrote it as a RICO, bro. Yeah, definitely could have juiced their ass. Yep. Yeah, easy. I don't even know the details, but because of what kind of charge it is, it's an armed robbery. So, I mean, I can write it to where as though y'all niggas planned it. Like, you had to get in the car together. Like, the whole process of an armed robbery, bro, like, technically I could say y'all planned it and it was in furtherance of. So once I fill in those blanks, it's a RICO. You feel me? Now you got to fight it as a RICO. And it's vague. You feel me? So it's like, technically, yeah, they could have wrote it up. I mean, if we got some previous some previous overt acts that can line up with the same type. I mean, you see what they doing. They putting all overt acts in there. So if you were serving before and you got caught, you feel me, gun possession, all that could get thrown in. So once you get it's up to the jury. Do they really believe these dudes was a threat to society and was a real gang? And are they going to charge them for that? Or are they going to say these boys ain't no real gang? They might be misled. They just, maybe some troublemakers, but they not a real gang. I'm going to say a lot of people on the jury can be misled by the right DA. Straight up, especially in context when watching the news and you don't know what's going on for real, for real. So, I mean, we definitely ready to be some turn up. But I'm going to say this too, y'all. The streets going to reply to this scrutiny. The fact that they showing us everything they be doing and watching, dude's going to tighten up out there. Yeah, dude's going to tighten up. Let me read some more, though, y'all. Hold on, let me see. All right, Mr. Steele successfully defended TD on charges of murder, felony murder, aggravated assault, and possession of a firearm during the commission of a crime. TD was acquitted on all charges. Self-defense. Killing with self-defense. All right. After JD proceeded to trial with another attorney and was convicted on all counts, Mr. Steele was hired to represent JD and reversed all convictions and sentences. Yeah. Mr. Steele was then hired to Mr. Steele successfully defended JD in his retrial on double murder, armed robbery, and burglary charges. The jury returned a verdict of not guilty on all counts after Mr. Steele ripped apart the prosecution's witnesses with devastating cross-examinations. Mr. Steele called no witnesses in his client's case in chief, and his client was cleared. Damn. Beat him on defense. He beat him on defense, ain't even use offense, y'all. Ain't even need case in chief, bro. Gee whiz. Mr. Steele successfully defended GG using a defense of self-defense against charges of murder and aggravated assault, as GG shot an unarmed man in the chest at close range. Yo. Mr. Steele and his former law partner successfully defended EH, a City of Atlanta police officer charged with attempted burglary. EH was the only alleged bad cop acquitted of all charges. 1994. State versus EH. Oh, yeah? Coweta County. Interesting. All right, he got a whole bunch of appeals and reversals. Suppression of illegal seized evidence affirmed. Hold on. MB was charged with trafficking heroin in September 2020, stemming from a traffic stop. Mr. Steele was hired to represent MB, and he filed a motion to suppress all evidence, challenging the lawfulness of the traffic stop conducted by a joint task force. Mr. Steele argued that law enforcement officers lacked any reasonable, articulable suspicion to stop MB's vehicle, and at a hearing on the motion to suppress, Mr. Steele meticulously undermined each and every one of the law enforcement officers' claimed justifications for the stop. The trial court agreed, found all police officers and federal agents not credible, and suppressed the trafficking amount of heroin. Whoa. The state appealed the trial court's order granted on the motion to suppress the Court of Appeals of Georgia, which affirmed the order suppressing all evidence. The state was then forced to dismiss the indictment, and MB walked. Damn. Cuz smoking boots. Yeah, he's smoking boots. Attorney discipline rejected by Supreme Court. Attorney NP was accused of violating the state bar of Georgia rules of professional responsibility, ethics code for lawyers. Mr. Steele defended NP during multiple phases of the accusations and argued that NP's conduct did not violate of any bar rules. NP rejected all negotiated offers. The matter proceeded to a hearing before a special master. After a contentious evidentiary hearing, the special master found in favor of NP and recommended the dismissal of all charges and proceedings. The state bar appealed to the review panel, which reversed the special matter and recommended sanctions against NP. Mr. Steele appealed to the Supreme Court of Georgia, which issued a clear and definitive ruling in favor of NP, and against the state bar of Georgia, which cleared NP of all accusations of ethical impropriety. Whoa. Damn. Convictions reversed for violation of Garrity and Castigar. What? KW proceeded to trial with other counsel, and after conviction was sentenced to 49 years to serve in prison. Damn. Mr. Steele was hired to do the direct appeal. Initially, Mr. Steele won certain counts at the motion for new trial hearing, and he appealed the remaining counts of conviction to the Court of Appeals. The appellate court affirmed in part and vacated in part, and remanded the case to trial court to conduct a Castigar hearing as to whether the state met its burden to demonstrate that no tainted evidence in the case was admitted at trial based upon KW's Garrity protected statements to law enforcement. The trial court found that the state failed to meet its burden under Castigar and thus granted KW a new trial. The state then appealed to the Court of Appeals, which affirmed the grant of the motion for new trial. The state argued for certiorari. What? Certiorari. What? State argued for certiorari to be granted in the Supreme Court of... Y'all got to excuse me. That word is crazy. State argued for certiorari to be granted in the Supreme Court of Georgia, but that request was denied. This case marks the first time in Georgia jurisprudence that Garrity statements are analyzed under the Castigar analysis. My bad. KW remains out of custody. Vehicular homicide, serious injury by vehicle, convictions reversed. KH proceeded to trial with other counsel and was convicted of multiple counts of serious injury by vehicle and vehicular homicide in the first degree and sentenced to 15 years imprisonment followed by 15 years of probation. Mr. Steele was hired to represent KH on appeal. The Court of Appeals in Georgia reversed all convictions except for the misdemeanor offense of failure to stop at a stop sign. The state then appealed to the Georgia Supreme Court, and again Mr. Steele prevailed before the highest court in Georgia, creating new law about when to file a general demurrer, whatever the hell it is. Yeah. Oh, he made case law right there, y'all, didn't he? A new law, yeah. Other crime evidence excluded from trial. The state of Georgia filed notice seeking to introduce 9 instances of other act evidence against BB in his upcoming trial. Mr. Steele argued to exclude the evidence as it did not meet any of the proper purposes specified in the other act statute and was prejudicial. The trial court excluded every and all of the other act evidence. The state appealed, and the Court of Appeals affirmed this ruling in an unpublished opinion. Damn, why was it unpublished, baby? Order modifying sentence reinstated. MG entered a guilty plea and was sentenced to a term of imprisonment. 10 months later, Mr. Steele filed a motion to modify MG's sentence pursuant to OCGA. Several months later, the motion to modify was granted by a different court sitting by designation, and MG's sentence was drastically reduced. 3 weeks later, the original sentencing court vacated the sentence modification and reimposed the original sentence. They were pissed. Mr. Steele got pissed even more. He appealed to Court of Appeals of Georgia, which affirmed the lower court, holding that the reinstated sentence was proper because of OCGA. Did not permit a trial court to modify a sentence after 1 year. Undeterred by this setback, Mr. Steele steamed forward, appealed this decision to the Supreme Court of Georgia, which granted certiorari and then reversed the Court of Appeals and the trial court and definitively held that trial courts retain jurisdiction to modify sentences where the motion to modify sentence pursuant to OCGA is filed within the 1 year term, even if the modification orders are entered outside the 1 year period. Yeah, who knows what the fuck. Supreme Court affirmed grant of motion for new trial. Yo, just to let y'all know, I'm still at the top of this page. Mr. Steele argued on direct appeal that under the rule of lenity, KM could only be sentenced for misdemeanors. The Court of Appeals of Georgia agreed with this argument, and all felony convictions were vacated. Damn. Murder conviction reversed. After being convicted at trial, where he was represented by another attorney that was ass cheeks, Mr. Steele was hired to represent SS on direct appeal. Mr. Steele, even though the other lawyer was ass cheeks, was successful in persuading the Supreme Court of Georgia that SS's trial and conviction for murder and related offenses was unfair due to improper comments on the client's pre-arrest, silenced by the state prosecutor. All convictions and the life sentence were reversed. Damn. Yeah, y'all. It keep going. I sound spicy. Hey, what kind of spicy? Oh, yeah? Oh, yeah? Gay? All right. Damn. I was just trying to read. All right. Say less. All you gotta do is say less. Yeah. Don't worry. I'm gonna make sure it don't sound spicy no more. I ain't reading. I'm a drag. Yeah, you see how they do you when you a black man reading? Yeah, yo, I see you over there reading. You all zesty and stuff, boy. Look at you. Got your wrist bent. You over there reading. You all in the books and stuff. Oh, you want to be a little zesty, little reading, little salamander. A little zesty reading, little salamander. Golly, they did me dirty.
You think you gangster because you got a pistol. Look at my trigger starts to issue YSL, we going overboard. Oh yeah, the lyrics found the prosecution, they searched for this stuff. There is no safe in this case. These are simply art. Next one. April 16, 2021, Mr. Arnold, Mr. Kitchens, Jeffrey did appear in a video titled Ski.
Hey, yo.
I F.
That's why niggas stop reading. Niggas like, yo, come here, yo, let me show you this shit. Niggas start reading like, bro, yo, look what it say right there. Nigga like, bro, I don't be fucking with that reading shit, bro. That shit gay. Niggas holler, what? Man, that shit phony, bro. That shit gay. What do you mean, bro? See? That's crazy. That's crazy, bro. They hit us with that one. They tricked us. Golly.
With slats, we come to eat rats. I came with some effing piranhas. I towed an FM on me called Nietzsche Nietzsche. It's Glock, he keep rolling.
I don't agree
Duke
with that,
rolling
bro.
60s.
That's crazy. Nah, like, I get it, y'all. Nah, they was just trolling me, y'all. They was just trolling. But that was, I mean, we read enough of them, y'all. I wasn't going to keep reading that many of them. But I get it. Yeah. Brian Steele, an animal. I've read enough of them. It's so many more. Salute to whoever sent that to me. I forget who sent it. No disrespect. I appreciate it sending that. Because that put things in context. Yo, capable to beat damn near anything what we just heard. And I ain't even read that much. You feel me? I mean, that was a nice example of yo ain't playing. Yo, Bunchy sent it. Send me some more, Bunch. You seem like you in the mix.
Locked in C. Duke is the name that Mr. Martinez Arnold used. It goes by Duke. Rolling 60s is the Crips. That's the C. Some of these words are not really the lyrics, but you can decide for yourself. You'll hear the songs. You can decide what the lyrics are. It's a wildly popular song. It's now become criminal.
Hey, yo.
Words in America are criminalized in Georgia.
Yo, if my internet mess up, don't
Next
leave,
one.
y'all.
It's count 56. So those were the overt acts dealing in count
about
one,
to see if
RICO
it's back.
conspiracy, deals with Jeffrey. There
Hold
are
up.
191 overt acts. Most of them don't deal with Jeffrey. But the
Facts.
prosecution has indicted it through the grand jury.
Don't
They
dip.
say Jeffrey's in this conspiracy. So the acts of a Christian Eppinger somehow roll onto Jeffrey. Jeffrey's not in a conspiracy, you will find out. That is everything pertaining to Jeffrey and count one. Then we have to skip. So you're going to have that count two. Count two is the murder of Mr. Donald Thomas. Jeffrey's not indicted for murder. And you keep going down until you hit count 56. And you're going to go through 56, 57, 58, 59, 60, 61, 62. Those pertain to Jeffrey. So that's what these are individual counts. It's not, these are just separated out. They're all in the overt acts, but now they are separated out into crimes. So 56 is from the 12th day of May of 2018 to the 8th day of May 2022. The dates are there because the indictment was returned the next day, May 9th of 2022. That's why it ends on May 8th, 2022. And it goes back the 4 years because that's something called a statute of limitations. The Honorable Court will charge you on that. But that's why you have a date range. And it says that Jeffrey, he occupies the position of an organizer, a supervisor, a management, a leader in YSL criminal street gang, and did engage directly or indirectly, either conspired with the following criminal street gang activity: murder, aggravated assault with deadly weapon, armed robbery, hijacking motor vehicle, sale of marijuana, possession of marijuana with intent to distribute, theft by receiving a firearm, possession of a weapon by a convicted felon. Jeffrey's not a convicted felon. They're saying that, well, Jeffrey is in bed with these other people, and therefore their acts are attributable to Jeffrey. Jeffrey doesn't even know most of these people. That is charging Jeffrey with participation in criminal street gang activity. Criminal street gang activity, you will learn, it is not enough to be in a gang. That's not illegal. It's not enough to associate with a gang. That's not illegal. It's not illegal to have a blood tattoo on you, wear red. It's not a crime to promote a criminal street gang. What makes it a crime is if you're doing all those things and you're wearing the colors and you are promoting the gang and then you do a crime to further that gang's activity, the agenda of the gang. That's the crime. Otherwise, we couldn't associate with someone who's part of the Ku Klux Klan, not that anyone would want to, or the Aryan Nation, or any other despicable organization. America would wipe them all out. That's what Jeffrey's charged with. That's count 56. Count 57 also charges Jeffrey with participation in criminal street gang activity. This is along with Mr. Arnold and Mr. Kendrick. And this on May 9th of 2022. May 9th, I may have misstated earlier, May 9th of 2000, I don't think I did, but maybe. May 9th, 2022 is the day of Jeffrey's arrest. When law enforcement surrounded his home, there were more than a dozen people there. And what the prosecution did now is say that this is criminal street gang activity. This furthered the gang YSL because in Jeffrey's home, where other people had access to, there's marijuana with intent to distribute. Jeffrey doesn't have to sell any drugs to make money. Possession of codeine with intent to distribute. Possession of cocaine, it's a very small amount. possession of firearms.
Who the hell has some
And
cane?
alleged in count
Ho,
15,
ho, ho.
59, 60, and 61.
Ho, ho, ho.
Some of the damage we'll get you right now.
Hold, Brian. Who be playing with their nose though, Brian? These boys some real drunkies, bro. They had the cane. They had some cane. They some major players. They had a little bit of nose candy in there. You gotta respect it. These boys some real rock stars. Hey Brian, tell them about that's that real rock star life. Like nobody got the cane. A little, like I could see if you said he had like 4 ounces of some cane. Now that mean they get yeah. But we talking about what they had like less than an 8 ball. Oh yeah, somebody playing with their nose, baby. Somebody playing with their nose. Who was it though?
That somehow promoted the gang. That was in
Yo,
further-
I ain't seen a guy with the cane. Guys be having all types of stuff. I swear, bro, you gotta be in special areas. Now I know. Certain areas it's available, but it's still rare, bro. Like you gotta be in the party area, real rare. Some of you, all right, ones in the chat. If this is regular where y'all at, no telling. Just ones like, yo, I ain't gonna lie, it ain't that rare where I'm at. It's rare where I'm at. You ain't gonna just stumble across somebody with a. Not rare. It's like grass. Whoa. See, it's not like that. Hold on. It's regular like that where y'all at? Not rare in Cali. Not rare. Oh, so so we the oddballs. So let me ask y'all this. Y'all got the smack heavy? Yo, how about the dog food? The dog food is readily available as well? Like I'm talking about flooded. Little areas here and there. See, we flooded on the dog food. Like, I don't know what's their problem out there. Florida going crazy with it. Yeah, yeah, that's surprising, y'all. But I just thought that was interesting. I think that alludes to these boys is real, they parties. They parties. Party Marty. Arty party and shit. You feel me? Like, I think the amount of drugs they would have been caught with, it would have been a different way. Like, a different amount, of course. They would have been able to catch them with transactions and things, baggies, scales, confidential informants, controlled buys. On the strength, they ain't got that. The fact that they try to really put the drug part in the RICO on the strength of what they caught on the raid at the house. I ain't gonna lie, that was phony, bro.
of the gang. Being in a house where other people have access to it, where these drugs now further the gang. That's the allegation. That's it. Next count. The 58, Mr. Arnold, Mr. Kendrick, and Jeffrey. They possessed marijuana with intent to distribute the day of Jeffrey's arrest. Marijuana is found in Jeffrey's home. There's marijuana. And it's bagged up. It was bought at a distillery, dispensary.
It was dispensary grass? What?
It said Brooklyn, New York on it. that's found in Jeffrey's home. Now Jeffrey, there's all these other people have access to. There's no drug test that Jeffrey's using marijuana. His hands, his clothing don't have marijuana on it, and nobody's going to tell you. But now he is charged, out of all the people, with Mr. Kendricks and Mr. Arnold with possession with intent to distribute marijuana. That's count 58. That's the day of his arrest. Next one. It's count 59. Mr. Arnold again, Mr. Kendrick again, and Jeffrey. It's the same thing. It's the day of his arrest. It's May 9, 2022, and found in the home is codeine. There's a lot of codeine in the home. Buckets full. There's all these separate glasses, bottles of codeine. Jeffrey didn't possess it with intent to distribute. It's in the home. That's it. That's it. The next one is 60. Mr. Arnold, Mr. Kendrick, and Jeffrey possessed cocaine. It's the same day of the arrest. This is a small amount of cocaine. I'm not pro-cocaine, but this is a small amount of cocaine. Now he's charged with it. Out of all the people in the house, they just picked these. Next one, 61. Mr. Arnold, Mr. Kendrick, and Jeffrey, possession of a firearm during the commission of the felony. It's the same date of his arrest when the police took over the home and searched it. And it says that Jeffrey did have on his person, or he conspired with others, was a party to crime with others, a Glock 30S firearm, a Glock 357 firearm, F&M firearm, Glock 919 firearm, Smith & Wesson M&P firearm, Glock 45 firearm, which has a converter. While involving the felony of marijuana, possession of marijuana with intent to distribute, possession of codeine with intent to distribute, and possession of cocaine, they're saying that the gun and the drugs are in close proximity to each other. And therefore, having a gun, which is not illegal for Jeffrey, except for the machine gun, converted gun. But if it's near drugs, and guns and drugs should not be together under law. You'll have zero evidence that Jeffrey was with a gun near any drugs. There are all these other people at the house. These other people were living at the house all the time. Jeffrey would go from place to place. Jeffrey just got back into our country. He was in Ireland. He was watching Sergio Kitchens perform. He just got back the weekend before. The next count is count 62. Mr. Arnold, Mr. Kendrick, and Jeffrey were in possession of a machine gun, Glock 45 firearm with a converter switch, extended magazine. During the commission or attempted commission of participation in criminal street gang activity, possession of marijuana with intent to distribute, possession of codeine with intent to distribute, possession of cocaine, as alleged in count 57, 58, 59, and 60. You will hear zero evidence that Jeffrey ever touched a gun with a converter. You will hear zero evidence. This is a knowledge. You have to know. We don't trick people. You have to know that the gun is transferred into an illegal machine gun. You'll hear zero evidence that Jeffrey had anything to do with that gun. The purchase of it, the possession of it, even knew what was in the house. Knew that it was a machine gun. That's the count. Ladies and gentlemen, that was the indictment against Jeffrey Williams. That was everything. Jeffrey has been targeted. Jeffrey does not trust the criminal justice system. Spent 10 months to choose you to decide his fate. Jeffrey trusts you. There's a wiretap in this case. There's actually two. Antonio Sumlin's phone, a wiretap. Wiretap just means that it's called wiretap because we used to have phones with wires, and the law enforcement would get into the phone system, the AT&T system, and be able to connect to the wire for that phone. And they can listen to all incoming and outgoing calls. Today, you don't, our phones are cellular, but it's the same exact thought. And law enforcement, with a court's permission, or without a court's permission, that's illegal, can get into a cell phone on the frequency so they can capture your Google searches, your text messages, your phone calls, everything you do with that phone, your GPS. And Mr. Garlington's phone was wiretapped. Mr. Someone's phone was wiretapped. And you will learn that these people who are so embedded with Jeffrey in crime, Jeffrey's the king slime, the leader of this organization. You know how many conversations in any way they have with Jeffrey? 0. He is not on a wiretap. 0. But others speak about Jeffrey. Hey, we did this for King Slime. He should pay for our lawyers. Jeffrey doesn't pay for anybody's lawyers.
Yeah.
Hey, how much will King Slime, the biggest, pay us to kill YFM Lucci, Mr. Bennett, who's in the Fulton County Jail and we have access to him?
Yo. Yeah, audio should be good, y'all. I'm here. I just had to switch up some things on my connection. Audio should be good. It should be. Yeah, that's me, y'all. I did that. That was me resetting my getting back on my regular internet connection without turning the actual yeah, something ain't right. Yeah, I got that email. Salute to everybody in here. Tap the like button, y'all. Yeah, I had to switch everything over, man. Straight up. It should be a little bit smoother now. I'm back on my regular internet connection. Until I restart, it should be straight. I had to figure out how to do it without cutting it off. Yeah, we back at it though, y'all. I resisted the hate. I didn't actually end the stream. That was weird. That was all right though. I ain't in the stream. All right, so yeah, I bounced back on the mouse. Salute to everybody in here. Tap the like button. Yo, one's in the chat if you can hear me, man. One's in the chat if we back. Yeah, I don't know what that was, y'all. I mean, I do, but I don't know exactly how I got disconnected while I was jumping. But I was just jumping internet connections, y'all. All right. All right, good look, y'all. I appreciate y'all sticking around, too. They not back from court. Let me it's live. Yeah, we ain't missed nothing, y'all. They was still on break. I'm here. I had to get my internet back on the main line. Salute. I appreciate y'all for sticking around, too. I swear I'm smitten for all of you. Yeah. I mean, I gotta go through stuff like that every once in a while to keep me sharp. I mean, at least I kind of understand how to deal with some of the problems, you feel me, just in case it does occur. No, I got the best internet. That wasn't me. That was them. The internet went off, but the problem was I had to, without ending the stream, I had to hop between internet connection. I did it. I'm back. I should have responded faster earlier to coming back. I actually sat there and didn't respond to the problem for a minute because I was letting the box. I thought it was just going to cycle. Yeah, I'm in here, y'all. Run it up. Let's do a roll call. Grease, D, Agnes, Taji, Young, P. Cookie Chip, Justin, Mill, Kosh, Miss Gripper, KT, Zariah, Benicia, Lisa, Benicia and Lisa, Agnes, Egg Coat, Paula, Immaculate, Mac, Hollywood Kang, Lala, Yaya, L, Blue, Jay Freezy, Tyrese, Money Mate, Wayman, Quality Cash, M3, Sugar Beat, Cloud, hold up, Paula Nick, Loyalty, Kurt Will, King Ty, Never Mac, G-Ski, Mitch, Grace and Peace, YPF, Ricky and CJRP, Tonya, Tanya, yeah, J Ham, Benji, Cherie, Curtis Nelson, L. Johnson. Hold on. If I missed you, I mean, you gotta excuse me. That was a lot of them. Young Swagger, Robin Casasola, Invisible Woman, Flo, Megs, Sugar Rush, yeah, King Meech, Shern, Mark Bent, Stephen Knight, Penny Lane, Tia, Bruce Wayne, Nikki Rabbit. All right, salute to all y'all, man. Straight up. I really appreciate y'all rocking out, man. Because we definitely had some technical difficulties. You heard? You heard? We definitely did. It's cool, though. We right back. It's cooler than the thong at the
Turn it
pool.
off again when you leave. Maybe it's just going to be an issue at breaks. I don't know, but I don't know. Just I guess try to turn it on and turn it off as you.
She got a blue diamond
arrive
wedding
and
ring.
leave the podium area. All right, Miss Love, I appreciate you sending electronically the communications between the state and the various attorneys whose clients have pled. However, I think for me, it's just going to be easier if you can print them out and give me a hard copy, and I'll give you if you can just have those to me by Monday morning, that'll be fine. But I just think it's
Yo,
easier
that
for me
is one
that way.
goddamn rock on that ring. You see that?
And just, and I didn't go through all of them. I started going through them.
Yo, what the hell is that? Hell is that her birthstone or something? There ain't no way that's no diamond, bro.
But make sure that if there is there were a couple of emails that, and it was like well into the string. So I'm sure if I got to the original email, the attachment would be there, but just make sure I've got the relevant attachment too. Okay, so I'll just deal with all of that after
Shorty got a goddamn Indiana Jones ring on her finger.
you give it to me in hard copy form.
Oh, that's the wrong hand? Yeah, I ain't married, y'all. I don't know the right hand. You know, I don't know
Did
that.
y'all get an opportunity to try to...
I ain't never asked nobody, oh, you married? I don't even be looking at hands. I ain't, bro, I'm ignorant with that shit.
come to any sort of an agreement, if there is any, on
See,
those?
y'all be thinking I know everything, right? Hell no. Hell no, nigga. I don't even know which one is the ring finger. Now, how ignorant is that, nigga? I don't know which ring, nigga. Fuck the hand. I don't know the ring finger, nigga.
Items 451Y through, I think it was 455 or so, and then 460Y.
Your Honor, no, it was not an intentional disobeying of the court's instruction. What I was doing was the state's position is slightly different than it was with an argument for why.
Okay.
And whenever the court allows, I'll address it. If he wants me to just start now, I'll just start now.
All right. So did you give a redacted copy to the defense, or you just think it's whatever your new position is might change everything?
It will change everything. And
All right.
and I did also, the thing that I'd asked Ms. Winfrey for that she so kindly provided was what exactly the objections were to the exhibit so that I could address them in turn. What I recall specifically, I believe that it was Mr. Stillwell who made the initial objection that...
Hang on a second. Can y'all try to be a little more quiet over there so I can hear? I don't know who it is, but... Oh, that actually reminds me too, before we get into that. Just a reminder to everybody that there's not supposed to be any eating in court and that the defendants are not supposed to be on laptops, okay? That has not changed since I took over this case. All right, go ahead.
My recollection is that
she a
Mr.
bitch.
Stillwell's attorney is the one, Mr. Sharp, who originally specified a portion of one of the exhibits that he felt should not be allowed or presented to the jury because it contained information he thought was overly prejudiced.
Hey, yo, you guys salute me, yo. I'm one of the only ones that's allowed to say that type of shit, you feel me? Because I'm a freelance reporter. So I'm going to let you guys, you guys support me. If you want to be able to be honest like that from time to time. Yeah, you just need that on the news. Don't y'all think the news should be able to say that from time to time? Now, that's some bullshit. Every once in a while, they should be able to allow to just, that's some bullshit.
Judicial.
She's a bitch.
If I'm not speaking correctly, I'm certain he'll correct me where I'm wrong. But other than that, I was wanting to make certain I heard all of the objections so that I could speak to them. But if my because I'm going to make a proffer to the court.
Okay. It would be a lot easier, I think, part of their position had been until we know what the state's actually proposing as the redacted exhibit, it's hard to make objections. So are you ready to share that?
Yes.
Okay.
Yes, I'm ready to address it.
If you would do that, that might help the
So, Your Honor,
court and the...
on what theory the state would be seeking to admit out-of-court statements?
That was part of what I intended to address. So
Okay.
I'll just
Well, let's all get a copy of what it is
they're not redacted. It's the ones we gave them. So the ones that I have previously identified.
Can I have a hard copy of them? Because that's another one of those things that if I'm having a look on the electronic, it's like embedded within several emails.
Yes.
Before I ever get to what I'm supposed to be looking at.
Yes, Judge. So
Thank you.
What I'm going to do is just give to the court my the copies that I tendered, and I'm going to speak from my notes as to what it is about them and why it is that I believe that.
All right. Well, hang on. Laura, can you have the substitute JA come down here and grab these and make some copies for me? Please. Thank you.
We back at it.
Because I have a tendency to write on things once I get them. I'll try not to do that until I get my copies, but if you'll come around here, I can actually reach you.
We back at it like crack at it.
You're welcome. And what, for the record, I have given to your honor.
Yeah, I mean, I know what they all are. So 451, 2, 3, 4, 5, and 6 should be, yeah, and 6, and then 460.
Yes, Your Honor.
Okay.
That wasn't me, y'all.
Permit me to take my seat so that I can read it.
Yes, you may.
That time, that wasn't me.
Your Honor, starting with Mr. Sledge's testimony.
I don't know what that was.
The court, and I think everybody else is aware, that as we referenced State's Exhibit 1AS or 444, my particular question to him, after he started talking about his truth and his ability to tell his truth, was using the guidelines if a acknowledgement that you signed.
Yeah, I remember. We don't have to like belabor the point.
Okay.
If he picked out several and listed the ones that he said were false, and they were 3, 4, 5, 6, 7, 8, 9, and 16.
Right. With the exception of about 4. Right. And then he said that he understood none of the sentencing
At the time, yeah.
acknowledgments at the time.
Mm-hmm.
So, Your Honor, under 246607, OCGA 246607, Your Honor. Impeachment by contradiction.
Mm-hmm. Well, that's not impeachment by contradiction.
Well,
That's who can impeach.
Hey, hey, hey.
so as I'm reading, and I know that it's who can impeach, who may impeach.
It's a different one. 621 is impeachment by contradiction. A witness may be impeached by disproving the facts testified to by the witness.
Right. The reason that I referenced that only is because it was in the book that I'm reading from. There's a section that I'm looking at. So
It's a novel.
particularly a witness may be impeached by contradiction in several ways. Close questioning to elicit concessions of errors in testimony during direct, questioning a witness about the substance or implications of evidence already produced during the case to suggest contradictions, confronting the witness with his or her own contradictory prior statements, or calling another witness, or introducing other extrinsic contradicting evidence. Generally speaking, the admission of extrinsic evidence for contradiction impeachment is restricted to non-collateral matters, so that evidence that impeaches by contradiction and is not collateral can be both substantively admissible as well as admissible for its impeachment value. And that is coming from Baylor, BEHLER versus Hanlon, HANLON, 199 FRD 553. And then the parenthetical is surveying numerous commentaries. Judge, with respect to Mr. Sledge, the reason that I began my statements to the court about what it is that he said, and will then go into what his lawyer said. When I asked his lawyer about plea negotiations,
When she confident, she don't even talk like this.
on the heels of Mr. Sledge, not just saying he was told he could get up and tell his truth, but on cross-examination, he was asked repeatedly through the use of allowable leading questions. These weren't your words. You didn't write it. You didn't understand it. You didn't know what you were signing. You felt like you could come in here and tell your truth. You signed it regardless. I'm not directly quoting, but essentially, even though it wasn't true, you signed it. And things of that nature were elicited during cross. You signed it because you wanted to get out to go see your sick mom, things like that. You were in Fulton County Blues. That's the only reason you signed it. These aren't your words. These are only the state's words. So all of those questions were intended to attack the credibility of the veracity of the statement that Mr. Sledge made on December 28, 2022, when he signed the plea agreement. And Mr. Sledge acquiesced to all of those attacks, essentially asserting through his sort of obfuscations and running back and pulling back my truth. I don't understand. I don't recall. I don't remember saying that. That isn't true. And his pointing out at the state's request the factual acknowledgments that he now asserts were inaccurate or not completely true. He allowed himself and the cross-examining attorney to, in front of the jury, completely question or to undermine the credibility of the statement that he made and his own credibility at the time that he made the statement. So as the court has already instructed the jury that inconsistent statements of a witness are also substantive evidence that may be considered against other persons on trial.
Yo.
Can the court hear me okay?
Yeah.
So as the court has already instructed the jury that it can now consider that statement as substantive evidence, what we've seen is an attempt by the defense to destroy the jury's faith in the credibility or veracity of that statement made by Mr. Sledge on December 28, 2022. So when questions were posed to his attorney regarding Mr. Sledge's understanding of those acknowledgments and sentencing agreements, on the one hand, after he made clear that though he's a friend of both sides, he's a defense attorney through and through, Mr. Wright, though he did clear it up, he seemed to, his answers on cross-examination, there were some things that were not true. There were some things we didn't agree to. He was kind of vague with it, and it took belaboring point by point for him to even acknowledge, hey, number 3, number 8. These are the only 2 anybody took issue with. So at this point, Your Honor, I believe that the iterations that were presented to Mr. Wright and to his client per his words are important because it is further evidence that corroborates Mr. Sledge's understanding of and his understanding of the final plea agreement that is 1AS and 444Y, and his ability to effectively engage in and have an active hand in that final document that he signed on December 28, 2022. It points not only, it demonstrates not only the inconsistencies of Mr. Sledge's testimony, but his outright perjury regarding his purported lack of ability to have any say in what that final document asserted that he signed. It is illustrative of the fact that he actually did have the ability to tell the state what he felt wasn't true, and what parts he wanted changed. And I think that our position is that it is relevant in showing or allowing the jury to judge the credibility of statements Mr. Sledge has made on the stand versus the credibility of the statement that he made on December 28th, 2022. The statute that I cited earlier, it substantiates our position that the representations that Mr. Sledge made under oath on December 28, 2022, were part of a long and detailed negotiation and refinement that Mr. Sledge himself took part in. I think at this point, 24-1-104 might become relevant. That's the one I brought up earlier that didn't have any bearing on what we were talking about. But in as much as 24-1-104 speaks to the code section not limiting the right of a party to introduce before the jury evidence relevant to weight or credibility, we believe that.
Engineer, that email you just sent me was awesome. Hell yeah, we need to talk. Remind me before I dip off.
This particular evidence allows the jury, it is pertinent evidence that they should be allowed to see, to understand fully what was put before Mr. Sledge, what he did dispute, what he did not dispute, and so that they can compare it with what he finally agreed to and make a better determination about the truth of the statements he made on December 28, 2022. I think that the argument that some of the statements, the allegations made by the state, those are things that one way or another may be asserted in any event. For instance, they caught nut down bad is a statement that we know is going to come out either through the person that said it, the person that relayed to law enforcement that they said it, or in his statement to police if he lies on the stand. These aren't matters that are so prejudicial that they should be kept from the jury. These iterations, if you will, the defense wanted to have us reference part of them, but pointedly objected when I attempted to have Mr. Sledge show or point out differences between a previous iteration and the final version. That previous iteration was not circled there. It's one that I have because I did not tender it as a marked exhibit. They actually objected to my calling it a previous iteration. And I think in attempting to keep from the jury not just the previous iteration, but the number of them and the changes that were made and requested, and the changes that were not requested, as is reflected in 460Y, we're keeping from the jury very relevant, pertinent evidence that in no way substantially prejudices either defendant through its admission. So I believe that an instruction that these are assertions made by the state, essentially questions that they ask the witness, then defendant, are these true? I initial them if they aren't, tell me what changes need to be made, and that they are not to consider as true from this witness or take as statements by this witness anything that doesn't appear on state's 444Y, and that they should look at state's exhibit 460Y as substantive evidence of the defendant through his representative of what he was calling true and not true at the time that the state presented him the iteration that came just before it. So it allows them to put in context Mr. Sledge's factual acknowledgments and sentencing understandings that he signed
I'm going to get copies made of all of these.
Yes, Your Honor.
All right, so just one. Oh, batteries. Thank you. All right, I've got some batteries. If
Oh,
you
did they
think
go in
that
here?
might help with, I'll just put them up here.
Wow.
Seems like your mic is out. And like,
Regular batteries?
I don't know whether they take double A or triple A. Double A over here. All right, got a few of each.
Sit your narrow ass down, boy. Let me get these batteries. Your little ass ain't meant to get batteries, boy. Let me do my job. You do law, boy.
All right, so I think that, there's the 444Y one, which is the signed plea acknowledgement.
I ain't
That's
never
sort of
seen
a
hold on, y'all.
Type.
Yo, just to let y'all know, batteries to electronic devices are rechargeable like your iPhone now. Like, it literally has a built-in battery that'll last so goddamn long. It's really like, you feel me? So, like, to see some disposable batteries come up out of an electronic device, I feel like Christmas or some shit. Real rap. I ain't even gonna lie, yo. If y'all know how much goddamn electronic devices I got, only thing use a battery is a mouse. And technically, we could get mice that don't even use batteries. They charge too. You feel me? Like, so, like, it's rare to see some batteries come out some shit. To be honest, I'm keep it honest. Like, whoa, that device use batteries? That's an expense. That ain't a cheap mic. I'm surprised that bitch run off batteries. I'm gonna keep it real. That's some serious shit right there. Like, that it even had some double A's in there. I'm gonna keep it real. That's some serious ass quality for some double A's to be running it.
Then all of the rest of these correspondences back and forth.
I get it. And that bitch got a light on it. It got a power switch and a light on it, and it's running off of 2 double A's. I'ma had to say, that's some pretty decent shit. That's some pretty decent shit right there. Whatever the fuck that is, if that's running off 2 double A's, yo, that's a pretty decent piece of equipment, to be honest. I don't know why they put double A's, but fuck it.
Just so I understand that, like, as to 460Y, you don't even intend to redact it at all? All right, help me understand
Look,
what you're
they
saying.
fresh now.
As to 460Y,
Charge everybody battery.
I wanted to redact everything except the one email that Mr. Wright sent. I want to take out everything else before. I even think I included twice in that 460Y the same email. So I would like to redact out all of that except the email from Mr. Wright to me on December 27th at 8:43 or thereabout at night, wherein he is making statements for his client. So they are statements of his client that number 1 is okay, number 2 is okay. And I say that under, I would call it an adoptive admission, but he is an agent.
It's an agent.
Right.
Yeah.
So he is stating, his client is stating, number 1 is okay. And in order to know what number 1 is, the jury needs to see what number 1 was that I sent to them, which would be the exhibit directly preceding, which I believe is 452. If I'm wrong, I'll make that correction. But the jury should see 452, wherein Mr. Sledge says that's okay. They should see whatever he wrote about 450.
Number 1 rule, don't trust the person that just tell you they broke, right? First off, it's 50-50 on if someone say they broke, right? But number 2, if they got on designer, really don't trust them. So everybody in this courtroom and everything going on in here is high caliber, high dollar, right? So we supposed to believe that they don't got enough bread? Nah, cap. They not, nah, bro. They got that bag in there. That's cap.
About number 2?
Let me ask you something. I mean, is he really a party opponent anymore?
He was.
But is he now?
Because admitting it in this trial now, is that an admission by a party opponent?
Oh, you mean in terms of the...
You're saying, this is a statement by Mr. Sledge's agent, which it is, but would that get admitted under the admissions by a party opponent exception to hearsay?
I wasn't admitting it under that.
So
I was just saying that they are statements of Mr. Sledge.
Okay.
So what you admitted it under?
Under what exception do they come in?
They are Mr. Sledge's statements. He is a witness who was on the stand, who was subject to cross-examination. So inasmuch as they are inconsistent and contradictory to the testimony that he gave.
Okay. So I can see 444Y coming in as a prior inconsistent statement because he definitely testified inconsistently.
All right, y'all. Yo, this the wet noodle trick she be doing. So what she do is she run a noodle in the water, right? Wet it up, let it get, soggy a little bit. Then she just sling that motherfucker, right? And then turn around to see if it stick. That's what she do. So she's intentionally doing this noodle shit, y'all. Yeah, knowing that certain stuff don't fit, but she gonna flood it. All right, it's like bum rushing the door. You feel me? You wind up getting something in there. If we throw so much stuff, somebody gonna get through the cracks. You feel me? So it's like they can't stop us all. So that's what she doing with, like, she done did it with so much evidence. Like, she doing it with different evidence, right? So look, it's certain stuff that shouldn't even be brought in, right? So what she done did was stockpile so much of that shit that the judge or the defense is worried about catching certain things and they might miss other things that shouldn't be in. So now what we saying is throughout the case, some of these things that slipped in is getting caught on the back end. So that's what we watching. Literally, she getting called out for little things that shouldn't even be in here, bro. I'm telling you. That only made it through on the strength of Glanville. Real rap. Because Brian Steele was trying to get a lot of stuff put out and, trying to manage this stuff. But it was so much. Just the defense did the same thing to them, though, with the motions. Stacked them all up to where as though the judge got to look through all these ones, so they wind up letting something get through. So we done seen both of these teams use this method, but hers is dirty.
Once he was on the stand, to what he said in that document, which admitted as factually true all of those things that he initialed.
Right.
So that's a separate item, and I'll hear argument on let's deal with that one. 444Y.
Is it my turn?
Okay, so don't talk about the rest of them until we get past.
Not yet, because I think this is kind of separate than the rest of them.
Okay.
Because it's a different type of document. So do you want to say anything else about that? You saying it's a prior inconsistent statement and it's impeaches him by contradiction.
Yes, and it corroborates the state's position and...
Well, I know why you want it.
Corroborates the state's position is not a hearsay exception.
Right, I understand that. Yeah. So why does that not come in as a prior inconsistent statement?
Your Honor, first, I just have to address one thing. And I'm sorry, I'm not trying to be a whiner. This is exhausting because every time we are on the same page and Your Honor seems to direct us, things somehow get relitigated. We were up at the bench and we all looked at 444
No, 444 is a different one, but yes, 451 through 6 and 460.
Are we talking about the emails right now? Or are we talking?
No, what I wanted to talk about right now is the actual final plea acknowledgement.
So I'll address that.
Okay.
We all talked about this and we determined what would be admissible as prior inconsistent statements. And
the state was allowed to read and confront, and he acknowledged that he signed. So he never said he didn't sign those things. He explained it. But those factual acknowledgments on the 1AS, which I think is 444Y, were read into the record and fully litigated. And we not only heard from Mr. Sledge, but then we heard from Mr. Sledge's attorney for a day. And the whole process of how everything happened was covered ad nauseum. I think the jury gets it. And there's nothing that I would understand to be gained by admitting the paper copy of what was testified to and discussed over a week with, this gentleman and his lawyer on the stand, however many days it was, that hasn't already been covered. Additionally, Your Honor, of course, my stance would be, if it were to be admitted, it would not go back to the jury because it would be continuing witness. It would be, signed statements, written statements, and the idea that somehow, well, that deals more with the prior versions, but
Yeah, let's not get to that.
yeah, I won't get to that yet, but we've discussed this, and now we're back to arguing about it again.
I don't actually know that we discussed 444Y1AS.
Well, the state sought to admit it at one point, is my recollection, and you instructed the state to ask about the ones he was denying, and they confronted him, and they said, this is what you're denying, factual acknowledgement. I'm using an example. 3, and then it was read, and then it was discussed, and then we went from one to the other to the other. The state was certainly not rushed in their examination of Mr. Sledge. So all this has been covered. There's no need to admit the document into evidence at this time. And it's cumulative, but also it should never go back to the jury to begin with. So I don't even know what purpose it would serve at this point.
Well, we can deal with that later, what goes and what doesn't go and what's subject to a continuing witness objection. But it's definitely a prior inconsistent statement. Y'all were given an opportunity to cross him on it. He was given an opportunity to explain it. It can come in as extrinsic evidence.
Well, okay.
It's pretty clear law, I think.
Well, the other thing is, I don't know if he denied, the other thing is he didn't deny adopting it. He said, and he gave an explanation.
I know.
Right, but I don't believe that lays the foundation for a prior inconsistent statement. Him saying, "Oh, I did sign this, and this is why I signed it."
Okay.
And then, so.
Well, the statements on the document say every bit of this is true, and I acknowledge every bit of this. And he testified inconsistently to that with regard to the majority of it.
He did, but he never said at the time he didn't acknowledge it to be true.
I think he did. Okay, so to me, I don't know if the entirety of it or just the parts that he denies are admissible, but does it really matter?
It
If,
does.
1, 2, and 14 through 15 come in?
I'd have to really look at it, and this is, the state has not given us a proposed redaction, but
do you propose to redact that at all?
No, and just as a point of clarification, on the first day of direct examination, he specifically said that 1 was not true. He said that. On the second day, he came back and said yes, but the first day he said no.
It's interesting that Ms. Love says that, because when she actually was examining him, she misspoke and said that he adopted number one. So now she's saying he denied it. Yes, I believe that if we're going to admit them, if the state's not willing to redact it, then it should not come in.
All right, so
What is it that they're proposing that we redact, Your Honor?
the parts that he didn't testify inconsistently with.
So I believe that the document as a whole serves to rebut it's a contradiction. The document as a whole is a contradiction, impeachment by contradiction. It serves the other, the three things that he said he admitted, 10, 11, and 12. I'm sorry, 5, 10, 11, 12, 14, and 15. Provide context to the types of admissions that he was willing to make. It provides context.
All right, well, didn't they watch a video of you reading out just the parts that he said were inconsistent?
Yes, just the parts that he said were inconsistent. And I believe that the document as a whole is evidence, powerful evidence of what the document contains, of the statements that he makes in the documents. I think it's evidence. The fact that he signed, the fact that the document exists, the fact that they can see what it is that he was looking at, and compare it with what it is he is saying on the stand allows them to further assess his credibility. It corroborates what they saw. It corroborates his understanding of what it is that he was signing.
All right, if we're talking about is it an exception that permits his admission, it being corroborative doesn't get you over that line. So yes, sir. Yeah. Now it may be that what you mean to say is that the entirety of the document needs to come in because that's the only way they can understand it. Is that what you're saying?
Yes. I'm sorry for not doing it as well as the court did. When I say context, yes, it is the only way that the jury can fully understand the document and what was before Mr. Sledge at the time that he signed it.
The state's stance is that the jurors can't possibly understand one factual acknowledgement about a video, for instance, without being provided another factual acknowledgement about gas stations on Cleveland Avenue. Mm-hmm. That acknowledgement about gas stations on Cleveland Avenue just sheds light on this acknowledgement about the video that allows the jurors to understand that. That's ridiculous.
You had him admit on the stand the factual assertions that he still agreed with, right?
I had him not read from the document.
Did the jury in any way hear the factual acknowledgments that he still acknowledged?
I believe that the answer is in some form or fashion they did. For instance,
hang on just a second, Miss Love.
Oh.
I'm objecting to the document coming in. Mm-hmm. And you said it, and I think the Honorable Attorney Sharp just said it. My memory, and according to my notes, the entire, from the swearing in of Mr. Sledge, then it skipped. And then the entirety of his acknowledgments, whether he admitted it or did not admit it, was read over my objection on a video audio from Crime and Law, or Law and Crime. And now we're doing it again. That's in evidence. So I'm objecting to it. It's already there. And the state at one time told you that they needed that evidence in because it shows demeanor and he had opportunity to sit next to his lawyer, and that there was no one else in the courtroom, and Mr. Williams and I and the others weren't there to intimidate him or whatever their word was. This is just cumulative. He's been impeached. He's been thoroughly impeached. So I'm objecting to 444 at all.
And at the appropriate time, I'd like to respond.
The answer to your question is yes. It has been acknowledged.
So your recollection is that on the video, every factual acknowledgement was read?
Yes, that is, if I'm wrong, please correct me. I'm not trying to be wrong.
He's right.
That's according to my notes. There was nothing redacted. It went right from the acknowledgments, whether he agreed or disagreed. It was read by Miss Love.
All right, Ms. Love, I know you sent us an email at some point that said, here's what I intend to play.
Respectfully, Mr. Steele is incorrect.
Right?
We did.
Okay, so hang on. And was sent Friday, September 6th at 7:45 a.m. And then, yeah, I think that's the right date.
And
then maybe again to me at 9:54 a.m.
Right. Would the court like that we put it on the screen or just reference the portions that we were taking out?
No. Oh, yeah, no, you didn't play the ones that he said were true. You only played the ones that he said were false.
Right. I know. Yes, Your Honor.
Okay. Okay, so.
And when the court feels it appropriate, I just had a couple of more words to say in response to Mr. Shart's response about 444 and impeachment by contradiction and the amount of time spent on it.
All right, I'm not concerned with the amount of time spent on it.
Okay. Then not that,
so the ones that are prior inconsistent statements are the ones that he said were false. So if you're arguing that the entirety of the document should come in, what's your basis? Your basis for that is it's the only way for the state the jury to understand what he was willing to admit to and what he wasn't later on. What's your argument as to why it should all come in?
So, Your Honor, reading from Morgan versus Morgan versus Covington, 648 F. 3rd, 172, 3rd Circuit. It's a 2011 case. The doctrine of, and this is quoted, this is cited from there. The doctrine of impeachment by contradiction serves as a means of policing a witness's obligation to speak the truth in response to proper questions and permits courts to admit extrinsic evidence that specific testimony is false, of course, because other evidence contradicts it. Other inadmissible evidence is admissible as rebuttal evidence where counsel opens the door to such evidence on direct or cross-examination. The doctrine of curative admissibility relates strongly to impeachment by contradiction. I won't get all into all of that, but when on cross-examination, Judge.
Appreciate it. All right, I'm going to give you your.
Would you get that back?
Documents back.
Thank you. Ms. Hilton's coming.
None of these are the. Yeah. Okay. Thank you. Sorry to interrupt. Go ahead.
Yes, Your Honor. So we're not just talking about, if we were only talking about inconsistent statements, then that would limit us to a portion of it. But here on cross-examination, the entirety of the cross-examination was intended to present to the jury the impression that the statement itself was not knowingly or willingly or voluntarily agreed to. And in fact, even though the court sustained the objection to the question, I believe Mr. Sharp said it, or I'm sorry, forgive me, Mr. Sharp. Mr. Weinstein said it when he said, when the state put these words in your client's mouth. So the point of it is, when on cross-examination, whether it's effective or not, when the effort is, and the witness has allowed it to happen, that an entire statement is essentially sort of undermined. You say you didn't understand it, you lied because your mother was not well and you wanted to get out of jail. The validity of the statement itself is now, it's impeached. It's almost like you're impeaching the statement itself. You're saying that the statement isn't valid. And so inasmuch as the statement as a whole does allow the jury to understand, it does place the few admissions he makes in context, we'd ask that it be admitted as not just a prior inconsistent statement, but as impeachment by contradiction.
Your Honor, there's no contradiction. He said that the state presented me a form that they wrote on their letterhead and asked me to initial it, and I did. And that's exactly what the form is. It's a form that they wrote on their letterhead that they asked him to initial, and he did. So there's no contradiction. The document doesn't contradict anything he testified to. Now, there needs to be a hearsay exception, and the reality is, if they're arguing that things are prior inconsistent statements, they've already been played in the video, and we've already heard it. And if they're arguing things aren't inconsistent, then they shouldn't be played. There's no reason for the hearsay to come in. So even if I granted to them that it's a prior inconsistent statement, we've just established that we played a video with all of that being read, the jury's watched it, and that was covered. So at this point, that form for any hearsay exception that it would fall under, that's already been covered by the video.
All right, I'm going to rule on this one that the portions that he disavowed on the stand may come in as extrinsic evidence of a prior inconsistent statement, and we'll deal later with whether they actually go out as continuing witness or not.
And for the record, which ones are those?
So I think that would be, if everybody has it in front of them, my understanding is he disavowed 3, or at least portions thereof, 3, 4, 5, 6. These are all under 4, under factual acknowledgments. 7, 8, 9, and 16, and then every bit of Section 5, the sentencing acknowledgments. He said he didn't understand any of them, even though he initialed saying, I understand fully each of them, as well as the paragraph underneath that.
He also acknowledged on day 1 of my direct, number 1, I wrote it, though he changed that.
Well, if he changed it, then it was no longer inconsistent. I mean, I didn't, when you were like, all right, here it is in front of you, tell me which ones there you have any type of problem with. He did not say number 1. So I made my ruling. All right. So that's that one. That is, and I don't know whether you're going to tender 444Y. That would make more sense. You've established that it's the same as 1AS.
I did.
Okay.
When
I'm listening.
You talking like Michael Jackson when he was on The Simpsons.
I'm going over just one moment, Your Honor.
Okay.
She talking like white Michael Jackson off The Simpsons, man. She chirping. Salute to everybody in here. Tap the like button. Help me get to 600, man. What's up? I'm here. What's up with y'all?
Yes, Your Honor. That is, we understand the court's ruling with respect to 444Y.
All right. And I don't think it would come in as, whatever it's called, the rule of completeness, because that would be if one party's introducing it, the other party has the right to do more. And this is all one party over here trying to get it all in. So that doesn't apply. All right.
Party over here.
I think now we can move on to the rest of them, which are all sort of, I need a bigger bench, the same thing. Well, I guess what's in 460 is not contained in any of 451 through 456. Is that correct?
Well, 460 is Mr. Wright's email to us.
Back. Okay.
Right. And so 460, and by 460, I do mean the last four pages.
The part where he says, let's not do these ones, or here are the issues with these ones. So do you actually want or need the rest of them in?
Judge, because so the answer is yes. And
okay. Under what basis? Okay. Under what evidentiary rule?
Yes. So as to number one, because Mr. Sledge, on the second day, he agreed and gave testimony about examples of number one, it's not so much that it's an inconsistent statement as it relates to number one, but when Mr. Sledge on cross-examination asserted that he did not have the ability to change things, that we didn't change things for him, showing the way that the recommended changes were presented to the state. What is not said is as important, in our opinion, as what is said.
All right, are we talking right now, I'm sorry, about just that portion of 460 that's Mr. Wright's 8:43 p.m. email?
I should have been clear. Yes, and the second part of that is just a duplicate where I asked that copies be made. So we are only talking about Mr. Wright's December 27, 2022, 8:43 p.m. Response to the state. Subject line is Reese-Sledge agreement updated. And with Mr. Wright on the stand, I clarified what exhibit came in before that he was responding to, which was 452.
Okay.
And then what exhibit came after that, which I believe was 453, but I'll check my notes to ensure that that's the case. So in as much as number one, he's saying, okay, there's no caveat, there's no, we need this. Okay. So number two, obviously Mr. Sledge agreed to number two, but there is an additional, they formed about 3 years before Peanut was shot, him offering up that kind of information, Mr. Sledge offering up that kind of information. He is nowhere in there is he asserting it's a record label.
All right, well, nowhere in his factual acknowledgement on number two is it asserted what YSL is. It just says defendant has been a member and or associate of YSL since blank.
Right.
So he wouldn't need to say, and by the way, it's not a gang.
I agree with that. Also, but in number one, where we say what it is, we don't use the word gang. We say something, we use specific language that he's perfectly okay with. And then in number two, he makes no effort to, qualify anything as he did on the stand multiple times.
Okay, well, as we all know, the case law holds that it's actually not illegal to be a member of a criminal street gang. It's only illegal to commit crimes in furtherance of it. Well, to commit crimes, period. And then it makes it a gang violation to commit crimes in furtherance of it.
And that's why number one says
right. And so, number one is whatever number one is, but that number two says, oh, by the way, it was about 3 years before Peanut was shot.
It's that he's offering information, and I'm going to defer whatever the court's ruling is, but it's that he's offering additional information. He's comfortable enough to say
I think that is okay. I think it was about 3 years beforehand, so it must have been about 2012.
Okay.
So 3.
Number 3.
Didn't we read that into the record?
We did. We read the response Mr. Wright gave.
Okay.
And I believe we
did read
read.
We did read into the record.
If I make it, I believe we read as well the portion of 452 that was number 3, and then the final. I think we read 3 number 3s into the record, just so that the court is hearing what I believe is a full truth. We read not just that, but I asked him to read what he responded to and then how we changed it for him.
Well, we read at least the final version of number 3.
We
many,
did.
many times.
Oh,
So number 4. Back on the email by Mr. Wright.
Okay.
We never read that in, right?
So
I'll
number 4,
I'll remind
we did
the
not.
court that we approached about number 4. There were obvious problems with number 4 that were inadmissible. We were told to stay away from number 4. The state was told to stay away from number 4 for obvious reasons. There's all sorts of speculation in there. And now, after being told to stay away from it, and we were told to stay away from it, and we did not address it during cross-examination. Now, after witnesses have testified, the state's seeking to admit a document that has number 4 in it. And it's just, I don't know what we're doing.
Okay.
Your Honor,
Number 5 is not even relevant, right?
Your Honor, if I may just circle back briefly, as it relates to number 4, there was an objection to it. We followed the court's instruction. We did not ask him about it. And when the issue that I have with number 4 not being addressed here is more importantly, I don't know how an assertion that the witness did not adopt is prejudicial when he is not, he denies it and we change it, we take it out, that he was planning, he had personal knowledge that they were planning. That is powerful because it is a material fact that
he doesn't have personal knowledge that they were planning it.
Judge, that's the point that I'm making, that he says, I did not know that. The fact that something that...
Even saying, I did not know that is sort of like...
Or that's not true.
It's true, but I didn't know it.
No, he's saying that's not true.
He's not. He's saying, I don't know. I think maybe XYZ. That is not coming in.
Yeah.
That needs to be kept out under 403, if nothing else.
Got her.
And that's really the only thing you wanted in, right? So
I didn't hear you.
Is that really the only thing from this that you wanted in?
When you say this, you mean
from this being this
Stop
part,
laying down.
the 8:43 p.m. email from Mr. Wright that is included within 460Y.
I didn't even the language of what he says. I didn't even need to have that in. I mean, I understand why that would be considered, and I understand the court's position there, why it would look like something was pre-planned. The reason that I was asking or seeking to have the assertion in is just to show that he says no to it. We could take out all of number 4 under Mr. Wright's email and just say no. He denied it.
Well, we can't make it say something.
No, not put the word no. He said, Mr. Wright said on the stand that is something that we did not agree to and we took out.
And that's exactly the point. Mr. Wright said all this stuff on the stand.
We're not going to be admitting 460Y. And that leaves 451 through 456. And those kind of, what would be the theory under which those would come in?
It, Your Honor, it contradicts Mr. Sledge's testimony when I presented him with a prior iteration, that there was an objection to it being called a prior iteration. and I asked him to show me things that were different. It contradicts his testimony that he saw prior iterations and was allowed to make changes to the prior iterations. He said on cross, the first time he ever saw that plea agreement, it might have been the first time that he saw.
Well, that was the first time he saw that plea agreement because all of these were prior versions.
And when I asked him, did he see any prior versions? My recollection is that he denied.
I don't remember that. I think he said the back and forth between us and the state was up to my lawyer. I left that to my lawyer.
And Mr. Wright clearly testified that he took a version to speak to Mr. Sledge the night before.
And I'll look back at
All right. Well, subject to that actually being some kind of so that would be what, impeachment by contradiction?
Yes, it would.
Okay. Well, you can let me know if he actually testified
Your Honor.
in the way that you remember it. Yes.
And I don't think we should have to litigate this again, and I'm going to explain why.
Yeah.
Okay.
The state, under the state's theory,
She loves
I mean, why don't they just do this for every case? They could write out their facts, just send them to a bunch of witnesses. Witness doesn't need to initial them at all, and then they take the stand. And then we just start bringing in all copies of documents that they wrote and sent to witnesses that witnesses looked at. I mean, it's false facts here. It's facts that haven't been adopted on these documents. There's inadmissible statements on these documents. It's a mess. And we didn't create this. We didn't tell the state to do it this way. We didn't tell the state to write their documents and then send them to an attorney, write the statements and send them to an attorney and see what the co-defendant says or the witness says. We didn't tell them to do it this way. They created this problem.
I understand. You get back to me if you can find some kind of testimony that you think lets you get this in. Right now, they are excluded.
Yes, Your Honor. Thank you, and I will look for that.
No, thank you.
Yes.
I can't say with certainty, but I'm just going to ask if there is also a case which I, in my mind, in the recesses of it, believe that it may address. Specifically, like iterations.
Sure.
Okay, thanks.
She said, "Oh, Bookie Boo, my Bookie Boo said."
Even if Mr. Sledge did say there were never any other versions, which I don't think he said, you've disproved that by presenting the testimony of Mr. Wright. So I think given the number of 403 concerns there are with 451 through 456, I'm going to just stand on my ruling excluding them.
Your Honor, with respect to the 403 concerns that were raised, given that 403 addresses matters that are substantially more prejudicial than probative, and given the extent of the cross-examination and the efforts to undermine the willingness or knowingness of Mr. Sledge's statements, essentially even in the arguments that are made, it's essentially the argument is that this isn't a statement that Mr. Sledge made. Showing a prior statement, contradicting that testimony.
That's what 444Y is. And that's it.
That's the ultimate one that he signed. But showing, yes, it is. It is. Showing that he was untruthful and letting the jury decide, why are you telling stories about that? About seeing a prior version, we believe is strong evidence that allows them to judge his credibility, why he's saying what he's saying, any bias he may or may not have, and help them to determine the truth of which statement they should believe. So we would ask that the court, revive its prior ruling, revive the ruling that the court made.
Denied. Let's move on.
Damn. Let's go. Come on. Come on.
All right. What were y'all tasked with over the lunch period?
Your Honor, we reviewed the proposed
segments of those videos that showed Mr. Beebe and Mr. Eppinger referring to and they weren't referring to it, but it's clearly involving the armed robbery that they're charged with that's listed as an overt act. I can say on behalf of myself and Mr. Steele, we have objections. I think Mr. Steele was going to articulate them
All right.
to those segments.
Okay, I think it would probably help for me to be able to see what those are. But before we do that, 463Y, were you intending to tender that at all? I don't know if that was one that you had included that we said we'll circle back or not. That was the one that was just his sentence that showed that he got the sentence on the second count too.
No, that was just
okay.
a refresher.
All right, thank you.
Bro, if you're in the chat and your comments can't come through, I don't know what that is, bro. Refresh your refresh your YouTube or something or whatever you watching on. I see two people sent me that comment that they comments can't come through in the chat. It's a YouTube issue. Oh, it ain't got nothing to do with my stream.
All right, can you queue up the portions of that video, please?
Yeah, they probably updating or something, y'all. Now they probably doing updates behind the scenes, and it's just like, you feel me? You might be they in the middle of doing updates, so you'll get caught using the old version that's outdated in the middle, and they just ain't say nothing. Who knows? Tap the like. Tap the like. Yeah. She on Miss Love Hills. Yeah, salute for the new members too. I appreciate that straight up. Yeah, I appreciate y'all in the chat too, the people that is typing. I appreciate it, baby. I promise I do, baby. Or what they got going. How do you upgrade? I don't know for sure, Tam. I can't see none of that. I don't even know what it look like. Like, it won't let me do none of it.
Together that, just the portions of that guilty plea. So if we're going to be just showing portions of various videos and things, if y'all could do that for those as well, that moved things along much more quickly.
Thank you, Judge. We will after we
Great.
work it out.
Decide. Okay. Thank you.
Oh, man.
Monte Beebe and it'll be Christian Eppinger. This is after the armed robbery that both are alleged to have committed. Mr. Beebe has recently or did plead to the charges in this indictment regarding this armed robbery.
All right. So I'm sorry, timing wise, this is shortly after the robbery or shortly after?
Shortly after the robbery.
Okay.
And we're going to begin the first portion at 1:12.
Yo, these boys is kids. Mind you, at the time they filming this, Young Thug grown. Their motive for him having people doing this in the furtherance of what gang? And them doing this is connected to Young Thug at the top. That's cap. Just keep that in mind when you watch.
3 seconds, Your Honor, from 112 to 115.
What that going on now? What's up, Slam?
And Your Honor, as you see, or if you see there, when Christian Aperture gets onto the call, he throws up what we have alleged.
That boy ain't no gangster. That boy give head, he got this piercing. Everybody with this piercing give head. Case over. Case over. I just solved it.
Trapaholics. Real trap shit.
Hey, where the Posted nigga at right now?
What's going on with Posted?
Hold on, Posted came on.
I have to
Straight like
I'm
that.
gonna break that nigga face.
I'm standing on it.
I can't give Posted back to late night. That ain't happening. Oh,
I'm standing on
it.
I'm standing on it, cuz. Every person with this piercing right here, give head. Yo ain't thugging.
That's just the YSL sign, and then Durante do it back towards him.
Bro.
Okay. The next portion, Your Honor, is 2 minutes and 45 seconds to 2 minutes and 52 seconds.
Yo, if your girl come in with this piercing right here, excuse my French, but just ask her, yo, who dick you sucking? I watch how she look guilty. I'm telling you. She gonna look guilty like,
Anybody in here, I'm out there. Alright, shit.
nobody ain't in there, so they got off.
Slatting.
Can you get rid of that box by chance?
Look at him, bored as shit, in the house, punished, with a ski mask and pajamas on. And she claiming they thugging. These boys got mental problems. Low ass apartment, boy. This is just regular life for people in the trenches. Them boys
And
ain't
so,
gangsters.
Your Honor, if I need to play
Them
back,
boys is bored.
I will, but when they're ending the call, they both say slat, which is a terminology.
Oh
that
my God.
We are alleging that YSL members use.
They off. They need to prove themselves. They live in poor environments. Of course they gonna gravitate and yell the same shit that rappers and shit yell. Look at him. Ain't nobody there, and look what he doing. What the hell what gang signs is them? What gang signs is them? Nah. You want to tell me all the hand moves before? Tell me what the hell is these? What gang signs is those?
And then the last portion is 356, 408.
That boy can't go outside. His mother told him, make sure that house clean. He on the box. You seen him. He on the box. His mother told him, you better have this goddamn house clean when I get back. And your dumb ass better not be on social media with that goddamn ski mask on. Don't let me catch you doing it. And you know what he did. He cleaned up the house, but he still went on social media with the ski mask. He's smoking blunts all in there. Yeah. Now, she done told him, if you gonna smoke blunts, you better not have it smelling like no goddamn weed when I come home. You little dirty ass. I don't even know why your ass ain't got no job. You just like your goddamn father. Da-doom. And she went to work because she worked 9 to 5 for real. You feel me? And she nice. But he a whole goofy. Look at him. Yeah.
But they hit him up.
Look,
My artist.
I look at him. She told him about this dumb shit. He acting just like his father. That's what she get for messing with drug dealers.
They give me, I done built me a business up.
And it ends there.
Boy,
just
ain't
a
got
few
no
things.
friends.
The clothing that he is wearing, Your Honor, I believe this is OTS on the slime
Can't
clothing
hoop.
that he is wearing. This is also his public page.
If he had the chicks, he'd have been definitely parlaying with the chicks. He ain't got the chicks. This what happened. You awkward. You can't get chicks. You ain't got the ass cheeks flooding on your phone. You sitting around calling your homeboys. They don't even want to sit on the jack with you. Look at you. You got the ski mask on in the house looking all dumb and shit. Nobody to smoke with. Nobody to joke with. He's a goddamn joker.
So immediately after this call, he then points a gun at and towards the camera. Again, going towards the state's theory that members of YSL operate with violence and using guns to show their threat, their notoriety, and given everything that has happened in the video, those relevant portions, those are for this video.
Man, if he had a smart homeboy could have told him, yo, stop waving that damn gun in the camera, boy. You ain't shooting nobody. Sit your dumb ass down and play this Madden, boy. Or make some grilled cheese or something around this bitch. You in there, you running around pointing guns. His little brother could have put him on point. He just off. He just off. His little cousin. You know what I mean? Anybody could have been like, yo, stop with that dumb shit, bro. Come in and play the game, something. This dumbass nigga just want to be a dumbass. That's all this is, man.
The three portions we see.
Ms. Hilton, excuse me.
Can you not hear?
I didn't quite follow the first thing she said. Something about what was on the clothing.
We believe that this is clothing that we've seen on other YSL members.
That nigga had a PlayStation 5. That nigga wouldn't even have been on that video, man.
It's either OTS or on the slime clothing. We've seen, and I think we have a few other posts, Your Honor, with them wearing similar type of clothing.
Oh, shit.
Either YSL or related terminology on the clothing.
Yo, it's a fucking record label.
Clothing is that?
On his, I believe, the headpiece as well as the shorts.
All right, can you show me that last portion again?
Yo, do they know at this point this shit is national? Like,
and I started a little.
So, the headpiece and the shorts.
They ain't got no involvement, but they hit them up. Really, on my artist made minimum.
What?
They give me out and built me a business up.
And what does he say?
Built me a business up.
I heard that
She don't
part.
know what
does
the
he
fuck.
say before then?
he's a nobody, Your Honor.
Is this just to show the clothing?
What?
No, the clothing and the pointing of the gun.
And pointing of the gun and saying.
They hit them up. Really, on my artist made minimum.
Your Honor, who
They
the
give
fuck
me
is
out
this
and
nigga?
built me a business up.
I think he's rapping a lyric to a song, but he says he hits them up, and I'll have to go back and look at the portion of the language.
Bro.
Your Honor, procedurally, are you wanting us to argue these one at a time?
I think, yeah, that'll be this set. Not like, well, not necessarily one portion at a time, but like this will be, I'll hear the argument as to this.
You sure? Because I'm about to go in on this Dusty O. How you want this to go?
There's the beginning where they're throwing signs, the end where they're signing off with the language, and then
What language?
Well, the middle, the end of their call, and then the end of his post where he is wearing particular clothing, pointing a gun, and saying,
Lady, they lead babies. I land my plane. They lead babies. What are we doing? Every single one of these co-defendants grew up in areas where lead paint is heavily found in some of these corridors and crevices and rendezvous. Like, what are we doing? These boys got mental problems. Stop playing. Especially the younger ones. I ain't jacking it.
something indiscernible other than that he's going to build a business up, but maybe you can let me know what he's saying. But if what he's saying doesn't matter, then
No, we need some type of learning expert in here.
okay. All right.
I have reason to believe that he's singing a popular
Okay.
line from a song that
All right.
is not involve anyone in this room.
Okay. So is this what's the line of clothing? Is it like a line of clothing you can buy in stores?
Lady, what's the difference?
I don't know if you can buy it in stores. We believe that there's one member of YSL, Miles Farley, who is purportedly a clothing designer. He creates
What the fuck you mean
some of the
purportedly?
clothing.
That is
I don't know if this is that,
That's not his clothing line.
Oh, well. But the clothing says, and I have another picture because I believe this is from all the same line.
Okay, but I mean, if this is something he's wearing and you want it in to show that he's
What?
a gang member.
Because of the clothes?
And the clothing says, and I want to back up, this, we believe this is.
What gang got clothing? Apparel. Nah, we not doing that. Fucking music brands got clothing apparel. Not gangs. Not even Nipsey Hussle Crenshaw shit is considered to be gang apparel. What the fuck? What in the hell? This lady ain't never heard no merch? What the hell? That's one of the most lucrative parts for the artists, being as though they getting milked by their record label. What are we talking about? This lady don't know how lucrative the merch apparel hustle is in Atlanta. She dumb. Goddamn what?
It says slat on the clothing, on the shorts. And I'm looking at another act that we have, Act 143, with him and Christian Eppinger, and Christian Eppinger wearing a jacket similar to the pants and the hat set that he's wearing in this particular video.
And when is this from?
Bro.
This video is around October 10th of 2021. The armed robbery takes place in October of 2021.
The relevance is nuts. This reach is dangerous.
All right, and tell me why y'all are offering this.
Your Honor, so with the first two portions is to show that both Mr. Eppinger.
All right. Italian Rico, John Gotti and them. They bring up as evidence, yeah, all them boys was wearing Robert Cavalli suits. That's a part of the gang. This is absurd. Yeah, you heard me. Yeah, all I'm wearing the Robert Cavalli, so we know anytime we see a picture or one of their guys with the Robert Cavalli, that mean he official. He a made man because he got that Robert Cavalli on. Fuck is we doing? Fuck we doing? Oh, the nigga got the handkerchief on it. Yeah, I mean, he got the white handkerchief with the red stitching. That mean he a part of gang. Look, if you look in the pictures, you'll notice, man, fuck out of here.
And Mr. BB, again, right after the robbery, are in communication with each other, showing their association with YSL by one, using the gang symbols, and two, using terminology.
Oh, yeah. We knew that this biker gang member was actually a threat because we seen him with his leather vest on. Man, that nigga ain't commit no crimes. You seen him with a vest that the team wear, that don't make him a goddamn criminal gang member, bro. Come on, bro. What are we doing with clothes and outfits? Really?
In which members of YSL uses. And then the last portion of the video, which is when he places the gun inside of the video, Your Honor. Again, this is a public posting of Mr. BB.
It's not whether they wore the same clothes, y'all. It's whether they really pressed the crime in the line of the gang in furtherance, bro. Real rap. You could wear the same clothes, all these determining factors. Did they really commit crimes, and can you prove the crimes? All those other elements need to be brought in to just be added to the fact that you can prove the crime. You don't prove the allegiance that's not illegal and then leave it up to the jury to try to believe they committed crimes. That's crazy.
And it shows, again, that members of YSL uses this gun for no reason, comes into this video at the end. There's nothing, I don't know what the purpose of actually flashing a gun is, but to show that he, as a member of YSL, has handguns, uses handguns, especially coming after an armed robbery, which we alleged.
All right, and the armed robbery was what, like October?
Fumble.
October 12th of 2020.
And then when is this video posted?
Fumble.
I just need to pull up the Instagram, Your Honor, of when this exactly video was posted.
Everybody
Can I ask
wear the same
another
clothes.
question while they're looking into that. It's being, and I'm.
So if we go to a family reunion, we all got the same shit on. Purple shirts that say my last name, we the Johnsons and shit, right? We got on black goddamn cargo shorts because that's all the Walmart had. We all got it on. We like 90 deep out this bitch. We whoop somebody ass. We catching a Rico?
I'm sincerely asking. It's being stated that this is a public posting, and I'm wondering if was it a public posting or was this something retrieved off of his cell phone? Because those are two different things.
Hold on, I got another one for you. Oh, softball team. They some firefighters. They off work today. They playing softball Sunday. They like what 12 deep out that bitch. All same jerseys. They start meleeing with the other team. Shit start getting radical because some of these niggas is MMA fighters and shit, right? Is it a Rico? You feel me? Like, yo, he can't, like, what we doing, bro? I mean, they definitely committed a crime. They not denying that. Yeah, they all out there ready to take their ag assaults and, domestic, whatever the hell you want to call it, right? They with it. But it's just a Rico. They work together and it's in furtherance. And it was because they was repping their team and they wasn't with taking no laws. So they say, yo, we ain't no jive turkeys. We ready to whoop these niggas' ass. And that's what happened. You heard? So what we doing? Is we charging with Rico? Or we gonna just put them in the clink real quick because they was a little bit drunk. Some of them smell like beer. You heard?
We got an Instagram return for Mr. BB.
So yes.
So was this on his Instagram page? Was this a story that disappeared after 10 seconds? I'd need a little bit more context about what exactly this video is and where it came from and how it was presented to the public.
It came from his Instagram return. His page, I believe, was a private page. And the Instagram video was of him. It's a Instagram call that he makes with Eppinger, so it has to be public because Eppinger knew to log into the call when that's how he gets onto the call.
Who the hell recorded it?
So is it public between the two of them?
No.
Forgive me, I'm not.
No, I believe it's public to
familiar.
Instagram because
To his private page? Because you said it was a public post on a public page, but then you said it was from his private page.
no, it's his personal page,
Oh,
but
okay.
a public.
You don't mean it's private. You just
no,
mean it was his page.
personal page.
Yeah, you can call niggas through Instagram. I never answer that bitch. I think you the police calling me through that motherfucker. I swear to God, it even ring funny. I'm not answering it. Who the fuck is you? I'm your friend on Instagram, my nigga. If you ain't got my number, man, you fluke. Fuck you doing?
Your
Okay,
Honor,
but it's a public page.
people that are younger than me that are helping me here are telling me that this is not something, like if I wanted to check out what Mr. BB was doing on Instagram.
You cannot see no call that he made on Instagram. So how the hell he get it? Uh-oh.
It's not something that I could find publicly. This was a call.
If you followed it, like if I know
No,
a lot
bitch.
of people have lots and lots and lots of followers, like thousands and millions. Would any follower be able to
No,
see
bitch.
this? I'm just trusting the youth in the room now to.
No, it's like FaceTime. It's like FaceTime. It's a personal call. It was a live stream, it looked like. It looked like it was a live stream, y'all, to be honest. Hold on. But she just mentioned it was a call. Yeah, it looked like a IG live. That's what I thought it was, but she just fucked me up when she said it was a call. Yeah, it looked like an IG live and nobody pulled up, so they ain't had no activity. So that's why Chris got off. He actually said it. Ain't nobody on here. I'm gone. But they just fucked me up because they said call, and you can do that. But who the fuck recorded it? Why was it still live? You understand? So he kept the live stream going after Eppinger hopped off. But he was talking to nobody. but he knew people will be able to see it later. So that's what we just watched.
I can Google it.
What? Good job, though. Good job.
All right, let's assume for now that it's a public page and we can circle back
My
on that.
understanding is once the call, and this is my confusion why I'm asking the state.
No, that wasn't no call.
I'm using call, but
Once
it's not
the-
technically a call. Okay, but once the interaction is done, it is not saved. This is what my understanding is. It's not saved on his page. So I would not be able to say, hey.
Oh,
for
he is
instance,
right, y'all. Previous live streams on IG Live, where the hell they go? He is right. That's the whole point. People screen record them and upload them on YouTube, right? Who recorded it? Which I asked at the beginning, yo, who's recording this? Back in the day, they gave you the option, to play it back. They get saved to your stories? Nah, hell no. Niggas lives be long as a Monjon, and Instagram don't save them. Because I done went through Woody page. That's why so many people be uploading them, y'all. If you pay attention on YouTube, that's why a lot of people got pages where they just upload people IG live streams. Because they know that it ain't going to be up no more. So technically, you got a gem if you catch it live and you screen record it. Because it's going to be gone. I know one thing. They not just stay, like it don't stay on your profile. It ain't just available for people to run it back. You can save them. It asks you if you want to discard or save to page. Oh, okay. So a lot of people must got that turned off. Okay, I get it.
If I said,
Could you watch it while it's going on if it's being posted
Hell
to
yeah.
the page?
You got screen record.
if you were, I think it depends if you were invited.
If you're a follower. I mean,
Yes, so.
whomever.
With Instagram, if they are on a Instagram.
Well, it ain't no question though, Shot. Y'all know what time it is. They was watching these boys heavy as shit by this time. They was already screen recording these boys back in 2015. So for us to think they wasn't watching everybody that came, it's their job, y'all. So regardless, I mean, so what? If the police did screen record it, it ain't surprising. All that shit they was doing in 2015, you understand? They was way past screen recording a goddamn IG Live. They was catching goddamn live pictures, they was, yeah. So that what we doing? What we doing? So what?
Instagram stories oftentimes the other person watching your story could get onto the call if you accept them.
All right. Can they watch it regardless?
Yes. Can they? Who does that?
I don't know. Somebody other than the two people
Yes.
communicating
Yo, how the fuck nobody in there can't explain?
can watch it.
Are you saying can watch it if they're given permission to watch it, or are you saying they can just watch it? Because our
If they're followers or if it's a public post.
Yo, we talking about IG, man. What we doing?
I was friends with this, not even friends. If he has a public page and he's in his Instagram story, he's talking to someone, I can log in and watch it.
And then there's clearly something he does even after the communication is over that he's showing in the post.
Right, and then the other person, Mr. Evinger, can come out of the call and he can continue.
All right. And does it disappear or does it stay up
I
until you
believe
take it down?
disappears. I believe it disappears.
Okay.
That's
so
not no goddamn story. If she keeps saying story,
It's up for 24 hours. And do we know whether this is an Instagram story?
Well, first off, Your Honor, should we be allowing this evidence if the prosecutors or DAs can't even explain? Like, should we? They can't even explain the reference to the foundation of the evidence they presenting. Like, isn't that a problem? I mean, in context, should we present this to the jury if the person presenting it cannot present it properly? I think we got a problem. I ain't even gonna lie. Like this.
Okay. Well, we'll assume for now that it's a public Instagram story that's...
It's not. That ain't no goddamn story. I'm filing for a motion of mistrial.
Up for 24 hours.
And I'll add one other thing, and I can't say this with certainty. On one of these calls, or whatever they're called,
Shot making it
one
worse.
of these interactions between him and Eppinger, it was determined that no one was in the room. So I don't think that there's the room meaning watching. So I don't believe that.
Well, I'm not sure that matters if you're posting it to be consumed publicly if there is somebody watching.
Okay, well, I think you can tell if there's people watching or not, and I think it was this call, but I don't want to swear to it.
All
but I have no evidence that anyone.
Yo, this a room full of lawyers trying to figure out how IG work. This shit crazy. I ain't gonna lie, this shit crazy right now. I ain't gonna lie.
Actually watching, other than him and Eppinger.
So, do you know when the post was made? Have y'all been able?
I misspoke, Your Honor. The posting was 2 days before the so on October 10th is when the posting, according to the Instagram video, was taken.
All right, but close in time.
So it was close. So it was 2 days before showing.
All right,
these two individuals.
Okay, I think that the first two portions are relevant.
What?
And not excludable under 403. The third one, unless you can
What's relevant?
give me a whole lot more to explain why that clothing makes any difference at all. The fact that he's holding a gun when when all he's doing is singing.
That video trash, Your Honor. Throw that shit out. Grab your nuts. Throw that shit out.
You're right. He is representing, we believe, with the clothing
cap
on YSL prior to an armed robbery that he commits with.
Okay. I understand you believe that.
Stop it. Please.
But until you can give me some basis to believe that.
To believe that the clothing is...
That the clothing, yes, it makes any difference whatsoever.
It ain't green or nothing. It's just made by a dude that's alleged to be a YSL member, so that makes him gang. This is nuts, bro. Wow. Our culture is being prosecuted at this point. God damn.
So, Your Honor, with respect to the case law that has come out after Rodriguez and all in the furtherance of a gang, so some of the things that courts have named as evidence of furtherance of it being done in furtherance of the gang is whether or not the person is wearing items of clothing, articles of clothing that have or bear the gang name, if they say the name, if they do things that represent the gang in close proximity to the time of the crime.
I understand that.
And with the fact that he is pointing the gun at the camera and saying whatever he's saying, we draw the analogy that in pointing that gun at the camera, if, as Ms. Hilton is looking, we find sufficient to the court's satisfaction that he is wearing YSL clothing. In the same sense, he's representing YSL as he's pointing that gun at the camera, making the statements, whatever.
First off, that's not YSL clothing. That has no connection to Young Thug. the official brand of Young Thug is Spider. So you lose.
They are singing or otherwise. And in doing so, he is making a public assertion about YSL's willingness to perform violence or to you know.
All right,
use
y'all
it.
get back to me on the clothing.
I'm ready for the
Okay.
clothing. So I'm going to show a portion of the video.
Your Honor, I think I'm probably stating the obvious, but that's not when the armed robbery happened. So
Yeah, it sounds like it was 2 days before.
yeah, so I don't know about what Ms. Love just said. This has nothing to do with showing that the armed robbery was somehow gang related. Even if he's wearing that clothing. But Your Honor, regarding the clothing, again, I agree with Your Honor about the ruling, and we'll look at the clothing, but the gun, I don't like. The thing about clothing is we can get a screenshot and see what someone's wearing. I don't know why we have him rapping and pointing a gun, because that is just
What lots of people unfortunately do these days.
right.
Your Honor?
Yes.
And further, what clothing is this? Because Miss Hilton, first she said she thought it was one clothing, then it might have been somebody else's clothing. So can you please tell us what clothing line is this?
I can't tell you the clothing line. I can just
Get
tell
it
you the
out of
clothing
here.
is flat.
Get it out of here. Get it out of here. Yeah, that's my little girl. Don't say nothing, y'all. That's my girl. Yeah, she a sleeper.
Can't tell if it's a dream or if it's
Get it
real
out of here.
life. Rewind the last days on a still night. He ain't played for a minute, but he's still nice. If the beat got 2 empty verses, then it get killed twice. Backpack rapper with the drugs in it.
And you look at his shorts, and this is at timestamp 3:43. I'm using this timestamp, and then I also now want to show the court Act 143 with someone wearing the same similar clothing, and where it's clearly that it says slats on the clothing, which is terminology used by YSL. So,
Okay, you're showing us where it says this on this clothing.
so on this clothing with the black base, the blue lettering says slats, and then there's also some red items, but we know that the blue lettering says slat. And I know this,
It's
or
blue.
we believe it is this, because just need to pull up.
Do you have him wearing other gang paraphernalia at other times?
That's what I'm
All
pulling up
right,
now.
then that's going to be sufficient.
So at the 143, Your Honor, which is, we believe on September 29th, 2021, so about 2 weeks before the video, Mr. Eppinger, who he's in the video with, is wearing the similar clothing, the slats. He just has the jacket version on.
Okay.
And then BB is wearing the OTS, which says only the slimes. I don't know who created it, but it's slime clothing or slat or YSL affiliated clothing, Your Honor.
Man, them boys look dick dumb.
And who is that? Is that?
So that's the same. So the person in the jumpsuit is Mr. Durante Beebe. This is the person who had the gun in the video. Next to him is Mr. Eppinger, who was the person who joined
Okay,
the
so
video.
you have both of them a couple of weeks before wearing what y'all allege to be gang clothing.
Yes, Your Honor.
All right, that's enough. You can have those two portions that are the
Gang
beginning and the
clothing.
end of his call. And
Gang clothing. Anything that say slime, wow. So you mean to tell me nobody that's not in the gang has worn that sweatsuit? So this apparel is just for gang members. That's what we doing? Oh, no, they losing this. We could go on Instagram and find that apparel's website and take pictures of all the people that are non-slime members and bring in the court as evidence to say, so all of these people YSL too. Everybody that wear the OTS shit is slime. All right.
Not going to do the third portion.
Okay, thank you, Your Honor.
Wow.
Yes.
Everybody that buy the clothing line is a gang member.
I want to, if you rule definitively, I want to just put my objection on the record. These are adequate.
Yup, they just criminalized the clothing brand. That is a lawsuit. That's defamation of branding and character. Straight up, bro. What the hell?
Court statements, Mr. Beebe and Mr. Eppinger are not here. So it cannot be, the way I understand the law, admission by a party opponent because they're not on trial with us.
Right.
And therefore, it has to come under some sort of co-conspirator hearsay exception. And
It said OTS. OTS, only the slime. Regardless, though, this is a brand that's made to save someone from having to be caught up in the poverty that they in, right? This has not got nothing to do with being a gang member. We don't make clothing lines to further our gang. We make clothing lines to make bread to actually get out of poverty. And it's known. A lot of people doing it. They got legal businesses. So trying to say everybody that wears this brand is gang is crazy. And it's so far of a reach is ass backwards.
I don't know how this furthers a conspiracy to say, and I believe these are quotes, what's going on in the first 112 to 115, Your Honor, and then what's up, slat. I don't know how that furthers the conspiracy, so I'm objecting to the verbal. In addition, I asked the court, there are a tremendous amount. There was a contest on the internet who can say slat with a song so many times. I tried to put that in evidence, and Your Honorable Court sustained the state's objection and said, who cares? It's a popular thing that is being said now, and who cares that people are on the internet saying that? The state just said that slat is important because that's what YSL members use. I want to show that everybody uses it. And slat was a popular term before 2012 when this supposed gang formed. You will learn if you let it in.
Did somebody already establish that? I know you established it with regard to like some of those other sayings.
Yes, Mr. Trentavious Stevens stated that when he was younger, it was made popular by a rapper, an artist named Lil Wayne. Okay. So I was stopped from doing it. So I'm objecting. I understand. I'm not trying to belabor this, but I'm objecting to all the verbal statements. And then I just think it's nothing here to me furthers the conspiracy. And that's the only way to do it.
Thank you. All right, so that's that issue. Oops.
The next video.
Yo, is it true that OTS is actually not connected to YSL? They actually literally a group of young dudes? Just like the ones One of One is another branch that's not really connected to YSL. Is this true?
It ends for the purposes of the record in 3396. And I'm going to find the date, Your Honor. This is after the robbery. And we'll play from 10 seconds to 2 minutes and 52 seconds.
Do you know how far after the robbery?
That's the date we're looking up now. Yes, sir. This is on 10/13/2021, so one day after.
One day after. Okay.
You're right. But I was invited. This kind is not invited in our house. My kind. That is a racist statement. I'll have you know, in this age of devices and bigotry, we can't do this to each other. She. Yes, I mean, listen. I got a real life vampire in my house, and he's telling me to calm down. If I had a wife as fine as yours, I'd. Hey, man, what you doing? You can't do this.
Oh, they took Trap Commander Chain. They took Trap Commander Chain, bro.
That's my hand, all right. You got some Overt sprays hanging on both sides of your face. People just on my girl shit. Calm down, okay? That's enough. Oh, I'm sorry. I'm sorry. I didn't mean to. I know I got to bother you a little bit.
That shit don't even look real. Spin that thing around. Let's see them air holes on the back.
All in the club throwing gun signs.
That's my princess, and that's my wife. And I love her. You're not going to destroy my family.
What do you intend to do about Carl Black and install my evil motherfucker? Oh my
Look, bro, this special ed gangster. Lead gangster.
All in the club throwing gun signs.
He just want to be cool.
Got all the fuck going on, man.
What?
Shit, why so?
Look at this, bro. Bro, he don't even got no YSL chain. Yo, he probably lucky he locked up. He probably would have died about that chain,
although
bro.
he's in the bed saying he's in the club throwing gang signs, he threw up the YSL sign in this video. He threw up, we believe to be the little B blood
This is
sign in the video.
embarrassing, y'all.
More importantly, I freeze frame on the chain. This is the chain that was stolen from the victim 2 days prior to, or a day.
So he went and testified? That nigga Trap Commander a bitch if he went to the police and reported it, y'all. I ain't gonna lie. That nigga Trap Commander is a whole turkey grown man. Got that chain took by some young bulls and went and reported it? Hell no. He a whole turkey.
Prior to the this video being posted. He's also wearing, you can see his headpiece or the hat or the
You don't even
mask
know what the hell it's called. Just shut the fuck up.
that he has on his head is also another mask that says "Keep America Slime Again," and then he says "This shit YSL" at the end. So,
Okay.
for those reasons, we believe that is relevant.
Anybody want to argue against that?
Hell yeah, that shit ain't relevant. Trap Commander.
And just like the first one, I'm not conceding that this is
I don't know his real name.
for publication for the public, and I haven't heard how this.
But she said the victim, meaning she done read over the report or something. Like she know his name. So, I mean, I would like to see the overt act. Is that one of the overt acts? I know what he looked like. He in one of the Cleveland Day videos.
State is going to lay that
bald dude
type of evidence before the court. And I don't have that evidence, so I can't tell you that it was for publication. I
So
can't
it's a
tell you
live-
it was private.
Okay, we'll circle back on that.
Okay.
I don't know how the state's going to prove that that is the chain that was stolen from Mr. Smith.
I bet it looks like a pretty distinct.
Everyone that keeps saying OTS stands for outwork the struggle, please stop. The actual clothing that they're wearing says only the slimes on it. So even if that is the name of the brand, right? Please relax. I think you owe me an apology for repeating it. Seriously. Seriously. Nah, Bunchy. Nah, we ain't got to get into that. We ain't got to say all that. That ain't even the gang, Bunch. Nah. But we ain't going to be saying, you feel me? We ain't doing all of that. That's cool for whatever that is. But this clothing that we looking at does say only the slimes on it. You feel me? Like, okay, OTS is a brand. I'm sure OTS is different brands, you know, like for different things. But
chain. Are you going to have
Trap
somebody to identify that as the proceeds of the robbery?
The victim goes by the rap name Trap Commander, and that's what is said on the chain that is stolen. And we intend to call that individual.
Okay.
And then I don't believe that this.
Yeah, we can roll with that though, Carl. That was good info. That is owned by a dude named Cato that doesn't have anything to do with YSL. I like that. But, maybe Holmes just happened to print up some ones that said only the slime. Smart idea. You feel me? Why not?
Depending upon if it's public or not, I don't believe that this furthers a conspiracy, which it has to, the way I understand it, for his verbal statements.
All right. Can you respond to that?
Yes, Your Honor. So, in looking at the Instagram return, we know that this video is from the archived live videos.
Okay.
Instagram does not disclose, at least on our immediate review, whether it's a public page, but we know it's a live video. I imagine he is broadcasting it out to someone because it's a live video. He's not broadcasting it to himself. And so a live video is what we discussed earlier. He gets on Instagram and anyone who is following him can literally open up his icon and see that he's doing a live video.
And if you haven't yet, are you going to present somebody to explain to those of us who are not 20 that all of this is true?
Yes, Your Honor. We will have someone explain Instagram for Instagram. And because he is posting a day after the armed robbery, the boldness of stealing the person's chain and with YSL paraphernalia on and saying YSL. For those reasons, we do believe it's in furtherance of the ultimate YSL enterprise conspiracy.
All right. I'm going to rule that admissible.
I ain't gonna lie, we missed a dude. This dude in the chat named Roy. He got OTS. He with him too. Only the savage. So we need to get his ass too. Somebody get Roy in the chat. Make sure y'all put some cuffs on his ass right now. Get him.
Yes, when I rule it admissible, I have done the 403 analysis and found that it is not excludable under 403. Nothing in there is substantially more prejudicial than probative.
We on everybody's ass. Roy OTS, we on your ass.
It's going to be from 53 seconds to 2 minutes and 50. And for the purposes, we'll identify it as the last four digits, 5860.
This
And
is Instagram.
It's also an Instagram video.
Live feed.
A live feed as well. And this is on October 14th, 2021.
Okay. So 2 days afterwards.
Yes, sir.
Okay.
I mean, that's how they rock it. They just putting anybody in.
52 seconds.
You see OTS, you might as well just go ahead. Hey, sir, come here. You look like a suspect. Track commander that made his IG private.
What? What they do? Well, hold on, line.
Look at these boys.
They locked Slate face up. They did. Damn, why everybody did? They wound up. You Slate face, man. He said, what? He said, so where you at? You still on the way up there? Yeah, we on the way to the room. We on the way to the room right now. Oh. Alright, I'm gonna call you.
Bro.
Yeah, how they motherfuckers playing. Cigarette, yeah. Slap theater, man. Hey, I'm at the studio. You at bullshit? Yeah, I'm gonna lock in right quick. About 4 or 5 hours. You'll be back by the time, young man. Alright. Yeah. Hey, wait. Oh, yeah, slap bit, no rat bit. Oh, kiss. He's about to add me, please. Where you from? Boy, how the... I don't think get out of this shit. His phone.
And we can stop it at 2:47, Your Honor. So a few things that occur in this video is Mr. BB is on his way somewhere, and Mr. Eppinger joins the call again, or joins the video again. You hear him say, as he's holding up the chain that they just stole a day before, says slap business, and then later again they say slap business, no rat business, Your Honor, and believe that testimony will come out during this portion.
So Thug told him to take that phone.
Darius Smith had went to the police, after he had gotten robbed. I believe there is some information that he was being threatened after he went to the police.
Okay.
After he went to the police, Your Honor. Furthermore, also in this video, you see another co-conspirator, Miles Farley. When they pan the camera to the individual who's in the front, he appears to be sleeping. That is another co-conspirator in this case, which is Miles Farley. So for those reasons, and you see them also in this video putting up the YSL sign as well, that for those purposes, this is relevant to show association, to show the furtherance of the enterprise, especially even after the armed robbery.
All right.
Track Commander Bish.
May I, Your Honor?
Yes.
I am going to wage the same objections, that it does not further the hearsay objection to the conspiracy. But if your court is consistent, then what I'd like you to do is please wrestle with the idea that the one before 3396, showing the court said that's a specific pendant, and therefore it's relevant, and the armed robbery occurred the day before. This is the following day, so 2 days after it. This has the same pendant showing, so I would argue that under 403, at some point, it's cumulative. So those are my arguments.
All right. So yes, sir.
Yes, Your Honor. I have a question. As a condition precedent to the admission of this particular piece of evidence, public or private is a condition in terms of the social media, whether or not the platform was public, correct? Is that what I'm understanding? It's a question.
So you said this was another live feed?
Yes, this is also for archive live videos.
So if they are downloading that information or those documents from a live feed, how do they know at the time that it was public? That's what I'm trying to understand. I want to make sure.
And honestly, you may need to have somebody come give a proffer on all of that. I mean, I hear you saying your understanding is that it would only be archived if it was the live feed, and that live feeds stay up for 24 hours. And I think that anybody who wanted to log onto that page could see it, or at least anybody who was a follower could see it.
Definitely anyone who was a follower could see it.
Yo, now she acting like
and I
a
think that's
jerk
the
with you
distinction.
again.
Anyone who's a follower of the person could see it. Whether or not someone who's not a follower could see it would determine whether or not it was a public or private. I don't know if that, to me, that goes to weight, not admissibility of the evidence coming in, whether or not it was a private or public page. But what we know is a live video. Other individuals can see that, whoever may follow him, or if it's a public page, people who don't follow him can see it. But other people besides himself could view the video.
So, I mean, this one it's a communication between and amongst several co-defendants and alleged co-conspirators. Given all that she set forth as the different things that were significant, I don't think it's just cumulative of him himself sitting there with the chain. This is him talking to his
co-defendant, co-conspirator, yes,
of the robbery, and talking about slat business and rat business. So it's not simply cumulative. It adds a whole lot more. And honestly, like, whether this one is public or not, it's them talking in furtherance of the conspiracy. So for this particular one, it wouldn't be significant to.
Hey, research team, send me some info on Trap Commander. Send me the links, ebanfilms at Yahoo. Send me what y'all can find on Trap Commander, y'all.
To the ruling, whether it's public. For that first one, it seemed to be, I mean, for one thing, that she was saying that was one of the reasons why.
Party time.
But, yeah, not really for this one.
And for the court, I'm being told that whenever the court does consider public or private in terms of whether or not it's a condition precedent, that there should be some comments or icons demonstrating how many viewers are present, common.
Okay. So I don't think how many viewers actually see it is significant to the fact that you might be putting it out there to be seen, or you're putting it out there where it could be seen.
And comments and viewers count are key, to determine, or in allowing.
Ag, I don't know his real name.
That's more what it's like.
Yeah.
Would you older people please stop talking about this?
But Your Honor, the reason why Attorney Matthews is bringing up comments and things of that nature is because when it is public, even just public, meaning that your own followers can see it, you would tend to see commentary from even your own followers.
Okay.
So I just don't think that the state has proven that the videos, at least the videos that you're considering, whether it's public or private, even your own followers being able to see it, I just don't think they provided any evidence of that.
All right. Well, I don't think it really matters for this one. So I find this one to be admissible.
Your Honor,
Yes.
before, and this has nothing to do with the court's ruling. I'm not trying to relitigate anything. But while Ms. Hilton was speaking, she mentioned Mr. Darius Smith and their possible threats.
Darius Smith.
Or something of that nature. I don't know
Darius Smith.
of anything that I've been told or provided in discovery that provides any information about that. So to the extent that the state's ever going to want to get into anything like that, I would expect to be given some information.
Some production of something.
Yes.
Are y'all planning to get into that?
I believe it's already, and we'll double check. I believe it's something that's already in discovery, that after this, whether it was his interview, whether it was Mr. Smith's interview, that he talked about receiving threats because he went to the police. And so I'll find specifically.
We'll just make sure that they've got that.
Okay, so there's no video of any threats or anything like that?
No.
Okay.
It's just that he says during the course of his interview with police when he was reporting the crime.
Yes.
Okay. And y'all are familiar with that?
I'd have to check too.
Okay.
I just
That's
didn't
fine.
remember seeing any
Okay.
videos or anything.
Yes.
I know you just said that the last one, which is 5860, has more, so it's not cumulative of the previous one, 3396. But wouldn't 3396 then
Be cumulative.
Yeah, that's what I was arguing earlier, because you said that it's coming in because it's showing the unique trap commander is what I believe it says on the pending. I think it says trap commander.
No, I just thought that when you that comment was when you said, how do we know it's his necklace? I was saying that looks like a pretty unique necklace.
But at some point, is it I know it's short, but isn't it cumulative of the next day?
That is much more to me, him really kind of flaunting the necklace that had just been stolen a day before, flashing money, throwing gang signs, saying, if he said, I heard him say this shit, YSL. I think that is somewhat different than what we see in that 5860 video.
Your Honor, after all of the
videos, okay.
Yes, after all of that, I just wanted to make a general, ask the court's instruction on a general matter about cumulative nature, but I'll let the court go through all of this. I just didn't want to.
Well, what do you want to know?
Generally, what I'm hearing is that whenever a video, a picture of something is shown that's slightly similar in nature to something else, there's been the cumulative of the 403 objection. And the court knows, and everyone does, that there are 65 counts in this indictment and 8 defendants currently on trial. And to the extent that some of the evidence in the court has been essentially ruling along these lines, but I just wanted to say that to the extent that there are efforts by the state to put in multiple showings of a defendant doing, or other defendants or co-conspirators doing things that may appear similar on different times or at different days, this is meant to rebut this continued assertion by counsels for 8 defendants on trial that this is a record label and nothing more. So I just wanted to put out there regarding the cumulative and the 403 objection that we constantly get when there is some similar, and the court's ruled the way I believe that is proper. But I did want to respond to that
your own clothing brand
objection that is constantly being made. Thank you,
Judge.
Your Honor. To me, cumulative.
It's a video of Track Commander on Cleveland Ave. Somebody find it. We already watched it. He bald. He out there in the middle of the parking lot. They point the camera at him, and then he turned. He got the clothes on with like a fanny pack of something.
Isn't whether there's some reason to put it in
Track Commander clothes. I think it's on his shirt.
Do 7 or 8 different pieces of evidence show the same thing? Then after like probably 2 or 3, 4 through 8 become cumulative. So you're not necessarily limited to, I can only show this one way with one piece of evidence, but you don't need to show the same thing 8 different ways.
Well, Your Honor.
Yes.
Ms. Love's argument may remain the same, but it's not 8 defendants, it's 6. It's okay.
You're right.
Right,
I suspect your argument would remain the same.
I found where we were referencing at least some indication that maybe the victim in the armed robbery was being threatened.
Okay.
It's going to be in
correct.
Discovery 7. And within Discovery 7, the last police report, it's the
Cleveland?
first paragraph from May 18, 2022. And then the actual text messages that is referenced in that particular portion of the police report is also found in that same folder, in the digital evidence folder.
Okay.
Brazen acts in Atlanta's Castleberry Hill neighborhood. Police say a group of men kidnapped and shot an Atlanta business owner and well-known rapper at his brewery. Police are now looking for the people responsible. CBS 46's Tori Cooper is joining us live from the Atlanta Brewery on Northside Drive near Mercedes-Benz Stadium. And Tori, police say this is where all of this started.
No, that's not him. Hold on, what's that? No, that's somebody else. That ain't him. That wasn't him. That was a different rapper. That ain't him, is it? Hell no. Nikki, that's not him, is it?
Actually, why do you think it happened? Who is a member of 30?
No, I know what group that rapper from. That was that old group.
It was the part, the flipping the car and laughing part.
No, that was that group.
So when I listen to it, I don't know if I hear flipping the car, but there is some conversation that starts at about 35 seconds into the call, in which, to set the stage, this call is at about 9:45 p.m. on March 16th. And so this is about 9. The house at 2830 Waters Road just got shot up late the night before, earlier in that day. Mm-hmm. And Mr. Garlington is speaking to someone that we believe to be Dewaskin Wright, who is a member of 30 Deep. And when they're on the call, they first talk about different types of weed.
Yeah, I just said that part then.
And after that, Demekion begins to tell Dewaskin about the drive-by shooting. Mm-hmm. And he tells them that 12 had us, they shot up Big Nick's spot, which is the home where they are. And we thought that they were going to come back through, meaning that they thought that the ops were going to come back through, that they sprayed through the house, that they were all in the living room, and they were surprised that no one got hit. And
they had mad straps and ain't bang back.
And Dewaskin asked, well, essentially, why do you think it happened? And Mr. Garlington says one of their little partners just got shot or just got killed in Mechanicsville, which would have happened on March 14th, 2 days prior. Then at some point in time, a little later within that call, Mr. Wright says, do y'all have a drop on them in words? And Demekion responds, I would need to play it again, what exactly his language was after response to that. And that portion is from 0:35 to 1:40, and then from 1:48 to 2:31. There's a small 8 seconds in there that
they talked about
we
this
wouldn't
before.
need to play, but those are the two, we believe, relevant portions. Again, they're talking about the opposition first shooting up the place and then being asked by a 30 Deep member who we allege they have alliances with, YSL.
Alliance?
That some members who were formerly 30 Deep are YSL, and then they still have an alliance with 30 Deep. He then asked, do you have a drop on them? Meaning, are y'all going to retaliate, is what we would think that they say. And those are the portions that we believe are relevant.
Okay.
And those are the only portions of that.
Yeah, the call is only 2 minutes and 30 seconds. So it's really the entirety of the call, except for that 8 seconds that is between 40 and 48. Yes, sir.
Yes.
There's a portion, I believe it's the same call. So I have it as call 513. Mr. Shark gave me that number.
Yeah.
That it says something to the effect, and I was going to object. It says something about McMiller's funeral is going to be private, and his mother doesn't want Thug there or his money. And I don't see how that should come in. That would be a hearsay statement. I don't see how that furthers a conspiracy. If it's not on that call, then I have the wrong number. I have 513.
It's not that call. No. Well, let me make sure.
Well,
Hold on.
I think it is.
No, I'm sorry.
Well, it may not be. I don't know.
So there's remember, there's a page number and a reference number.
Right.
I'm with Mr. Steele. I have 513, and I think we're going by the call reference number.
On the sheet.
So the call reference number for 513 is the call that I'm just speaking of, which is on March 16th.
They came through and they were going to come back.
Yes.
Getting ready to
I
write
have the
them
same
up.
date as well. You're on 5
Okay.
3/16.
What time on March?
So the call
941.
941. But we can listen to the call, but I just listened to it and I don't hear
We're not
anything
going to
about
play it. If it's not an issue, there's nothing to discuss. But if it is an issue, I wanted to raise it.
Okay, because part of it when it was described on this big sheet that y'all shared with everybody was them laughing about the drinks murder.
Right. And I have that happening at 4 minutes and 20 seconds into the call. So, and I'm not saying Ms. Hilton's wrong. Maybe this call isn't that long, but the parts that you wish to play, can we just play it?
Yeah.
Because there's a lot of confusion.
Okay. Because then I guess the part about the drugs comes after all of this.
That's the first thing we talk about.
Okay. All right. Because I definitely wrote down that there was something about y'all said there was a non-hearsay purpose, and you wanted to show something about flipping the car and laughing. But if y'all aren't going to get into that anymore, then that's fine. And I think this one and the one before reference a quay, and understandably there's some concern about confusion. Is it going to be clear? Mm-hmm.
And I'll apologize. I must have listened to 512, which is the 2 minute and 40-second call, because they talk about drugs in that call as well. But it looks like I was supposed to look at the call under
the one at 9:41 p.m.
Yeah. Course indulgence for one moment. Let me just...
No, that's the 502 is also 512, and that's talking about Big Nick's. And that one also says something about not having a drop on people. But we ruled that one, or I ruled that one could come in, but there was a concern about whether we need a 105 with regard to quay or qua, which I'm happy to consider.
On call at lunch, I listened to the 2 minutes and 40-second call, which is the call right above it. If we could have
the one that says 502.
Yes, Your Honor, at 6:49. Okay. If I could have a brief moment, I can listen to the correct call, Your Honor. So that I apologize.
Okay.
Let's talk about the same thing twice.
Only other one we had talked about but not made a decision on was the nested hearsay one. Do we need a quick break? Why don't we all take a quick break?
They hit us with a break. The good thing about it, we were slightly behind, so we don't gotta wait. What y'all think? Well, they just going over evidence, y'all. But it's showing that they had some evidence that they shouldn't have brought in. So I'm glad they is going over it. What y'all think, though? What we got on track, Commander? Yeah, love, definitely. Everybody in there is making moves for their career, y'all. This the time for everybody in there to move up, regardless win, lose, or draw. So everybody in the courtroom that's working, they definitely making out because of exposure. Like even if they lose, they putting up the right effort.
Take way longer than 3 minutes.
Yeah, we
just
need
like
his
to
age,
recap
Agnes.
if we can before Ms. Hilton. Can we recap where we are just for a second?
I would say he in his 40s.
You can help me with that, please, Judge. My notes from our previous sessions said 513 was open, 624 was open, 806 was open. The state today said 1109, and I'm going from the reference numbers.
All right, hang on.
They weren't going to try to get that in. Was there a ruling on 513?
That's what she needed to go back and
Okay.
listen to again. So that's what we're about
36?
to
Damn.
hear from her, whether she's narrowed.
Okay, great.
And then, okay, so read those out to me again.
All right, 513 we're going to deal with right now.
Yep.
624. I had that, my notes reflect that was open
Hey,
as
Bunchy,
well.
you could get the paperwork on that?
Open meaning you hadn't ruled
We
on
have
it.
a, yes, agreed. That's the one that's the nested hearsay, right?
No, the nested hearsay, well,
Oh, okay.
nested hearsay was 2119. That's on the next page.
Okay.
At least that's the one that.
Yeah, you're right.
So I'm trying to
So
figure
what
out.
else? So 513 slash
624.
6, which is also 635. It's very complicated with these
Yes,
two different numbers.
806 and 820.
806. Yeah,
I had.
you're right. I have a note by both of those that said
So there's no-
tomorrow, which we apparently never
Right.
got to that
So
tomorrow.
there's no ruling on those
Correct.
yet.
No
Okay.
ruling yet. And on both of those, if somebody from the state could listen, I think the question for both 6, I don't know which reference number's which, but 624 slash 635
good,
and then
Nikki.
806 slash 820, I think, was who is the other talker? That's what we were waiting to hear back on. But yes, that matches up with what I've got as well, Mr. Harvey. All right, so if you're ready on the 513, 523 one, we can do that one.
So I can answer the 624 and 806.
Okay.
We just know right now that it's a person named Unc, but we don't know who that person is.
Okay. Name, what's the first name?
Unc, like they call him Unc.
Okay, which y'all knew also. And they don't know who that is. And so are y'all asserting that Unc is a co-conspirator, or you have no idea?
No, we're not going to circle. We don't know who.
Okay,
Unc is.
and so then is there some other basis under which you're asserting those two, whatever they are, conversations could come in?
One second, Your Honor.
Okay.
No, 624, 806.
Getting to sorting through the evidence exhibits today.
And also, Judge, while the state is discussing among themselves, I think that's almost as far as we got.
It is. Because we stopped with, I mean, we got much further, but we stopped with the one that is 2119, that is that nested hearsay.
Yes, that's what I mean.
Yeah.
And then there's a page
That's
and
as far as we
there's
got.
a page and a half.
I know.
Okay.
After that.
Yes, that's.
Yeah, no, there are many, many pages after that. 3 pages after that.
Judge, forgive me for missing the portions of the conversation that Mr. Harvey was just having. I was looking with my colleagues at number 624 and 806. Are we correct that those are the two that the court is now inquiring about?
As to, yes.
513 and 513.
No, we're not. We're going to come back to that one.
All right, sorry.
Okay.
Go ahead. Sorry.
So, Your Honor, in advising the person that he calls Unc about the search warrant at Waters Road and Ms. V being on him, one, and I'm not yet through in saying this, but one, the familiarity of the person to whom Mr. Garlington is speaking with Ms. V, and without further explanation as to what Ms. V being on him means, it becomes apparent that this is a person who is aware that at the time Investigator Vivarito is someone who's had Demekion Garlington on his radar. So Demekion Garlington obviously is talking to someone that he trusts. But the 806 call where Demekion Garlington is telling the call Unc that he said on the news they got 2 and 1 outstanding warrant. They just hadn't said my name. He just wanted to make sure he didn't know what was going on. You've made it back, okay. And the person advising him to keep it to your chest, and that Mr. Garlington is advising that person that he's trying to make as much as he can now. These words all lead us to conclude that this person, though we don't know his identity, he is a person on whom Demekion Garlington is relying, who he is getting support and advice from as it relates specifically to the conspiracy, arguably in telling Mr. Garlington to keep these matters to his chest. This person that he's talking to knows all about Waters Road, knows what it's there for, knows that likely knows about what was being kept at Waters Road, given that he's not asking, wait, what do you mean? What about Waters Road? Who is Ms. V? So this could be, though we don't know, and we're not trying to assert that this is some person we know is, YSL. This seems like, reads like, he listens like an unindicted co-conspirator, someone that he is relying on and trusting for information and guidance as it relates to his actions in this conspiracy. Those type of actions fall under what courts have deemed statements in furtherance of the conspiracy may consist of. Because of that, because of the type of information he's sharing and the feedback he's getting and the role that this person seems to serve in Mr. Garlington's life, these 2 statements, we'd argue, would fall up under the co-conspirator statement exception.
All right.
Does anybody need to hear them again?
I don't know. It seems to me that if we don't know who this person is, I don't know. My understanding of the case law, and I don't have the, but I'm certain of it being the law. And I can get a case. Is the statement itself cannot establish the conspiracy and the prerequisites of 801 D2E. So without knowing who the people involved in the conversation are, and just going by the conversation itself, I don't know if that ever. Well, I do know that that could never satisfy the requirements of 801 D2E under our Supreme Court precedent and state in case law in Georgia as well.
What do you say to that?
I do not agree with that assessment at all. In 502, this is an 11th Circuit case, but United States versus Miles 290 F3D1341 is from 2002. The courts have said in its admissibility evaluation, the court may consider the statement itself as well as extrinsic evidence to qualify. The statement need not be necessary. This is not what Mr. Sharp was putting forth, but it's, I think, helpful.
It's exactly what I just said.
The statement need not be necessary to the conspiracy, but needs only to somehow further the interests of the conspiracy, Your Honor. And personal knowledge of the subject matter on the part of the declarant isn't required, but it talks about the statements of unindicted co-conspirators. Specifically, Your Honor, I think
all right, we know statements of unindicted co-conspirators can come in if they otherwise qualify. What Mr. Shard is saying is conspiracy and it being in furtherance can't be established by this statement alone. Is that what you're saying?
Correct, Your Honor.
I haven't seen
it. It can't bootstrap itself, and I'll get you the case.
So, Your Honor,
he'll get us a case.
So,
and then we'll take it up.
I'm reading from
it's not in the statute.
Yes, it is. The statement must be considered, but does not by itself establish the declarant's authority.
Your Honor,
under the existence or scope of the relationship or the existence of the conspiracy or participation in it.
Your Honor, I'm reading from United States versus Rivera, R-I-V-E-R-A.
Okay, and I'm reading from the statute.
Hang on, don't talk at the same time. Let me pull up the statute. That would certainly be the easiest place to go to if it answers the question.
And I have cases, Your Honor, as well.
Right. Give me a second. The contents of the statement shall not alone be sufficient to establish the existence of the conspiracy and the participation therein of the declarant and the party against whom the statement is offered.
And so, Your Honor, the state is not tendering the statement. We in no way suggest that the content of this statement alone establishes a conspiracy. The conspiracy, we'd argue, has been shown by evidence that we've already presented at trial and more evidence that we will be presenting later on. What the content of the statement does show is that the unknown party to whom Mr. Garlington is speaking about about things that the conspiracy inherently kind of involves, i.e. Waters Road, Miss V looking for him, the outstanding. When he does that, he is receiving, he's giving the statements and he is receiving assurance, and the statements made between the two are serving to maintain trust and cohesiveness among them, or inform of the current status of the conspiracy, which furthers the ends of the conspiracy, so long as the other requirements of 801D2E are met. And that's coming from a First Circuit 2012 case, United States versus Rivera, RIVERA-DONATE at 682 F3rd 120. Especially when you hear, given everything Mr. Garlington is saying, I mean, he's literally just telling the guy, like, you know, Miss B is on me, blah, 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 blah. And of course, the court and anyone can listen to it. But he just wanted to make sure, you know, he didn't know what's going on. You made it back okay. The man is saying, keep it to your keep it close to your chest. And Demikian is then saying, I'm trying to make as much as I can now. This particular case that I'm about to point out is a Third Circuit Court of Appeals case. So it's not anything that the court has to follow. It's just sort of instructive, but it does speak to the United States versus Lignelli, Lignelli. And the site is 660 Fed APPX 118. It's a 2016 case. There, the court found that a statement made by an unknown speaker could qualify for the co-conspirator exception if the government establishes that the speaker was likely a member of the conspiracy alleged. And in United States versus Helmel, which is an 8th Circuit 1985 case, and Helmel is spelled HELMEL, and that site is 769 F2D 1306 at 1313. What Lignelli says or cites Helmel for is the parenthetical. What is essential is that the government showed that the unknown declarant was more likely than not a co-conspirator. And I believe that the prescriptions that were described earlier regarding the statute alone, the statement alone being used to establish a conspiracy is not one applicable here.
Okay. All right. Can I hear the statement again? It's been a while since I've heard it. Yeah.
And Judge, just so that the court is aware, since we are researching in real time, there's a notice at the front of Lignelli that says not presidential opinion under Third Circuit Internal Operating Procedure Rule 5.7. Such opinions are not regarded as precedents which bind the court. I want to make the court aware of that notice.
Just a second. Okay. This gave me that local storage caches thing.
What? What's going on? Where you at? In the apartment. You got your family? Hell nah. Oh, nah, I got my shit. Just got now. What's in? So no folk got now. Where you at? I finna pull up. The meat on White out there. Yeah. Nah, everybody out here though. I ain't got no fire. I been got the chilling until these folks home. You say you trying to do what? I said I just been chilling trying to see what these folks on before I get another fire. What? Yeah, man, fuck you. Nah, cause them folks they got man. That shit, them folks they hit the spot the day one and then I was still just like what? Boy, Miss V, boy. I know they hit that bitch. Yeah, but now I just feel like Miss V on a nigga, boy. So I'm really trying to move cautious. Well, definitely. You know that wrong. Yeah. And she saying y'all see nothing. Well, you know she y'all. Who all you say out there? Big regular, big, zoo them. Big out there? Yeah. Alright, here I come. Alright. Yeah.
Your Honor, I'd also point out a thing I left out. The person to whom he's speaking is also advising Mr. Garlington, giving him more information about the circumstances out there that Mr. Garlington was describing at Waters Road, where he's talking about who all else is still out there. So that adds to our argument as well.
All right. Let me hear the next one, if you don't mind. Yes.
Gotta love it. Hey guys. Do you like violence? Do you want to see me? Yeah, buddy. She's a smoker. She's a smoker.
Hello?
Tell him stop playing with me.
What's up?
Hey, what's up with you? What happened?
What is that? My bad. Oh, no, look. I just seen the news. I seen the news. They said the two they got, and they said the one they got on, outstanding one. They ain't say my name.
Oh, okay.
Yeah, well, I just feel.
Well,
I said I just want to make sure I don't know what's going on.
yeah, you know I'm back though. I just really let you know 2 hours back.
Yeah, you don't made it back?
Yeah.
Okay.
Well, shit. You just keep that shit on to your chin, really, and hold on to that paper.
Yeah, that's what I'm doing. I'm just trying to make as much as I can,
Yeah. Exactly. Goddamn, I'm here though. I'm gonna let you pull up on me. Just goddamn answer the phone.
All right.
And if the court notices, I think Mr. Garlington does not even start giving details until he's reassured that it's Unc, who of course then tells them, you just keep that close to your chest, and so forth. So I think that both of these calls make it apparent that this person is giving information
that serves to reinforce the underlying purposes of the conspiracy itself. They're providing reassurance. They're informing of what's going on, that is putting members of YSL in peril. Ms. V out there looking for Mr. Garlington. He knows who she is. So we believe that these all form to tell the court these are statements of co-conspirators that should be admitted. And yes.
I'll hear any defense argument. And Mr. Shard, I think with regard to, and Mr. Harvey, the issue of the statement alone can't establish the participation of the declarant. I think with regard to Garlington, there's certainly more. And are y'all offering like both sides of the conversation?
In order that they understand what's going on, yes, both sides are being offered of the conversation. The most important part, we feel, is what Mr. Garlington is saying. His words are more pertinent because they're reflecting a knowledge of something that just took place. Is very important and close in time to acts that are alleged via overt acts or counts on this indictment. So Mr. Garlington's words are the most important ones, but the other ones are needed for context.
Can I just respond very briefly to this? It's still just the statement itself. And every court, the United States Supreme Court and our Supreme Court, have specifically said in determining the existence of the admissibility of a co-conspirator statement, the trial court may consider both the co-conspirator statements and independent external evidence, although the co-conspirator statement alone does not suffice. That's specific language from Dublin versus the state at 302 Georgia 60, pinpoint site 63. But that's the rule, and that's the intent of the rule in the code. I have heard nothing but argument about the statement itself, but no external evidence other than the statement itself. And that is simply not enough with an unidentified party.
Right.
Period.
Yeah. So I think with regard to whomever Unc is, that it does sound like all you're relying on to establish that Unc is a co-conspirator, and therefore the jury can consider what Unc is saying is what he's saying and what he seems to know that's based in the statement itself. So I think that if this comes in, if these two come in, there needs to be an instruction that, you know, it's only Garlington's statements that you can consider.
In his, hang on, I'm sorry. In as much as Unc's is providing context to what Garlington's statements are, one moment, Your Honor, I'm reading a statute. If the court would indulge me, I apologize.
All right. Can you wait just a second? Because I think Ms. Love's trying to absorb the statute right now.
Tap the like button. Salute to everybody in here. Smoke some. It's 420. We live.
Almost, Judge. I apologize.
Well, hurry up. We ain't got all day. Salute to everybody in here. I appreciate you being here. Yeah, don't worry about her, yo. She'll heal up soon. Before the trial up, she'll probably hit. But, you know, I don't know who did that to her. I think she probably fell down the steps. You know how it be when you live in the outskirts. You be working them truck stops. You got you a old man, and he don't treat you right. Y'all got habits, and y'all spend a lot of time in seedy motels. You might wind up like this, but you don't really want to report it to the police. It could get worse. You feel me? And really, you might want to blame it on the habits that you chose. The meth.
Make sure that I'm
Your best friend being
the
meth.
right area.
My bad.
It's the portion of the statute that says the contents of the statement shall be considered, but not alone, sufficient to establish a declarant's authority under paragraph C, which is not applicable here because we're not talking about that.
It's not applicable, and then
or the existence of the conspiracy and the participation therein of the declarant and the party against whom the statement is offered under subparagraph E.
Right.
So if I'm reading this last portion that Mr. Harvey references, we're not trying to establish both
the existence of the conspiracy, right? That part's not the issue.
And the participation therein against the declarant.
That declarant being
She was playing basketball.
The Garlington statements are one thing. I mean, y'all have other evidence that Garlington is a member of this conspiracy, but you don't appear to have others for Unc.
So it's not, and I hesitate to say it, but it's not so much Unc's statements that are important. Unc's statements are the ones that give context to Garlington's statements. And so to the extent that you need to hear what Unc is saying so that you know what Garlington is responding to, that part is important. So to the extent that I guess an instruction that Unc's statements, you can consider them for context for Garlington's statement. I mean, I'd have to work through that, but my reading of it is that the declarant of concern is Garlington, and we're not really that concerned about Unc.
Well, you might not be that concerned
I know that.
about Unc,
I know that.
but if the jury's going to hear it all, then why don't you look at both of those portions again and see if there's some way, if it's Garlington's that you need to have just Garlington statements come in, and if not, what limiting instruction would be appropriate.
I appreciate that opportunity. We will. Thank you.
All right.
And Your Honor, I was never able to verbalize, maybe for the record, maybe to persuade the court, about why I didn't believe that Garlington's statements were admissible under 801 D2E.
Okay.
And my argument, I think the fact that we don't know who Unc is important, because certainly knowing who the receiver is, knowing who Garlington is speaking to, would better educate us as far as whether his statements are in fact in furtherance of a conspiracy or not. And at least the second call, he seems to be calling Unc and just saying, "Hey, I heard I have a warrant. You know, what should I do?" And Unc seems to say, you know, just stay safe and get money ready for a lawyer. But it seems that Garlington is concerned about his own legal troubles or the possibility of being charged. I don't really find that as furthering any conspiracy. That seems to be concerns about himself and his legal future and his and concerns about being incarcerated. But I don't view that in any way, shape, or form as furthering any conspiracy. And especially since we don't even know who Unk is, but me calling, if I was involved in a conspiracy, and me calling my literal uncle, who I reach out to for advice, and him saying, "Hey Max, if you think there's a warrant, start getting your money ready for a lawyer and stay in the house."
Yeah, man.
I don't know how me asking my uncle for advice would be furthering any conspiracy. So I don't believe that Garlington's statements, at least with that second call, meet the requirements of 801D2E.
Your Honor, I think that Mr. Sharp's analysis leaves out, if I'm mistaken, forgive me, and he can correct me. I think it leaves out Unk telling him what's going on at Waters Road, like who else is still out there in that second call. So he's informing him of circumstances that still exist that put members of YSL who incidentally were hiding in and then ran from and apparently took contraband from. And this is our assertion that we believe the evidence will show. So I'm not trying to put something in front of the court that, is just my word is bond. But Unk is advising Garlington about circumstances that continue to place YSL members in peril. And Unk obviously has knowledge of what this conspiracy is. He's not asking any kind of questions.
Mm-hmm.
And
then Garlington's responding, he's wanting to make sure what's going on and is told to keep it to your chest. And frankly, he doesn't need to be talking to a co-conspirator.
I agree.
Okay.
I agree, but I still think knowledge of who he's speaking to
would certainly,
and
further elucidate things for us, but it's not necessary for the admissibility of this statement. This, I think, would come in under, I can't remember the name of the case right now, but the case that's, I think the state cited where, somebody's getting support from their girlfriend or something about, how to handle the fact that somebody might be on to them. And it's not exactly the same, but it does sound like, frankly, it sounds like this is somebody who knows a whole lot about what's going on at Waters Road, and they're sharing information in order to stay hidden. I don't think.
Respectfully, so this is the day after the Waters Road shooting. So this is not while Waters Road is in practice. And he says, "I'm pulling up." And I think a very common sense reading of what was said there is he's pulling up to where Unk is and wants to know who's at Unk's house. The state keeps saying, alerting about who's at Waters Road. That's not the way I hear that call at all.
Your Honor, the court should also be aware that this is the day that police go to search Waters Road. And
found nothing.
I think in another call that the court heard on
and they found nothing.
Previous hearing, they find that the sticks were removed, like they took guns and stuff out of the Waters Road.
No, they said they put him in the attic, didn't they? And them police, and they gave Holmes his gun back because it was legal. But nobody fired back at some dudes who were shooting at the house, though. So how tough is they?
The night that they were there initially just to check on the occupants, and nobody was willing to come to the door, but they found everybody hiding in cubby holes and stuff.
Because they showed up afterwards.
And so in subsequent calls, I think the court heard last time that they didn't get the sticks that were in the attic or wherever it was. And
because they wanted them boys to still have the guns, y'all. How they searched the house but not the attic? When y'all know about some police that know y'all got guns or drugs and they don't hit the attic. That's like not hitting the basement, right? Really? We missed the attic. They just mysteriously put them in the trapdoor attic of the house. Attics ain't no secret spot. Fuck out of here.
Now Unk is talking about.
They let them boys have them guns. They wanted them boys because them boys was already ratting. The fuck? They was lining them boys up. They wanted them to retaliate so they could get more evidence. They ain't want no guns out that house. That's why they pulled up so fast after they got shot at.
My reading or listening to it, Unc is talking about who's still around, and Mr. Garlington is talking about Miss Fee.
I think whether he's saying who's still at Waters Road or who's at wherever he's about to pull up to.
I just want to make it clear for the record. This is not the day, to my understanding, that Waters Road was searched. Okay, and the state, I would love to hear their evidence. Whoever Unc is, that he was at Waters Road on that day, because it doesn't exist. He's talking about where Unc is, and I'm pulling up to you, and who's over at the house, which is not furthering any conspiracy. But I understand the court's ruling, and I just want to state that for the record.
All right, thank you,
Your Honor.
Yes,
I did just want to bring attention to one case. This, I don't know, perhaps frames it in a bit of a different way. Statements are admissible when the state establishes a basic case.
Stretch your neck a little bit.
Independent of the co-conspirator statement. I think looking at this, if we look directly
Reach your neck out.
Standard, let's take out what the statement is.
Mm-hmm.
What evidence is there to make a prima facie case? Nothing. And the case I'm relying on for that is Williams versus State, 293 Georgia, 750 from 2013.
Thug admiring her lawyership, y'all. Look, Thug peeping her like she all right.
Mm-hmm.
There's another case which quotes the same language. It's Newer Franklin versus State, 298 Georgia, 636, 2016. And in both of those, they go on to discuss some of the other independent, separate, apart from the statement evidence, which did justify using that co-conspirator exception. But here, where we have no information about Unc except his name is Unc, I don't think the state can make that prima facie showing.
I don't either. I mean, I think that with regard to Unc, there's not enough. So that's why I've directed Ms. Love to figure out whether she can either get in the Garlington statements without Unc's statements, or if not, come up with some appropriate limiting instruction.
We can do that, Your Honor. And just as a matter of the prima facie showing of the conspiracy itself.
Yeah, no,
we're not dealing with that.
I get that. And there's enough to show that Garlington is a co-conspirator and that there's a conspiracy. This
Thank
is
you,
just
Judge.
with regard to Unc, as far as I'm concerned. So let me write myself a note. And then we'll circle back to the 513, 523 one.
Thank you, Judge. And this case that Ms. Abbasi just cited, does the court mind providing that cite one more time?
Franklin or Williams, or both?
Both, please, if the court doesn't mind.
Franklin versus State. Franklin versus State, 298 Georgia, 636 from 2016. And Williams, 293 Georgia, 750 from 2013.
Thank you. And I think that the court already has Kemp.
I do. Thank you. All right, let's go back to the 513, 523 or whatever it was, one. So the narrowed version, that's what you were going to do, was figure out.
So it appears the narrow version is going to be from roughly 34 seconds Yeah, there's about 3 sections, Your Honor, so I'll play. The first will be from 34 to 354.
I don't need to hear the drug part again. We already rolled on that.
I believe we're past the drug part.
What's back?
Nick, fucking free.
Last night?
Last night, boy. You know, I wasn't even gonna come out. Man, it was like, goddamn, pull up. We were finna be on one. Goddamn.
But y'all was in there?
In there, boy, about 6, 7 deep. Tunk just had them pulled out, boy.
Damn, that's a fool. I thought they already went over there and shot one other
They
side.
did, but still, man, I'm on some everyday shit.
They double back.
Oh, you talking about it?
Oh, yes.
Right?
Yeah.
Oh, ain't nobody went next, right?
Oh, no, I heard it a couple days or something. They said they went over there.
Oh,
that one ain't
yeah,
no.
No.
You said they Jen went over there last night.
Yeah, well, we there, man. I'm like, yeah, man, boy, I wasn't even finna come over here, man.
Yeah, you talking about? Yeah, I ain't even know nothing about this.
Yeah, look, we like to hear. We think we like, all right, they gonna come back through. Man, we think they gonna come back through so we can hit that motherfucker up, man. 12 pull up, man. Hey, what?
It how?
Yeah, I'm like, the hell. We hit them folk like, cause we got our lights out. Them folk like, we gonna have to come in. We gonna have to come in, cause goddamn, make sure ain't nobody dead, man. I hit the back door like, yeah, boy, I'm on parole, man. Man, all this shit in here, man.
Hey, you talking about, hey. Y'all have to come in.
Yeah, no, we just heard them talk to the other officer, like, yeah, we can go in, make sure ain't nobody. Man, it be them up under the house. Goddamn, man, but 4 of us in the house, they keep saying, man, they don't go out. I'm like, man, I got me fucked up, man.
you took out right?
No, I hit the back door. Them folks it was on both sides. And I was just like, I seen them on one side, cause I was just gonna sit in the car, in the yard.
Yeah.
I seen them looking at the cars over there, go through the other way. They know they was over there. I felt like, hey, come here. I'm like, hey, man, I just heard some gunshot. Yeah, I'm like, hey, I just heard a gunshot, man.
Okay.
Yeah, that's like, where you coming from? Like the wood, I'm dry here. It pouring down rain. No folks like, man, you ain't wet at all, man. I'm like, man, I'm telling, man. I was in the woods. I don't know how I ain't wet. I was in the woods. But I ain't no savage. Man, y'all check that house, found them guns. I went in there, boy.
Yeah, man, I ain't got nothing to do with
They
that.
still went in there, though. They checked that. That was good, boy. And be safe.
Oh, they ain't certain. They just
make sure.
They just looked around.
Make sure nobody dead.
Yeah, so when nobody know when they went in?
Yeah. They found now. Goddamn, look Quay and other name.
Okay.
Yeah. I'm like, hell.
What they at the house?
Yeah. From the pop out for Colt on her. Colt, so they got a little video shoot.
And we'll stop it here. We'll fast forward to the next relevant portion. And we'll say, Your Honor, Little Quay is not either Mr. Nichols or Mr. Huey. That is Quatez Arnold, who was at the house during the shooting.
Are y'all going to stop and tell the jury that?
That will come out through Investigator Viverito, who was all in the house prior to this call coming in, because Investigator Viverito will testify as to who was there when it occurred. But we've always established, even when we did the motions hearing, who was at the home, and it was never Mr. Huey or Mr. Arnold. And so that will come out.
Well, couldn't you just stop it 3 seconds before that Little Quay part gets said?
Right, and we can either remove it, or we can do a stipulation so that it can be, so the jury can hear it in real time, so that the jury doesn't develop.
Okay.
Yeah. Because, I mean, Viverito may not be coming till sometime later.
Well, this call is coming in through Viverito. Okay. So none of this.
Regardless, I think it's stipulation.
Yeah.
This is not either of these people that are on trial would.
We'll cover that.
Safer than if you can either do that or you can take that part out.
Yes, we can do the stipulation and ask her. And I mean, we all agree that it's not either of these individuals.
I have a solution.
Don't play it.
Don't play it at all.
Yes,
But
because
it's important, little quick.
It's two parties giggling and laughing about what happened at a prior event. There's no informing anyone for any purposes of further any conspiracy. It's just spilling the beans.
Your Honor,
and giggling.
I would
Thank you,
say,
Ag.
though, that Quatez Arnold is important because that individual is in a previous video that we have with Quamavius Nichols that's already in evidence with Quamavius Nichols.
But just because something's important, just because something
as to who all was at that house, right? Right? Hello?
I'm sorry. I apologize.
You are going to have the detective testify to that person being at the house anyway?
Yes.
I mean, I didn't hear anything in this portion of the conversation that does sound like anything other than, man, can you believe what happened? So this portion is out. Yes.
So it'll be out, Judge.
I know. I hadn't listened to that other portion yet.
No, I mean, she was on the cusp of addressing Mr. Sharp's concerns and was wanting to make sure the court knew who was in the house, but she had another argument she wanted to make.
That explains.
Thank you, Your Honor. Yes, Your Honor. So when you hear this portion of the call, Your Honor, they are boasting and bragging about what happened in that home, the fact that they were hiding from the police, or he was hiding from the police with the other members in the house. We believe that was stated to obtain confidence between co-conspirators. We do believe that this person is the Waskin Wright, who I mentioned earlier.
Right, well, nonetheless, it's out. Let me listen to the next part.
The next portion starts at 4:18, Your Honor. I'll start a little bit earlier.
Too much going on, oh yeah, nigga got to see what's going. They flipped nigga get up on the bridge in the Ville.
Yeah, I heard. Yeah, I heard. Where the hell you at?
I'm right here.
So, Your Honor, that's when they say they flipped under the bridge under burden. We believe that they are referencing and laughing about Shamel Drinks because he just got killed under the bridge, which would be the I-20 bridge in Mechanicsville 2 days before this phone call.
Okay, and you had said before that you had some non-hearsay purpose for that wasn't even hearsay that you had. I mean, I don't know what it was, but you said that there was some non-hearsay purpose to introduce that so that it didn't need to come in under an exception.
Sure.
I don't know. I wrote it down. I don't know what it was.
I got it. You're right. I believe that the fact that they are speaking in code and laughing about this particular murder when they say, I heard someone flip the car in Mechanicsville, and then there's like a pause, and then they both laugh. Given that this is again 2 days after the murder of Mr. Drinks, and we believe that Mr. Garlington was a part of that homicide, the fact that they are laughing about that particular instance at that time is a non-hearsay purpose of why this portion of the call will come in.
I'm going to exclude that. So that drug part that we talked about before is the only part of this conversation that is going to come in.
And there's one more portion, Your Honor. I believe this is the portion that Mr. Steele referenced earlier today.
Oh yeah, they were like, they said his mama like, well, she only wanted to come.
Yeah, they said she don't even want to come.
Yeah, I already told them for but folks family gonna be talking crazy anyway. Like they gonna be like, we don't want no money, nothing. Like they gonna be tripping.
Yeah, you know how.
That's just how this shit be, yeah.
Yeah. I'm like, damn.
That's why I know he just
Yo, this not even fluent language.
like, man, he just respect it. He just know how this shit is.
Yeah.
Yeah. I never seen what the hell you had going on. Just chilling.
I'm pull up on you like tonight or tomorrow or something.
And Your Honor, that portion is Mr. Wright and Mr. Garlington speaking of the murder or the funeral of Christian McMiller, and it's Christian McMiller's funeral.
Street
and
trade stopped talking on the phone.
McMiller's mother did not want
They ain't gonna say
Mr.
nothing.
Williams to
Why?
be present.
They ready to tighten up about that.
At the funeral, we do think that that is relevant, given that we believe that Mr. McMiller, Mr. Ford's murder was a direct result of Mr. Bennett being stabbed in the jail. And we do believe that the evidence, we believe, will show that the stabbing at the jail was done at the permission of Mr. Williams. So it was a trickle down effect. So we believe that Mr. Jaden Myrick, who actually stabbed Mr. Bennett, asked for permission through Demekion Garlington to Mr. Williams to get permission to do that stabbing. That stabbing occurred once that stabbing occurred at the jail.
Thug even had to look over.
Released to the public.
Thug even had to look over like, come on, lady. You lying. She keeps saying him, bro. Look at Curry.
On early in March, on March 2nd or March 3rd, only about 7 days later was Mr. Ford and Mr. McMiller murdered by YF and Associates. And then the other murder happens when Mr. Drinks after that, Your Honor. And so the fact that Mr. McMiller's mother does not want Mr. Williams at the funeral, I believe, is relevant to show that there is a belief that he is the cause of the murder of Mr. McMiller and Mr. Ford.
And Your Honor, in addition to that, I see the question. You say I'll be quick, but Judge, the fact that he is bragging about what we believe to be the murder, and that he is informing the person that he is talking to that they were going to come back and they were getting ready to light them up, we believe falls under
that in that clip.
So
It was-
about
that
the
part is
funeral is
the
definitely
funeral is
out. If there's some other part where somebody.
That's the first part, Your Honor, I think is coming in, that you allowed to. My understanding is everything from the drugs to everything before Little Quay can come in when we talk about what it.
No.
Or,
No, nothing from this call is coming
That
in.
part is the only part that can.
but Your Honor,
Yes.
but there's portions of that first part where they discussed that they were going to get ready to shoot back at them, shoot back at the opposition when they were going to come through. And so earlier in the call,
When they're talking about shooting up Big Nick's, is that this part?
right? So before,
And being surprised nobody got hit?
right? But Demekion says we were getting ready to shoot back at them, but we thought it ended up being the police and not the opposition coming. And so I think that that's important, that they were willing to shoot back at them if they came
Oh
back
my
through
God, they was capping.
And to augment that, Your Honor, just to add a little to what Ms. Hilton just said, them boasting and bragging to one another, we would argue our statements used to obtain confidence between co-conspirators, and it is serving to up and maintain trust and cohesiveness among them, and to inform them of the current status of the conspiracy, and in doing so furthers the ends of the conspiracy. As Ms. Hilton.
Thank you. I
Thank you.
understand the argument. I appreciate y'all perfecting your arguments. For the record, my ruling stands. So the drug part can come in, and that's the only part from that wiretap. Now, I have a note that the one above that, 502 or 512, there's a reference to a quay in that one also. And there was a question whether there needed to be a 105 instruction, or there could be a stipulation that as to who that was about, if y'all know it wasn't, you know.
In Your Honor, I'll just add to that. My notes indicate that the reference to Quay is that he's locked up in that call. Okay. So that made it especially concerning.
Do y'all know who was being referenced there? Probably.
If they're talking about Quay or March 16th, they're always talking about Quattrez Marks. That is who was at 2380 Waters Road. There were, outside of Mr. Garlington, Mr. Stillwell, and Mr. Farley, was Quattrez Arnold, a young man named Jeffery K that's escaping me right now, and one other individual. So every time at Waters Road on March 16th, there's only talking about Quattrez Arnold.
All right, and so y'all are going to enter a stipulation that says it's not either of these defendants?
We can't.
Okay. I mean, if it's a stipulate, would you rather it be that?
Well, I'd rather that it not.
I can't hear you.
I'd rather that it not come in, because it's an assumption, Your Honor, that they're saying we think that it's Martinez Arnold.
No, it's going to be a stipulation that it's not either of these defendants.
And again, Your Honor, we intend to introduce testimony through Investigator Viverito, who was at the house when she arrived, along with the responding officers.
Okay.
We'll talk about who was detained on that day.
So is it going to be a stipulation that it is whomever Arnold, the Quay referenced in here?
Yes, that is Quattrez Arnold. Yes, okay. We will stipulate that the Quattrez Arnold, that there's the Quay that they're talking about is Quattrez Arnold.
Okay. So that's another Quay that's being referenced. Fair enough. Thank you.
Okay. So that takes care of that as well. Make sure y'all get that stipulation together before that gets played. All right. Let's get this nested hearsay issue taken care of before we break for the day.
How inclined the court will be to entertain a request to do the nested hearsay, not today, but on another day.
Why?
Because I want to make certain that we have our most cogent, succinct, and clear argument for the court, because we're going to get one go at it, and I want to make sure that we do it properly.
Well, hadn't y'all already briefed it?
Judge, we have briefed something similar. That's what we were looking for earlier. But I don't want to read a brief to the court. I just like to give about 4 lines to the court if I can, if the court would indulge us and allow us to just argue it on a different day. That particular one, because it has layers, and I want to make certain that we say it clearly and quickly.
I couldn't hear. Are we just saying, hey, I need more time because I haven't briefed it yet?
No, Judge, I'll be clear, and I'll say it loudly enough for everyone. We are asking to be allowed to make this argument on a day different than today. That is it. Please.
And
thank you.
the reason is?
And the reason is we would like the opportunity to make certain that our argument is as concise as possible. We don't want to be trying to read a brief and distill information. We have briefed a similar subject. We would like to respond more clearly than we believe at this point we would end up doing today.
Well, the state has already sent what they thought was the issue to the court, which was 2 pages from a brief that was filed when in November of 2023, maybe? No, 2022. And that was in response to Mr. Copeland's statement. So the state has had plenty of time to come up with this. And you know something? We've been asking since December of 2022 for the unindicted co-conspirators. They were supposed to have been given to us well over a year ago. And now we get in here and unidentified people are being identified now as unindicted co-conspirators. And no, I object to any additional time because we got some unknown person referenced in this phone call. And I don't want to hear anything about, oh, well, now we know who the hell this guy is. Now we know who we're referring to. And now we know that this dude is an unindicted co-conspirator as well. And I don't even know whether it's a dude. So let me undo that reference.
And I apologize.
And the unindicted, the whomever it is that's unknown that you're referencing is Rel?
Yes.
Or what
yes.
sounds like Rel?
Yes.
So, Judge, I'm sorry. We got the 9:30 p.m. Monday 9/9 supplemental brief by Mr. Harvey, and we want to just address everything and be concise. That's all.
Okay. And you know, y'all have had this for a couple of years now, and you indicted it. And you've had this wiretap.
All right. You don't need to be talking to her. So, I mean, I think your biggest sticking point is probably the fact that some of this is only coming through Rel, and we're probably going to have the same issue we just had with UNC, which is unless you're going to be able to tell us more, it's only this statement that is going to be able to establish anything about, and obviously Rel is very knowledgeable about what's going on, or they wouldn't be talking to Rel about this kind of thing, but that's only the statement that establishes that.
So if we could be allowed at the same time that we address, that we provide the court the additional information the court said it'll allow us to do on that one, the call, or if we have to do it before, I'm just asking for an additional time to address the last call, just this last one.
Okay, so I haven't given you any additional time at this point to do anything about the UNC call, right? That's out.
No, it was out. I thought that the court had said something about redacting, and if there...
Right. Yeah, yes, figure out a way to, yes. Okay, I'm sorry, I misunderstood you. I mean, honestly, I'd like for us to do, what do you want, to just skip over it and move to another one?
Yes, if we can, and then come back.
Well, we certainly have 3 more pages to get through. Have y'all looked to see whether you really want, or you really feel like all of what's in this is necessary to establish different issues? I'm sorry, yeah, it is 3 pages. Have y'all done that yet?
Could the court repeat the last part?
Yes. So we still have 3 more sheets worth of this printout that you gave us, which is probably 10 calls or so a sheet. So maybe 30 more pieces of a call. Have y'all taken a careful look at that to see whether you really need all of this to establish the issues in the indictment? Because, I mean, this is going to take a long, long time to get through.
And so obviously, Your Honor, we are trying as the court, as we go on, to pare down where we can, as much as we can, but at the same time, keep defense apprised of things that we may use so that there's no argument that we didn't. But we can look at it some more.
I'd like for y'all to start making some decisions about, oh, we're not going to use this. So have you done that evaluation yet?
We on a lot of others, these are the ones we said we wanted to use. So yes, we can do that more. And as it relates to these that the court has in front of it, Your Honor, we'll give it another pass.
Okay.
We'll give it another pass.
Appreciate that.
Tap the like button. Salute to everybody in here, man. I'm here.
Does the court have another day because that we can just, or do you
Have
just want us
another
to send the
non-jury
one
day?
to us?
Oh.
Yes.
Nah.
I mean, can y'all get that done by Monday too? Or no?
My team is saying we're gonna.
I mean, I'm asking.
If we could have a couple more days, but if we have to, we will.
I mean, get it. We're not going to be able to discuss it next week anyway. So
And then next.
get it done
So
by the 20th.
Thank you.
So we're not arguing today?
Thank you.
I don't know if we're going to. I don't know.
20th.
We're not
Yeah.
going to do the other ones, but
So we ain't
there's
arguing
other
today.
stuff we can do.
No, I meant the call 2119.
We're not going to play 2119 prior to the 20th, so we appreciate that.
So, Mr. Harvey, I guess that your brief that you filed is so impressive and intimidating that they want some time to be able to respond to it.
Just agree to it because it's right.
What? Look at that.
So, have y'all gotten together yet on, Mr. Steele made us all a nice chart of where he thinks the evidence, the status of the various exhibits is. Have y'all been able to look at it and see where there is any kind of discrepancy in what y'all believe?
We have been looking at that. We've not done that joint effort, but we've been comparing Mr. Steele's chart with what our chart and what Ms. Weaver's is.
And where are y'all on that?
We're checking with our team member that's in the office now.
Okay, because had I walked in here at 9, dealt with the 2 Rule 22s, and then said, let's hit the exhibits, which I told y'all by email several days ago is what I wanted to do today, would y'all have been ready?
Bro, check how white boy staring love down, though. Check this out, y'all. Watch white boy.
Look at it and see where there is any kind of discrepancy in what y'all believe.
We have been looking at that. We've not done that joint effort, but we've been comparing Mr. Steele's chart with what our chart and what Ms. Weaver's is.
And where are y'all on that?
We're checking with our team member that's in the office now.
Okay, because had I walked in here at 9, dealt with the 2 Rule 22s, and then said, let's hit the exhibits, which I told y'all by email several days.
Yo, something wrong with Holmes, cuz. Yo, he like a foot and a half away from her face, bro. He is on her ass. He knows she's lying. I know, Tanya. I know. That's the same thing I was thinking when I was peeping it. I said, yo, on her ass. He trying to pay attention to her so he could keep up with the lie. You know, when your man with you, if you telling the truth, I don't gotta watch you while you telling, whoever we with, right? But I'm on your team, so I don't gotta look at you. You telling the truth. When you start lying, I kind of gotta look over and pay attention to the story myself. You feel me? I gotta start paying attention to you myself. You might say some crazy shit. I need to pay attention. Hold on, let me see.
Days ago is what I wanted to do today. Would y'all have been ready?
At that person over here to be arguing that.
Okay, so that answer sounds like
Master exhibit list, Your Honor,
Okay.
and then we can forward that we believe is up to date, and we can take some time over the next couple of days to go over that with any designated person from the defense, but we can forward the master exhibit list that we have that we believe is
y'all exchange that and copy Ms. Persfield as well, and then y'all get together to narrow down where there might be disagreement on the exhibit list. Yeah, because it's going to be a bear, and we can't just put it off until the end. We need to be doing this a few times as we go along.
I don't know why you called him Sling Blade, but I like it.
So,
call home Sling Blade.
y'all, Mr. Ryan's crowd is going to get together on whatever else that evidence might be and where there might be disagreement.
State's going to get us a list by Sunday, narrow down, we'll have conversations based on that.
Okay. All right. And y'all are both going to get me briefs by Monday, I think is what I said, on the what was it? What did I tell y'all to brief me on?
It's been an all-out cap fest.
Anybody know?
I believe we were supposed to. Yes. Over it, whether or not
It was
over
something
acts.
else. Yeah.
Was someone in jail that it ends the conspiracy with that one?
Well, somebody wanted to do that a long time ago and never did.
The other one was whether or not an overt act not listening indictment could solely be the basis of a conviction on count one.
Okay.
But you abandoned.
No.
You think that something not charged? Is that what we're going to reason?
Yes, that's what
An
was one.
overt act is
Not
not
sure.
listed, not a count charge, but an overt act not listed.
Did you provide any law?
No, they haven't yet. That's what I would like for them to do.
Okay, that was the Monday one.
That was one.
Okay.
Judge, with respect to that, would we be able to wait for the state's brief and then respond in kind if they're able to find that? Versus us just
Lil Rod look guilty as a motherfucker over there.
says to begin with?
Sure, you can wait on that.
Thank you.
And then, okay, I guess if a prior conviction, which Mr. Ryan's murder conviction is alleged to be an overt act, were y'all going to brief me on whether and how and if that needed to have any kind of a limiting
I think that
instruction?
That would be a smart thing to
Or was I just writing that down on my own as an issue?
No, I don't. I think that we had earlier
Okay.
today we had said that his conviction, that there should be a limiting instruction as to his conviction. We had not fleshed it out or anything,
Okay.
but I think it does bear some addressing.
I think so too.
Brian, put the dressing on.
Do whatever if you want to brief, but I can't imagine a limiting instruction to cure. I'm on trial with Mr. Ryan, and to have this jury be told that another jury in Fulton County found Mr. Ryan guilty of murder, and that his overt act, because you're dancing, the court's going to tell the jury to do this dance because, okay, don't use the prior conviction against Mr. Williams or anyone else of the jury because it's hearsay.
Damn.
But you can use it against Mr. Ryan somehow. But then it's an overt act against Mr. Ryan. And if Mr. Williams and Mr. Ryan are in a conspiracy, even though Mr. Williams is not part of that overt act, you can use that evidence against Mr. Ryan to find the overt act, and therefore Mr. Williams gets convicted on that piece of evidence. I don't mentally understand how you're going to cure that.
The determination is going to be made separately as to each defendant.
All right. This is similar to my argument. Remember, I kept asking, I don't think Raj stuff should be brought in on the strength of it's caught up in limbo right now. Now, Brian's still arguing the same point, but he actually attacked it with legalese. He picked the argument. Mine was more vague. Mine was more like, hold on. I was more looking for the way to get it bunked out. But I knew like something ain't right with that being hard stamped as a fact in this RICO trial right now with it being in limbo. Like, it's just like weird. Like, I knew we needed something. It needed to be addressed.
Whether they participated in those.
And Your Honor, I think that the conviction itself, the issue of the conviction, not the act of the murder, not the evidence or proof of him having convicted the murder, just like we've had to present evidence of other overt acts that were external to the conviction itself.
And you're presenting that evidence anyway, that he committed that murder.
Right. Yes, Your Honor. And so the conviction itself, and by conviction, I mean the certified isn't the overt act. It's the actual murder that we are putting up evidence of that we...
Right, but you're also wanting to put in the certified copy of the conviction of Mr. Ryan for that overt act, right?
Right, and that's what we were discussing with the limiting instruction.
Right, and so there is a danger, or it gets complicated about how to tell the jury
you can't
what they can do with that evidence.
You can't without damaging the goddamn other
and I haven't looked at the two cases that you cited yet, the 14 F 3rd 881 and the Choco 200 F 3rd 1.
The mere mention of a murder,
that was you, right?
In context, the mere mention in the murder of a murder in the RICO trial will easily be perceived as you're blaming this current gang for the murder, regardless of what you say. So, I mean, wouldn't that be damaging to the other co-defendants regardless? I believe so.
Yes, Your Honor. That was the state's cases.
So maybe those will elucidate it somewhat. I don't know.
Anyway, I just want to follow the court and aid the court if we can. So whatever I need to do to write, but I think that would be very prejudicial.
I believe so
and that's
too.
The danger is it going to be, is there a way to correctly limit it?
No, you can't bring it in.
So I think
I need some
more. We
something on that would be nice as well.
Yes, Your Honor.
All right.
And Your Honor, I think we asked for just some additional case law, not in brief form, possibly about a prosecutorial meeting.
Okay.
Those were minor additional information.
Yeah, I mean, if you wanted to provide that.
And
And then you'll get me the hard copy of the in-camera material by Monday also.
my
Right,
first
right,
thing
the
I meant.
printouts, right. And when we're discussing the prosecutorial need for the intrinsic acts, we're looking at it through the lens of.
I mean, I don't need further evidence on that.
Oh.
I mean, not evidence, further case law on prosecutorial need. If y'all want to come up with some, great. But yes, that is exactly what I did want further evidence on, was could y'all find something that more factually aligns with your situation? And obviously that one, y'all were going to file at the same time because you can find case law that factually aligns and says, no, it's out. And just to flesh that out some more, and it being either admissible or inadmissible, because it either does or doesn't complete the story of the crime of the gangs or the crime of the RICO violations, or, you know, be the same kind of series of events as that. Because those are the only two that it might come in under.
Right, it has to, right.
Okay.
So just.
That's them with the audio,
making
man. I
sure
don't know
that
what
the
that is.
case
That's
that
feedback.
we-
Somebody got a
cases
phone
that
in the
we bring
mic.
to the court's attention addresses that.
If, yes, ideally, that would be wonderful. All right. Anything else we can do in the next 15 to 30 minutes?
Can I just get, I ask every day, want to know what files to bring
So,
tomorrow.
in terms of witnesses?
Yeah, if it didn't change, that's fine, but I know that
So,
the state said.
I think y'all said Pitts, Latner, Turner, Bell, Hill, Jinks, and Thorpe. I may have that one wrong. Jinks. Was it Jinks or Jenkins? Jenkins. Is that still the plan?
Yes, for the upcoming 2 days.
Couple of days. Yeah. Okay. And then we'll talk again on Friday about what'll come up next week.
Thank you, Your Honor.
All right. Anything else?
Your Honor, if it matters to you, other people spoke with the sheriff, and you're going to.
Okay. Yeah, I didn't know where exactly y'all were going, but somewhere that gives y'all a little bit more room considering the number of people involved. Oh, right. I'm sorry, I don't mean to just point at you. Miss Borden. Yeah, coming up to the podium.
Yo.
I want to say thank you, Your Honor, for allowing me to come back up again.
Sure.
And I'll be real brief. I just want to share something to
Bro.
you and also on the record.
Okay.
I appreciate being granted the access to the camera pool, and I just want to respectfully express my concerns that that solution does not fully align with the principles of transparency and equal access. The decision to limit the media coverage to a single camera controlled by a pool, which restricts the diversity of perspectives and it raises concerns about control, suppressing, and also withholding crucial details that can be caught by several angles. And I know earlier, I think I might have shared, I am a civil rights leader. I'm also a noted and awarded community advocate for the state of Georgia since 2009. The Rule 22 provision was designed to ensure that the public and media has open access courtroom proceedings.
Mm-hmm.
And
where you been, though? Where you been this whole time? And why the fuck you got a blazer on with them goddamn, what is them, cross-colored shorts? God damn it.
It is not to be limited to a singular source because that risks tampering with the spirit of that rule. By only allowing one feed, it is inherently biased. It ends up being biased with that coverage.
Are you reading from a case or are you just reading?
No, I just take some notes. I didn't want to spend extra time and I'm almost
okay.
done.
I mean, so this is just your position. It's not case law, is it?
I do have some case law. I got two of them.
All right, let me hear that case law.
So it assumes that one viewpoint is sufficient for capturing the full scope of the trial. It's essential that different media outlets are allowed their own access so the public can be provided with a fair and transparent view of all proceedings. So I am asking the court to reconsider this limitation and the transparency of the Rule 22. So when it comes to, for example, O.J. Simpson trial, also I was a part of Derek Chauvin trial. We were permitted live streaming to ensure full and unbiased representation of the proceedings. If you look up Press-Enterprise COV Superior Court, 1986, also Richmond.
I don't know how to look that up.
Oh, I'm sorry.
You just said.
What?
Okay.
Do you have a site to a reporter, like a case reporter?
What?
Well,
it's usually like numbers and then a book and then some numbers again.
I didn't. So basically, I pulled it. If you was to type in Press-Enterprise COV Superior Court 1986.
Yo.
COB?
I'm sorry.
I got Enterprise. C
is in Charlie, O is in Oscar, V is in Victor.
V.
Hey, yo, can you imagine me debating about Rule 22? Come on, lady. You felonious with your argument.
Yes, V is in Victor, Superior Court, 1986.
Man,
and I have another
on
one.
this argument, and I ain't even mad about it. But what this light, we arguing about whether a man.
What state?
This.
Look, this how she came. Man, I could go off the top of the head better than this. I could have rocked that. Could have made the judge without case law. I swear I could make this argument right here without case law. Real rap. Raw. And I ain't even talking about for myself. I see what ground she trying to make right here. I see what she trying to do. But like, come on, shorty, if you really meant that, you'll be able to rock. Especially coming from a civil rights base. Straight up, bro. Like, come on, lady. You got gas. You got the race card you using right now. Yo, she using the race card, cuz. Man, come on, cuz.
Try that, but I don't think that's going to bring anything up for me. But anyway, what's the next site?
Okay, the next one is Richmond Newspaper, INC versus Virginia Supreme Court. And I also want to share that the restriction of the live streaming serves a compelling enough interest to warrant limited media access to a single perspective. Again, when it comes to civil rights leaders, right now I don't see any other civil rights leaders here. Also, when it comes to community advocacy.
All right, well, Mr.
I apologize,
feels
Mr. Bryan.
himself to be a civil rights leader.
So,
Yeah.
I do want to go on the record so I have just as much vested interest as the defense team.
Cat. What? That was insulting.
And I did
Brian Steele, you should laugh again at that.
look at the media room. What is required, I do not have. So therefore, I would ask the courts if I can bring a computer into the courtroom. I don't have to have my phone.
What?
But just a computer to do it physically in here. And
To do what?
I'm sorry,
physically
to be able to do my notes, also to do live commentary from my computer.
What? With no audio visual.
And I'm also asking the court to uphold the First Amendment protection of public access.
All right, there is full public access. Anybody who wants to can watch this trial. It is being live streamed with a pooled media of at least 6 different news organizations. It is also being live streamed by an individual who is pooling with another individual whom you are welcome to pool with. And so you can do that as.
So is everybody welcome to pool from this pool? Can you just make that available to everybody to stop this from happening, Your Honor? Just post the link on Fulton County website or something so we could just all get this pool link and we could just solve this at once. Like for real.
As well. Okay. So then are you saying at this point you just want your computer in here so you can do live commentary, but you're okay with not filming it because you don't have the capacity to do it from the media room?
Yes, Your Honor.
Okay.
And also, I would like to, I know I brought it up earlier, I still would like to submit to the courts. Maui Davis, Davis Bozeman Law Firm did a letter. Also, Channel 11, I work closely.
Oh, yeah. I mean, and I said before, I'm happy to, and I
would like
know
to
Mr.
submit.
Davis and happy to, but again, I don't not believe that you are a civil rights leader or that you would be able to add something to what's already in the news. And you,
What is a civil rights leader? Nah, that don't give you no respect. Where was you at when these boys was getting railroaded before? Do you even know anything about this case? You just want to pop up and take notes all of a sudden when it looked like these boys could beat it. But where was y'all at the beginning when they looked guilty? Now it's close to politic time. Y'all want to pop up and show face. Man,
certainly welcome to report on, everything about this trial.
So in there also is a letter from DeKalb, Mr. Robert. He was the DA, DeKalb County.
Yeah, I know him as well.
Also, Channel 11, I work closely with their investigative team. They also did me a reference letter as well.
Okay.
You work with Channel 11, who talk down on the black people of Atlanta on a normal basis. How you work with Channel 11 and you civil rights? And part of the problem in Atlanta is the news stations that perpetuate the black people in a bad light and don't help them. They don't help them poor people. They ain't help them with no jobs. Won't they run articles about how the statistics of job opportunity is lackluster in these urban environments? What are you doing, lady? Stop playing with me. Stop playing with me.
Yes.
I just wanted to, this young lady referenced Richmond newspaper v. Virginia, and I believe the site is 448 U.S. 555.
I thought that was a pretty big case.
So much.
I was familiar with that.
Impressive.
Shark, don't help her.
464 U.S. 501.
Ooh.
Okay, thanks. So, those numbers and then letters and numbers, that's how we lawyers look up cases.
She don't even know nothing about case law.
Nice, but it's the numbers that we actually need. So, okay. And what would you need to do it from back in the media room? Is this
just be able to plug up my computer and that's it?
Oh, so you're not worried anymore about being able to film?
No, I could make everything work from my computer.
Okay. All right. Well, I just gave somebody else the ability to do that. So I will revise your Rule 22. I don't know I think it might have already been emailed to you, but
Yes,
we'll withdraw that one and do another one.
And just to make sure I'll be able to come into the
y'all
court.
are going to have to fit in the media rows that are available here in court. So it might get pretty, I mean, sometimes there are only a few people here. Sometimes there seem to be a lot of people here.
Yo, just know this.
And, okay.
Thank you, Your Honor.
Thank you.
These people is not prepared. Yo, who want this work? I swear to God, bro. If somebody is in Atlanta and want to get this money with this, what these people trying to do, they bluffing. Seriously. If you want this money, holla at me, because these people bluffing, y'all. They bluffing. They popping up late. They cheeks. I don't like it because you had that blazer with them stripes. Straight up. What that was that zebra gum. Zebra stripes gum. That's what she had on, a zebra stripes. She like a zebra stripes, like the lady out the commercial for the zebra stripes gum. Stop playing. Could you eat the wrapper or something? That was the gum niggas was eating the wrapper, I think.
Well, tomorrow is your next court date. Is that what you meant? Or no, the jury's coming back tomorrow. Did you mean another, when are we going to have our next non-jury date? I don't really know.
Oh, I'm tripping. I could have swore that's how that shit looked.
Oh, no. I'm thinking we could.
I swear I think niggas was eating the wrapper, bro. I think niggas try to convince me, yo, you supposed to eat the wrapper. I'm like, hell no, cap. Niggas was smashing the wrapper. I think so, bro. I might
don't
be
know.
wrong.
Possibly sometime the week of the 7th, later in the week. But if we need one before then, or if we need one or two before then we'll have to fit those in. I mean, I'm planning for us to have 2 full trial weeks for the, next 2 weeks of September, but do y'all think we're going to need some 1 or 2 non-jury days?
No. No, I was the little kid that denied it. Don't eat that, bro.
Okay. All right.
I did
so
eat
then
some paste before.
We'll plan to do full weeks for the next 2 weeks. And then maybe sometime the week of the 7th.
That pace was all right.
We might have a non-jury day or 2. And if not, I mean, certainly
that Alma?
Sometime close thereafter. Okay.
Not glue, paste.
Judge, one last thing
out the tub.
Matter that the court brought to our attention.
They knew that shit had an edible flavor. They knew that.
From the sound of things regarding the request that we dealt with at the bench, no further.
I don't know what you. No, I don't know. I don't know what you mean. I'm sorry, my memory just may not be as good as yours. I'm not quite sure what you're referencing.
May I approach with just
Blue? They
further
knew what we
defense
was
so
doing.
that I can
yes,
deal with it appropriately.
Yo, the Almas, it had like a blue-white glow to it, cuz. I took a couple dabs. I ain't even gonna lie. Now I knew the kids that was off was eating it, right? But one of them convinced me. I don't know how it went down, but I remember, I got put on. I knew they was off though, y'all. So I made a choice. It wasn't a mistake.
Anything else?
I chose to eat it, y'all.
Before we break for the day. Nope. Okay. Nobody else. All right. All right. Let's see. We have the jury back at 9. Considering that we've been together all day today, hopefully we won't have anything unexpected in the morning. Do you think we could just plan to convene at like 5 till 9? Okay, let's do that. See y'all tomorrow.
You're right. All right, y'all. They had a real dry and felonious day in court. Hopefully tomorrow we get some action, right? I ain't mad at them. I mean, I guess they needed it. 5 a.m. till 9. What? What happened? Yeah, today was kind of stiff, but it's cool. I mean, at least they got it out the way. If anybody, if y'all find anything about the trap commander, let me know about that. Yeah, I gotta go back and I want to look into why I just want to see what type of guy they dealing with, because he in the one video, so I got a gist of Holmes, bald head Holmes. Had his shirt tucked in, I believe. 5 to 9. What's 5 to 9? Hold on, what y'all heard 5 to 9, y'all? A big civil rights attorney. Nah, you need to use non-civil rights people. 8:55, what y'all talking about? That's what time they said they starting? The judge just said something about 5 to 9. Five minutes till 9, y'all. All right, I get it now. Y'all just threw me off. I get it now. 8:55, 5 minutes till 9, y'all. Golly, y'all was right. That was killing me just now. I didn't know what was going on in the chat. That was like a puzzle. That was a puzzle just now. Like what? I had to put 2 and 2 together, literally. I ain't seen it, you feel me? I ain't gonna lie, it caught me off guard a little bit. What? 8:55. 5 till 9. I'm like, whoa. 5 a.m. That's impossible. And 9, they leaving at 9 a.m. Damn. Like, you feel me? Like, what type? Oh, who said that? That's why I'm like, oh. Cat. Cat. The judge was sleeping yesterday? I ain't catch it. $5 a.m. to 9 p.m. I mean, you would think the way they behind, they would be doing some. I mean, we could do night court. You ain't saying nothing to rock this bitch out. We take a little break in between and come back. Get this thing shaking. I mean, we getting paid overtime. Yeah, but hopefully tomorrow we get some action, y'all. The witnesses be back, the jury. We should get they said a police. Whoever Pitts is, that's a police, right? None of these police should take long, though. It's only a couple police that's like, experts or main witnesses, I don't think. None of these police that's coming should take long. Oh, looking for Unc? Who, y'all trying to figure out who Unc is? I really didn't even try to consider it. They ain't looking for his ass. I wasn't even really trying to figure him out. Y'all, who y'all think it is? He ain't sound like one of the characters we already know about, is it? Pitts is for the autopsy photos. I think Pitts APD. They might work, they very well could be, who knows what they do. Was he really somebody's uncle, though? The way he was talking was kind of like he really somebody's uncle. Did he ask about Big? Or that was the two young dudes talking when they asked about Big? That was the two young boys when he was talking about Big, didn't he? He said Big down there. Salute to you, Dynasty. Salute to everybody in the chat, too. We had a nice stream today. I appreciate y'all pulling up. Tap the like button on the way out if you didn't tap it. Shut up. Probably just an old head. I mean, I'm going to leave it like that because I ain't trying to incriminate no guys that ain't get caught up for real. Because if he made it out with just being, called Unc, then you feel me? That's smooth. Only reason I kind of, went and figured out who other people was because of the way they got mentioned. I'm going to keep it real. The way Holmes just got mentioned, they really reaching by even including yo, to be honest. That's from her falling off the podium. Hell yeah. Yeah, we got a lot of Unc going on too. Yeah, where I'm at, like you are Unc long as if you 5 years older than us, you Unc essentially. It's a respect, it's different ways you could use Unc. So you got a disrespectful who Unc? Yo, a flunky. When it's more in a upbeat manner, it's nah. We rock with Unc. So it's like, yo, you got Unc you can send to the store, or you got Unc we getting work from. Nah, hey yo, I was gonna call Unc. Hell yeah, hell yeah, call Unc. You feel me? That's a good Unc. That's a good Unc right there. Yeah, nah, yeah. Now, that Unc can be replaced with Big Homie, but guys don't really be on that old Big Homie. You feel me? It sounds a little bit weird. So it's just, Unc easier. Yo, call Unc for me. All right, bet, say less. But you come in the house like this, yo, what the fuck Unc at, yo? I think that nigga stole like 3 dimes of Ready from me last night, bro. Hell yeah, I left his shit on the table. Unc ass be stealing. Where he at? Where's funky feet ass at? I'ma fuck Unc up. That's a bad Unc, you heard? Straight up. Now, I done been around both. Yeah, man, I can take you to both. I got a good Unc I can put you with. Yeah, man, he good peoples, bro. That's, yeah, man. Unc, shit. Then I got Unc, he get high. Now, if you got some stones for sale or you want to chill around and see if he can make some plays, you might want to play with him. Don't put nothing in his possession. Just stick around and chill with Unc. And he gets to some action because he a smoker, so he be out in the mix too. Don't trust him around shit, though. For real, bro. Yeah. He'll spin you. He'll do good for about, 3 hours, maybe a whole 24 hours. He doing right. Then all of a sudden, you know what I mean? You like, Unc, shit, here, you might as well just take these 10 pills, Unc, and go ahead and bang that off. He like, all right, bet you ain't gonna see his ass for 3 days. That's the bad Unc, y'all. This shit real, y'all. Straight up. Salute to everybody here that the like button. For real, y'all. See, I really was around, y'all. See, y'all think I be playing, y'all. I really was in these trenches. I ain't necessarily, I mean, it was needed. You feel me? Yeah, he was gone. He ain't even far, though. He ain't far. We could track him down. It ain't worth it. He didn't wait. The shit gone as soon as you notice he missing. Stone's gone. I mean, what you was gonna recover it? Nah, them bitches was gone before you even noticed he was gone. Yeah. See, you thought he been doing right. So you ain't even noticed that he was gone. So by the time you like, yo, damn, where Unc? Ain't nobody saying Unc. Niggas like, nah, what happened? Like, nah, I gave him some art. Niggas like, damn. Why you give him something? Nah, what you mean, bro? He had made like $700 for me in like a couple hours for real, bro. What the fuck? Told him hold something, I was gonna be back. Niggas like, nah, bro, I ain't seen his ass. You know what happened. He smoked that. Everybody know. That's gone. You might as well just get ready to dust him or just chalk it up. What you gonna do? What you gonna do, man? You gonna dust him again? We done dusted him a million times, bro. He know. He gonna eat the squabble. He knew the squabble was coming. It was worth 10 stones to him. That's what I had to figure out one day. Like, damn, yo knew he was going to get dusted. But Joe really ran off and smoked the 10 stones, knowing. So I had to weigh out how long would it have took him to earn 10 stones versus stealing 10 stones and just taking the motherfucking ass whooping. Yo, this is the type of shit I used to be trying to scientifically figure out, y'all. I'm putting math equations together like that, y'all. Fuck wrong with you. You think I wasn't in the trap learning? Shit. Figuring out, yo, what's the probability that this nigga could have probably earned the 10 dimes instead of stealing them? Yo, I seen my man father, straight up, used to smoke stones out of nowhere, y'all, like just out the blue. They done gave the nigga something, right? He basically had the access to the shit. I don't even know why every once in a blue moon, Holmes would just go radical and just do some old nut shit. You feel me? Smoke a 8-ball. You feel me? Like, yo, what happened? Niggas like, yo, my father stole a 8-ball. What the fuck, bro? The nigga be having this. He know I get to the money. What the fuck made him just crash out and go on a weird-ass crack binge out the blue? The nigga could smoke all day by just walking to the store and shit, bro. What happened? Like, I see the nigga, yo, all scruffed up. I'm like, yo, what the fuck? He looking at me all guilty like a dog that shitted on the living room floor. I'm telling you, y'all, I used to be in some weird-ass spots, bro. Real rap. Y'all think it's a game. To the people that was in these same type of spots, y'all know I ain't lying. You can't make this shit up. Whole time, we up there waiting for sales to come and playing GTA and shit, you heard? Straight like that. Some of y'all was doing the same shit. For real. I know I just brought back memories. Y'all like, what? Hell yeah. We was in the bitch playing the GTA. Whole time, the whole spot. Crazy, though. The nigga, yo, this nigga, my man father, too, I'm talking about, that nigga probably might have sold $1 million worth of drugs. Straight up. That nigga might have sold $1 million worth of drugs, bro. Nigga was had it like a motherfucker out there. He had a drop. I ain't even gonna tell y'all the secret. Yo was white. My man was mixed and his father was white. So we was in an area where it was mixed. So yo had to drop. Yo could blend in with looking like a fiend. It's weird, y'all. It's crazy, y'all. If y'all see this shit, I swear to God, this shit was crazy. But yeah, salute to y'all, man. It's time for me to get the fuck up out of here. I appreciate y'all being here. You know what time. We be back early in the morning, man. 8 a.m. Tap the like button on your way out, man. If you're new, subscribe to the channel. I'll be back. Holla. I appreciate y'all. If you're a new member, you already know. If you hit the Cash App, you already know.